Good morning, everyone. Ooh, I got an echo. Hang on. All right. Can you hear me okay? Hey, Louise. Hey, Kimmy. Hey, Casey. I'm glad I didn't come on any earlier than 9 this morning because they've done nothing but discuss whether or not they're going to allow some of these conversations with Crumbley and their attorneys while they were, air quotes, on the lam into court. I don't know. It's weird. I'm trying to figure out exactly what they're talking about, and I haven't figured it out yet. And it has to do with attorney-client privilege. So, can you hear me okay? Just let me know. Give me a thumbs up in the chat or something, guys. I've got 2 chats going at the same time, or 2. You can't hear me. Thank you, Casey. I've got 2 computers hooked up to this stream right now as a backup. Let's see. Hey, Bama, good morning. So I'm confused about, I guess there's attorney-client privilege in there that makes what some of this being brought in makes it against attorney. I can't even say this. Oh, I'm still on my first cup of coffee. Information in attorney-client privilege is involved in what the prosecution wants to bring in. And so they've been chatting this morning about whether or not they're crossing the line by doing that with attorney-client privilege. But in the meantime, I wanted to show you guys something. So we'll leave that up, but I wanted to. Okay, let's do this video right here. I thought this was a really interesting little news clip. But then this was back in December. I was trying to find stuff from back in December.
Prosecutors say early on they raised concern that trying James and Jennifer Crumbley together would pose a conflict, and we now know at least some of that has to do with 2 people in Florida where the couple once lived.
I think they're both just as culpable. They both played their roles in different ways.
Many parents of Oxford High School students believe Jennifer and James Crumbley share in the blame of their son's massacre, and now the husband and wife want separate trials, 2 years after the couple and their attorneys declared that they wanted to share counsel.
At this time, there is not a conflict. We have addressed if a potential conflict, how that could arise. We don't anticipate that's going to happen.
Ms. Crumbley, and knowing all that, do you still want to proceed today with these attorneys?
Yes, Your Honor.
Mr. Crumbley, do you want to still proceed today with these attorneys?
Yes, Your Honor.
Okay.
It was predictable. It was so predictable that one of the defendants was going to throw the other under the bus, or there would be testimony that would only apply to one of the defendants.
In James Crumbley's motion for a separate trial, his attorney says they just realized there's a conflict of interest based on information recently provided by the prosecution. We get more details in the motion Jennifer Crumbley's attorney filed, in which they state that 2 weeks ago, law enforcement interviewed 2 people in Florida. And after reviewing audio of those interviews, they need to sever Jennifer Crumbley's trial from her husband's. Attorney Todd Flood represents one of the young shooting victims who survived.
There was inevitably going to be a conflict, right? Of
I want to come back and watch that again in a little bit because I thought that was interesting. Could y'all hear it okay? Hear it okay? We're going to go back here to this. There's also, oh, they're coming back in. All right, let's listen in. Why can't we hear it?
I have reviewed the extraction provided by, I believe, the County Sheriff's Department on the sealed envelope. The prosecutor, I reviewed all the text. I made a copy for Ms. Smith. And Ms. Smith, do you have an objection to anything in the text chain?
No, I don't. I would ask that if the text chain is used, that it just be admitted as well.
Yeah, okay, so I am going to maintain a copy of the text chain in my own personal file. All right, and I'm handing a copy over to the prosecution.
Okay.
All right. So,
Thank you, Jessica.
can we continue the trial? What do you think?
Absolutely.
Can we have just a minute to look at it?
Okay, yeah, it won't take you more than a minute, but yes.
It sounds like you're going to. Just give them a second. I gave them time.
All right, I'm
But they're too short, so.
They're reviewing them, it should not take long.
Stay with my old reliable computer here. All right. Present, share screen. So I guess they're still reviewing some stuff. They can't decide what the heck they want to do. Well, they're just trying to be cautious. But I was going to read something to you guys really quick while we were doing that. Here's their takedown video. Let's watch this real quick.
We begin with breaking news this morning. Jennifer and James Crumbley, the parents of the Michigan high school shooting suspect, are in police custody right now. This was after the pair evaded authorities for hours after they were charged with involuntary manslaughter yesterday. Police say they were found early this morning inside a building in Detroit, not far from where their vehicle was found. Listen to this.
We got a tip that they were here, or that possibly the fugitives were at this location. The vehicle was spotted. Our officers responded in a matter of minutes. When they got here, they set up a perimeter, did surveillance. We notified and activated our Metro Division, our special response team. They came out and they were able to take the fugitives into custody.
Now, attorneys representing the couple say they fled the area.
There was another video I just thought that was interesting since we're all going back to the time period when this occurred on December 4th. I guess it was the early morning hours of December 4th. And I read something I wanted to bring up to you guys. The defense attorneys for the Crumbleys still argued Saturday, this was Saturday morning, December the 4th, that they never intended to flee and had made plans to meet their lawyers in the early morning of December 4th. Shannon Smith then accused the prosecutors of cherry picking facts to release publicly, including that accusations that their teenage son had unrestricted access to the handgun prosecutors say his father purchased for him days before the shooting. Our clients are just devastated as everyone else, blah, 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 blah. There was something else I saw I wanted to read to y'all. And it was about, okay, this is what Shannon Smith told them on December 3rd. She said that Crumbleys, speaking of the Crumbleys, they're making their way back here. They will be arraigned. They will be turned in. They are not hiding. They are not running from anywhere. They're not out on the lam. They are turning themselves in. Smith said her office contacted Oakland County Prosecutor Karen McDonald's office to discuss possible charges, and she said she didn't find out about those charges until the public was notified. Instead of, quote, instead of letting us know what was going on and calling us back like they said they would first thing this morning, they went ahead and did the press release, and then everything blew up. Oakland County Sheriff said that if they had tuned in at all, he said if they were tuned in at all, they should go ahead and do what was originally supposed to do with their attorney, because they were supposed to turn themselves in on Friday afternoon or have an arraignment on Friday afternoon, and they did not show up for it. Let me share my screen real quick. Okay. Laura said, I can understand hiding from the public when your child does something like this, but clearing out your bank, selling your property, selling your horses, being told warrants were issued. Well, I think the problem was that, and I'm not defending him when I say this, but what I understand is they were told by an attorney friend that they were going to confiscate all of their assets once that the police were going to come in and confiscate their means. So they were trying to have a backup plan in case that happened. So they say. They were scared to death. Yep, you're right.
All right, so I know you think that we all went out to breakfast this morning. We did not, as I described for you in the beginning of the trial. Sometimes things come up. If you need to take care of legal issues, I usually try to do that when you're not waiting for us, but that's not always possible. So I appreciate your patience. And we are going to continue on with cross-examination. All right, Ms. Crumbley, could you raise your hand? Do you swear or affirm the testimony you're about to give is the truth, so help you God?
I do.
So you can put your hand down, and could you state your name again for the record and spell your first and last name?
My name is Jennifer Crumbley, JENNIFER CRUMBLEY.
Go ahead, prosecutor.
Thank you. Mrs. Crumbley, I'd like to talk to you about your vigilance as a parent. But before I do, I want to make sure that you understood the oath that you just took.
I do.
Okay, you understand that you took the stand under oath and you have to tell the truth?
I do.
You understand that was the rules yesterday as well?
Correct.
All right, we're going to come back to that. Now, you have been described by your attorney as a hyper-vigilant parent.
Correct.
Okay, do you agree with that?
I do.
In fact, you called yourself a helicopter parent before.
Yes, I was.
So you told us that you spent a lot of family time together.
We did.
Now, I'd like to talk to you about what your digital footprint shows,
Okay.
what the evidence on your phone shows.
Okay.
Now, it's true, you agree with me that having horses is quite a time-consuming hobby,
It can be.
okay? It was for you,
It can be.
and that's what you said yesterday,
Yes.
okay? And you were at the barn for between 3 and 5 times a week,
More like 3 times a week.
3 times a week
Yeah.
for a couple hours a trip?
Correct.
Okay. It's also an expensive hobby.
It is.
So your banking records show that in the year 2021, you spent over $20,000 on the horses. Is that correct?
Probably.
Okay. And that's not including cash. That's just from Capital One and Flagstar Bank.
Correct.
In fact, you told a coworker that half of your salary basically goes to the horses.
I might have. Yes.
Now, except on rare occasion, you didn't bring your son with you to the barn.
He was not into horses. I would ask every time I went to the barn, but he didn't want to go.
So the answer was no.
No.
Okay. And at least as far as your horses being boarded with Kira Pennock from June of 2021 to November of 2021, your son never went with you. Is that correct?
I think he went once when my in-laws were in town and we met them at the barn.
Okay. But there was nothing stopping you from taking him.
No, he just didn't want to go.
Okay. It's a family atmosphere.
It can be.
Okay. Like the Halloween party that she had, that was for families.
Yeah, most of the kids there are young.
Okay. In the winters, you were on ski patrol as well.
Correct.
Okay. And that can be a bit of a time-consuming hobby.
It can be.
All right. And you would be on ski patrol between 1 and 2 times a week?
It's a total of 10 hours a week.
10 hours a week. Okay. So how many days?
I did doubles on Saturdays, so 1 day a week for me.
Okay. So you told this jury yesterday, you depicted your affair with Mr. Malash as a one time a week meetup at a Costco parking lot. Is that your testimony?
Correct.
Okay. But it wasn't just that, was it?
Nope.
Okay. In fact, there are numerous photographs sent to Mr. Malash.
Okay.
Yes or no?
I'm sure there was.
Okay. Numerous messages exchanged with him.
Correct.
And it wasn't just during the week, Monday through Friday, was it?
No.
No. In fact, that's what you said yesterday. But in fact, it included.
There were actual business trips that he met me on.
Okay. And included other individuals.
Yes.
What's Adult Friend Finder?
So where you can go on and meet people who meet certain tastes that you're looking for.
This is 429. And you had the app Adult Friend Finder on your phone.
I do not believe I had the app. on my
Okay.
phone.
It was found on your phone.
Okay, well, I guess it was on my phone.
Okay. And there were messages from you to other individuals.
Correct.
Your Honor, I would object that this is going outside of the scope of the affair with Brian, but.
I don't think the court's ruling on opening the door was confined to just her extramarital affair with Brian Walsh.
Well, I guess with regard to Mr. Malash, I determined that the defense opened the door. I don't know that I determined that the defense opened the door as to other.
She depicted herself as having one extramarital affair for about a 6-month period of time, where she met with him 1 time a week. That was her testimony yesterday. We have evidence to the contrary, and I think it's important.
This is gonna get exciting.
All right.
It is what it is.
All right, well, go ahead, but
I won't delve too far
okay, yeah,
into it, Judge.
really, this jury has been here a long time, and
I respect their time, Judge. I'll be brief.
You might have blushed.
So Mrs. Crumbley, I'm sorry, this is not a laughing matter. Mrs. Crumbley, on Adult Friend Finder, we see messages from you in at least of August of 2021, August the 4th, 2021.
Okay.
Okay, and you don't dispute August the 10th of 2021,
No.
August the 11th of 2021.
No.
And more importantly, November 21st, 2021.
No.
Okay, and more important than that, November the 28th, 2021.
No.
Okay, you don't dispute that evidence was found on your phone.
I don't dispute it.
Okay, and you don't dispute that it wasn't just you and Mr. Malash meeting after work hours. It was with you and Mr. Malash arranging with other individuals to meet after work as well.
No, I only met with Brian during work hours. The times that we were at the hotel, I was on business. We did arrange for other people to meet us there.
So Sunday, November the 28th. You remember that day? It was the day after you took your son to the shooting range.
I don't remember it.
You don't remember that day?
No.
2 days before the high school attack?
No, I don't remember what I did that day.
Okay. Well, you were pretty specific in what you did on November the 27th with the firearm. You remember that?
Correct.
All right. Now, November the 28th, 2021, you spent your time arranging a meetup with somebody on Adult Friend Finder.
I never met anybody on Adult Friend Finder that day.
Arranging a meetup.
Oh, okay.
Meetup.
Oh, okay.
I'm not just talking about the time that you spent physically with somebody. I'm talking about the time that you spent and devoted your energy to setting that up.
Okay.
And you'll agree with me, it's not just the time period at the Costco parking lot or the time period at the hotel or the time period on the trip, correct?
That's the only time I met with people.
Right. But that's not the only time that you devoted your own personal time and energy and focus to that, is it?
I guess I don't understand what you're asking.
Okay. Well, these meetups didn't just happen by themselves. You had to set them up.
Correct.
You weren't driven there. You weren't dropped off there. You set them up with somebody else.
Correct.
And that took your time and your energy and your focus to do so.
I don't believe it took too much time and energy, no.
Now, you told this jury that when your son texted you that he was seeing demons and bowls flying off the shelves, that was in the spring of 2021. You recall that evidence, right?
Correct.
You don't dispute that that was on your phone.
No.
You don't dispute that at some point you read those messages.
No.
And you don't dispute that your son said at least one time, "Can you please text me back?"
Correct.
You don't dispute that when you're at the barn, your other messages take pictures, send pictures, and receive pictures.
Usually I'm at the barn. If I take pictures and I try to send them, they don't go through right away, or I won't send them until I hit a spot where I actually have service.
So in Exhibit 423, the Facebook message chat between you and James, the chat that you deleted, there are a number of pictures that James sent to you from the barn of a horse in a conversation about that particular horse. Do you
Okay.
dispute that?
No,
Okay. And in fact, dozens and dozens of pictures of the lake.
I'm sure, yes.
You're sure? Okay. And those pictures were sent to you with a timestamp on that Facebook message chat.
Okay.
Do you dispute that?
No,
No. Okay. And then you responded in that same time frame. Do you dispute that?
no,
No. So that conversation with that picture that was taken at the barn was occurring while one of you were at the barn.
I'm sure it was.
Okay. Now, you don't deny that your son wrote in his journal that he asked his parents for help. You don't deny that evidence that was admitted.
No, I don't.
Okay. And you don't deny that he wrote in his journal that he now had access to the 6-hour 9mm handgun.
I do not deny that.
And you don't deny that the 6-hour 9mm handgun was in fact the murder weapon.
I don't deny that.
And you also don't deny that that gun was gifted by you and your husband to your son on November 26th.
Describe gifted.
How about when you posted on Instagram his new Christmas gift?
Correct. And I explained yesterday that it was for him to use at the shooting range. We didn't just hand him a gun as a here you go, son. It was something he could use when we went to the range as a family together.
You don't deny that in April of 2021, you described your son as being depressed.
I didn't describe him as being depressed. I noticed that he was acting depressed.
You used the word depressed.
Yes, he was acting sad. He was acting depressed.
Okay. And you know what depressed means?
It means a lot of different things.
Well, to you, it meant depressed, and you wrote that.
Right.
You don't deny in April of 2021, the evidence shows that your son told his only friend that he had asked you for help?
No, I don't deny that.
Okay. And you also don't deny that he told his only friend that you laughed at him.
I do not deny that.
Now, yesterday you told us that you took those messages in the spring of 2021, which, by the way, is at the same time you started your affair with Mr. Malash?
Around that time.
Okay. So in the spring of 2021, when you sent those messages, or when you received those messages, you indicated it was messing around.
It was.
It was messing around. In your mind, messing around. That's what your testimony was.
Yes.
Okay. Even when he said, can you please text me back?
I didn't see his text message, so I didn't text him back.
Even when your phone logs show missed calls?
Can you ask it again?
Even when your phone logs show missed calls from your son in that time period?
No.
Now, you said yesterday about these messing around texts. You agree with me that there's no indication in any text message, either between you and your son, or any Facebook message between you and your husband, in any of those exhibits, in fact, anywhere on your phone, that indicated that any of those messages were a joke?
No, there weren't.
There weren't. And we're talking about hundreds of messages between you and your son, and thousands of messages between you and your husband.
Correct.
And you don't deny that you never once took him to see a therapist or counselor?
No, I did not.
You did not. Now, you testified that, actually, Mr. Malash testified that you would meet during work hours, and we've established that it wasn't just confined to work hours, but we're permitted to leave as you please.
Correct.
Okay. And your boss actually testified that no problem if you needed time off.
Correct.
If you had a family issue, no problem, you can go.
Correct.
If you were sick, no problem, stay home.
Correct.
Okay. In fact, you could work from home on an as-needed basis.
Correct.
In fact, on November the 30th, you didn't even ask your boss if you could leave. You just told him you were leaving.
Correct.
And you told him when you were coming back.
Correct.
And you told him when you were coming back after receiving a phone call from the school asking for an immediate meeting.
Correct.
Because that was at what, 10:05 a.m.?
Around that.
Okay. Now, had you ever been called? You have the CD on, please, Mr. Blaine. Had you ever been called?
It takes some time for all three of them.
Sure, Judge. I have a few more questions I can ask before we get to these.
Okay, go ahead.
Have you ever been called to the school on an immediate basis before?
No,
Have you ever been told that your son had suicidal ideation before?
I was never told he had suicidal ideation before.
Okay, that's your testimony. But you've never been called to the school once for a meeting, I need to see you now,
No,
correct? Okay. So even before you had made it to the school, you had told your boss when you were coming back.
correct.
So you had already put a limit on that meeting.
Not necessarily.
Well, you said, I'll be back in about an hour,
Okay,
right? That's your, those were your words.
correct.
This is Exhibit 74. Do you see it?
No, she doesn't.
Oh.
It's not on here. That's. Yeah, it takes a minute.
Okay.
Is it?
Yeah.
Can you see it?
Yeah.
Okay. This was sent to you. So Sean Hawkins called you at 9:24 in the morning, correct?
Correct.
Okay. You called him back at 9:27.
Correct.
You had a 5-minute phone call.
Correct.
And then in that phone call, he texted you the picture with it was drawn out. They emailed you this original picture.
Yeah, he texted me the modified one and then later emailed me this one.
Later is at 9:32.
Yeah, like after I asked him for it.
You looked at it.
I did.
Okay. You told us yesterday you found it, I think your quote was a little concerning. What struck you about this?
Originally, when I saw the modified one, I was kind of angry at my son because we just talked about his missing assignments in geometry and his E the night before. Then when I got this one and opened it, it was concerning. I honestly thought the guy on there was a poor drawing of Batman, the way the thing in the cat. I thought it was a cape. I didn't know.
You thought that was a cape?
I did. I didn't look
Okay,
at
what
that
did you think of
closely.
the gun?
I thought it was a gun.
Yeah. What about the fact that it is identical to the gun that you got him for Christmas a couple days before?
I mean, honestly, it's just like it looks like a gun to me. I didn't even notice.
Well, you took a picture of the gun. You posted it on Instagram. You know what it looks like.
I do, but I didn't analyze it.
You saw Sergeant or Special Agent Brandon's testimony. He described how it's identical. And you told us yesterday how your son was a good drawer.
He's a very good drawer.
Okay. What about the thoughts won't stop help me? Out to you?
Yes, that was what was concerning to me.
Blood everywhere, and there's a bullet. And actually, you were the one who bought the bullets on November the 27th.
Correct.
You later came to learn that those bullets were used in the shooting.
I did.
Okay. So you said yesterday it was a little concerning, yet you told your husband emergency in all caps.
Correct. That's why I left to go to the school and I
you said-
texted him.
And he wrote back, "My God, WTF."
Correct.
And then you told him he was distraught about last night.
Correct.
Distraught's an intentional word you chose.
Correct.
Not sad. It's not a little anxious about school or his future. It's not talking about a video game. Distraught has a meaning.
Correct.
And you chose that word to send to him.
Correct.
So you went to that meeting, and this was November the 30th of 2021. And at that point, you'll agree with me that you knew prior to that day, the November 26th purchase day, that your son was wanting to get a 9mm. That's what you said yesterday.
Yes, I knew that they were talking about getting one because they had
Okay.
rented it in the past.
And you knew that he had shot one in the past.
Yeah.
Okay, and you knew that a 9mm is significantly more powerful than a 22.
I did not know that until I actually shot it.
Okay, well, your dad took your son with James to the shooting range when they visited in July of 2021.
Correct.
And they talked about how powerful the 9mm was because they rented one.
Okay. I don't know.
Yes
if I
or
was,
no?
I don't know if I was part of that conversation, but if it was, it didn't register to me.
It registered. Okay, you knew at the November 30, 2021 date that your son's friend had been taken without notice to your son.
Correct.
You said, I'm sorry, incorrect or
I said correct.
Correct. And you knew that when your son's friend was taken, your son was extremely upset.
He was upset, yes.
He didn't go to school for a few days.
I don't remember that.
Okay. Well, if the school records show that he was absent for a few days after that, would you deny that?
I wouldn't.
And would you deny that he missed school because he was so upset?
I don't know if he missed school because he was so upset or maybe he was sick. I don't know.
Now, you told us yesterday and you acknowledged that that individual, that child, was like a second son to you.
Correct.
So he was the only one that your son hung out with.
Outside of school, correct.
Okay. Well, who did he hang out with inside of school?
He named some names to me. I've never met them before, but he told me some group of kids that he sits eats lunch with and he talks to in class.
Did he ever visit their houses?
No.
Did they ever visit your house?
No.
The only other peer to visit your house was this student who left the state around Halloween 2021.
At that time, correct.
We're talking about that time in October, in September, in at least August, July, June, May, all
Of
2021.
2021, correct.
2021, thank you. Now, he left on Halloween, and you knew that your son was planning to hang out with him on Halloween,
Yes.
okay? But his friend didn't show.
I had texted his friend's mom the day before trying to confirm if he was still coming over. And that's when we found out that he was driven to Wisconsin and taken to that school.
Okay, so you're telling us you found out the day before Halloween?
Yeah.
Okay, so that didn't stop you and James from going to a Halloween party at the barn.
I don't believe it was on Halloween.
Oh, that's what Kira testified
It was
to.
it was the Friday before Halloween.
If there was a picture with a date stamp on it, would you deny it?
No.
Okay. And it didn't stop you from after you left that party without your son, you went to another Halloween party.
We did.
And your son was home alone at that point.
Yes.
So you talked to us a little bit about your son's hobbies in 2020. In November of 2021, so we'll start with November the 1st, 2021. You know that those hobbies were non-existent. And I'll go one by one.
Okay.
So you told us about bowling.
Correct.
Bowling the team wasn't in session at that point in time, was it?
No, I think actually at that time he decided he didn't want to do bowling that year.
Okay, so he stopped bowling the
He did.
sophomore year.
He did.
And it wouldn't have been bowling season anyway.
I guess not. No.
So one hobby you talked about yesterday that was not in existence in November 2021.
Correct, but we did still go to the bowling alley with him.
Okay. And you said that he worked, but would you be surprised to learn that he only worked a few shifts post-COVID?
No, I'm not surprised at all.
Okay. So he wasn't at work every day?
No, he worked Tuesdays and Thursdays and sometimes Saturday mornings.
Okay. But not very often?
No, not very often.
A handful of shifts post-COVID, which of course, March 2020 is when things shut down.
He was working on a weekly basis.
And you knew that he didn't have any friends?
That's not the right way to put it. I knew he had friends, but no, he did not have many friends.
You had never met another peer his age who he refers to as a friend?
He actually had friends that used to come over prior to 2021 that he was still in contact
We
with.
went through defense exhibits yesterday from 2019 to 2020. I'm talking about 2021, at least from the time period where he sent you a message that he saw demons in the house.
Right. In 2021, the only friend that came to our house was the one that was
Right.
on the thing.
So you knew to be true in November of 2021 that he had no peer support.
I don't know what he had in school. He told me he had friends in school that he talks to.
Okay. You never met him?
No.
Okay. And he didn't have any clubs at school he was a part of?
No, not that year.
So you told us yesterday that your son wanted to design video games.
Correct.
Okay. He wasn't in a robotics club or a coding club at the high school.
He did take a coding class prior to 2021, and he was in a robotics after school activity in middle school.
Talking about in
I'm
2021.
just telling you, he's been in that before.
Now, despite what you have called yourself as a vigilant parent and a helicopter mom, you never decided in at least November of 2021 to look at his phone.
No.
That's despite what happened in the spring of 2021, right?
What happened in the spring of 2021 did not concern me.
Okay. Now, the one thing that seemed consistent with your son, to you at least, is his desire to obtain a weapon. Is that right?
I wouldn't say that, no.
He had a consistent desire to obtain a weapon.
Not to me, he did not.
Okay. You didn't know about the 9mm?
Oh, I knew about it.
Okay. You didn't know about the 22s?
I knew about them.
And in fact, you posted on Instagram that he got himself a 22
Correct.
in June of 2021.
Correct.
And from that time up until the November 26, 21 purchase, he was wanting to get a 9mm.
I know him and my husband had discussed getting a 9mm. I'm not part of those conversations.
But you knew about it.
I knew, but not that he was so, however you described it.
I said he consistently had a desire to obtain a weapon.
I know they consistently talked about it. Correct.
Okay. He didn't just talk about this is a gun. He talked about how he wanted the gun. You don't deny that.
Oh, no.
In November 26, you said you weren't there for the gun purchase.
No, it's not.
Okay. But are you telling us you didn't know it was going to happen?
I did not know they were going to the gun store that day. No.
Okay. But you knew that you were going to eventually get him a 9mm.
No, I did not know that.
Okay. So you're telling us that was a surprise purchase to you?
It was surprising to me that they went to the gun store that day.
Okay.
It was not surprising to me that they purchased a gun that day.
And it didn't upset you that they bought a gun?
No, it did not.
It upset you that they cut into your Christmas tree shopping time, but it didn't upset you that they bought a gun?
Correct.
And you told us that it was, in your words, James's responsibility to take care of that gun.
Correct.
Now, you don't deny that, at least according to the cell phone evidence, the photographic and video evidence, you're the last adult to have possession of that gun.
Correct.
You were with him at the range on November the 27th.
Correct.
You saw your son shoot the weapon.
Correct.
You saw him shoot the last practice round before the shooting on November 30th.
At the range?
Yeah.
Yes, correct.
You saw how he stood.
Honestly, that didn't mean anything to me at that time until this whole case came about and I've learned what a shooter's stance is. So
He knew how to use the gun.
yes, he did.
Okay.
He's used one before.
In fact, he showed you how to use the gun.
Correct.
Okay. And the stance he took, you saw from the Oxford High School video, was the same. You saw that, right?
I don't know. I can't compare it. I don't know.
But you entrusted this responsibility. Will you agree with me that owning a firearm involves a great deal of responsibility and trust?
I do.
Okay. And you entrusted this responsibility to your husband, James.
I did.
If you look at Exhibit 423, that's the Facebook chat thread between you and your husband. It's pretty clear you didn't trust James with much. Would you agree or disagree?
Depends on what you're talking about.
Okay. Well, you didn't trust him to get out of bed on time.
Correct.
You didn't trust him to cut the grass when it was time to cut the grass.
He would cut the grass when it got to a length I didn't like. I didn't trust him.
You didn't trust him to update you on his whereabouts.
There's a reason behind that.
You didn't trust him to not turn off or turn on the Ring camera in your home.
Correct.
You didn't trust him to keep track of your son.
Oh, I trusted him to check my son.
In those messages that we'll see in Exhibit 423, asking him, where is your son, over and over and over again, does that signify trust or distrust to you?
That was when my son was walking home from school. Not that I did not trust my husband with my son.
Okay. And you didn't really trust your husband to hold down a job.
It's not that I didn't trust him to hold down a job. He had a hard time holding down one after COVID.
Okay. And in those messages, you are constantly asking him about work, how much money he's making, and what he's doing to obtain employment.
Correct.
Okay. But this is the person you entrusted with a deadly weapon.
I did.
Why did you buy the Patriot defense rounds?
Where are the? Oh, those are that's the ammo. That was the ones my son told me to purchase. I didn't know anything about it. I'd asked him, and he told me to purchase them.
So you told the jury yesterday, I think you repeated it again today, that the gift was for target shooting only.
Correct.
Okay. Yet you bought 100 rounds of ammunition.
Correct.
And you only shot 50 while you were there.
Correct.
And those 50, at least according to some statements you made throughout the investigation, you put somewhere.
The box of them, yes, I did. I hid them.
Now, on November the 27th, when you came home, you posted pictures of the gun and targets to your Instagram account.
Correct.
And then, according to the location data, your location data, you left.
I think that's when we went. Well, I don't know. I must have. Yeah.
Okay, well, you don't deny that.
I don't deny
Okay.
it.
And your husband James was gone all day, according to his location data.
I think so. Yeah.
Okay. And you saw in the evidence that in a picture you posted, there's an ATF pamphlet on handgun safety for children.
Correct.
Did you read that?
I looked it over. Correct.
Now, on Exhibit 74 here, I want to get back to this meeting for now. Exhibit 74, you don't deny that you could have left work for the day.
No, I don't deny that.
Okay. And you don't deny that you didn't tell the school officials, Mr. Hopkins and EJAC, about the gun purchase on the 26th.
No, we had stated that we went to the shooting range with I went to the shooting range with my son on Saturday.
You didn't tell them that you had gotten him that Christmas gift.
I didn't think it was relevant. No.
You acknowledge that you never told Mr. Hopkins and EJAC that it wasn't just a friend, but it was the only peer that you had ever met and left.
I probably said his best friend.
You acknowledge that you didn't go home to look for that firearm after the meeting at the school.
We wouldn't have a reason to.
So that the answer is, and you acknowledge that?
No, I acknowledge that.
Okay. And you acknowledge that you had already made plans for the night to go to the barn.
Yes, I do.
Okay. And you acknowledge that you had the time to stop at your house before you went back to work.
I would have, but I didn't have a reason to.
Now, you had told us that you had never taken your son to any sort of mental health professional.
No.
Okay. But you know how to obtain the help.
Correct.
In fact, you have prescriptions related to that.
I do.
So it's not that you didn't know who to call or how to call. You didn't.
Correct.
Correct. Okay. Yesterday, you talked a little bit about how you express emotion.
Correct.
And in fact, and the counsel asked you about your nerves when you testify. But you're capable of emotion.
Yes, I am.
Right? Okay. And in fact, you had some explosive emotional fights with your husband.
What we did.
And that was in the home that you shared.
Correct.
Okay. And with your son.
Correct.
We saw pictures of that home.
Correct.
And you told us that your son was at an age where he wouldn't text you back, I love you.
It wasn't a text me back, I love you. It's like in passing, like, hey, Ethan, good night, I love you.
Well, yesterday you told us that your son was at the age where he wouldn't text you back, I love you. Those
Well,
were your
that,
words yesterday.
yeah, but more or
Okay.
less like just saying it in passing. He wouldn't say it back. I say good night, Ethan, love you, and he did good night.
Okay.
For him to text me that he loved me was abnormal.
Abnormal.
Correct.
Okay. But you didn't respond to that text until 44 minutes later?
No, I was in a meeting at work.
Okay. And if you go through your entire text message thread between you two, the word love pops up how many times do you think?
Between me and my son?
Yeah.
I have no idea.
Okay. 3.
Okay.
The first is in reference to the game chess about a year before.
Okay.
And the other 2 times are right before your son committed this act and after the shooting when you responded. Does that surprise you?
No.
Your Honor, I would just ask if there could be a foundation for the dates of those texts, because I feel like we got just a few texts.
Okay, well, I think he specified, did you specify the date?
I did.
Two of the times were before and after the shooting, and the other time was when?
About a year prior. I could pull the data if council would like it.
And I'm also wondering if what the data he's relying on is coming from Jennifer's phone where she deletes all her texts, or if it's coming from the shooter's phone. Because the prosecution's asking questions, I just want to know the foundation.
Oh, sure. Let me clear that one up. It's from your son's phone. So all the messages would be contained there. You don't deny that information would be accurate.
No, I don't deny it.
Okay.
He is so arrogant.
You told us that
He asked if the chess one was a year earlier, and the other 2 were close in time to the shooting.
the day of the shooting.
Yeah, I know.
I'm asking,
Those have been admitted in evidence.
do we know?
Wait, what's the question?
Okay, but he's asking about the text overall, which have not been admitted into evidence. And I don't know that the text chain has all the texts. There is no foundation that what Mr. Heath is looking at.
Judge, in cross-examination,
texts.
if the
He's
wit-
asked if that, is that wrong? Would you argue with that? That's what he's asking. I mean, there are people.
I know, she just doesn't know what.
hold on, counsel can't testify.
No, she can't testify. Well, there are people that end every conversation with love you.
Yeah,
Right?
I'm with that.
Okay, so, and there are people who don't, right? So he is asking what's normal for them, and would she be surprised that how many times they'll hear?
Yeah, I'm just asking, I get that, and I get that it's not common. I'm just asking. what
Judge, this is
period-
argument.
I'm just
Counsel can
asking
argue
what
whatever she wants to.
period of text this is from.
Well, you have redirect.
Okay, well, she doesn't know what he's even basing these questions on. His
How,
point.
okay,
Well,
it is inappropriate for counsel to
Okay, she
suggest to the
can say, I
court
don't know.
she or does not know.
She can say, I don't know, or she can also say, I don't understand the question. She
Okay.
can say that too. Mrs. Crumbley, if you don't understand the question, ask Mr. Peace to clarify it.
Okay.
All right?
All right, thank you, Judge. Now, yesterday, Mrs. Crumbley, you talked about going into planning mode.
Yes.
Okay. And that was in reference to counsel asking you about emotions and how you express them. So I want to talk to you about your planning mode and your priorities from the time that you were arrested.
Okay.
Now, your phone calls were recorded from the time that you were arrested until now. You know
Correct.
that? You
Yeah,
know that,
I
right?
knew that.
You know that, okay. And your priority on your first phone call, December the 4th of 2021, was on your animals and the cash recovered from the art studio. Do you deny that?
I don't deny it.
Do you deny that it wasn't until 10 days later and 14 calls later that you even mentioned your son? Do you deny it or not?
I don't, but I was under the impression that I couldn't mention him because I could get flagged at the jail.
Well, you mentioned him in later conversations.
I did.
Okay. And in fact, in one, a year later, March 25th of 2023, you said he just needs to man up. Do you recall that?
I do not.
Okay. Do you deny that you said it?
It sounds like something I would say.
In December of 2021, your concern was about a GoFundMe. Do you remember that?
No, I do not.
I'm going to play this for you. Ms. Williams, can you have the volume up, please?
Is this submitted as an exhibit?
This is impeachment, Judge.
Appeared on a secretary.
Oh, he is destroying her, you guys. And it's just getting started.
Well, there's no, Jennifer, that's. Like, she knows that for speaker face, but I know there's a lot of people that call the lawyer about the welfare of my horses. So, I mean, I'm just not, listen, I'm throwing shit against the wall to see what's different. What's that? I'm just throwing shit against the wall to see what's different. I know.
Okay, that was between you and your dad?
Correct.
Okay. And you asked him to set up a GoFundMe to pay for the board of your horses?
I did, yes.
You were concerned about other things related to yourself around that time, weren't you? Is
yes.
this still planning mode?
I believe so.
Okay. And you were arrested December the 4th. This is going to be December the 22nd.
Okay.
Oh, I got it from
Yeah, okay.
Can you have her Google how many calories are in a bologna sandwich with white bread?
How many calories in a bologna sandwich with white bread?
Yeah, American cheese.
With American cheese?
Yeah.
You get some mayonnaise on it?
No, just mustard. No, there's nothing mustard. And then peanut butter and jelly on white bread.
And peanut butter and jelly white bread, okay, so you're looking up bologna right now. Is that what your lunch and dinner is?
For the most part, yeah, and the other stuff, I put my cereals, now some of them are actually.
Well, there's American cheese, yeah, American cheese.
And an apple and a banana. Because they like, they're carb loading me, and I want to make sure I stay at like 1,000 to 1,200 calories.
No, I know bananas are 100 calories.
Is it okay? What about an apple?
Yeah. So the sandwich is 140 calories. Oh, 240.
Okay, that's 300, so that is
Yeah.
calories a day.
And then peanut butter jelly and white bread.
Still planning mode?
Well, I wasn't planning there, no.
Okay. Now we're talking about how you describe planning mode. You describe that in context to statements you made to the police on November the 30th, 2021. Right? That's the context you use the words planning mode in relation to.
Correct.
Okay. So you told us that the last phone call on December 31st, that was still you in planning mode. I want to make sure we can accurate depiction of what that is. Now here's one from January 15th, 2022.
No, it's not an issue of that, it's an issue of, that bank's gonna be always, they've had issues with their online stuff, and they had issues with, just all kinds of stuff, about how can they bank on these people, it's like, so.
But that child deposit thing?
So what?
Am I still gonna get a deposit of $300? That child thing the government does?
I just got, cause I lost access. For some reason, I don't know if I told you that, I had access. Well, I had access basically to view only, and it's hard to see everything on there, but then also I lost access, and it took me, I lost access like a couple days before Christmas.
Yeah.
Okay.
Okay. Is that still planning mode?
We were talking about filing my taxes if you played the whole thing.
You were asking about your child tax credit, if you're still gonna get that $300.
My dad was doing my income taxes for me.
Now, when we started, we confirmed that you understood the oath that you just took.
Correct.
And the same oath you took yesterday.
Correct.
Okay. And you don't deny that you had $6,000 in cash in your purse the night you were arrested?
No.
You don't deny that your purse with the cash and 4 cell phones were in a plastic tote?
Correct.
You don't deny that that plastic tote was contained in a different plastic tote?
Correct.
You don't deny that your backpack with clothing items was found in a different plastic tote in a different area of that studio.
Correct.
Okay. And you don't deny that you knew you had been charged with involuntary manslaughter.
Correct.
In fact, as early as December the 1st, 2021 at 6:10 p.m., you were talking about how you're being charged with involuntary manslaughter.
That was what I was being told by a family that was texting me. That's what the charges might be announced as, correct?
Okay, and one is to Mr. Malash. There's a text to your cousin about you are being charged with involuntary manslaughter. You don't deny receiving that.
No, I don't.
That's Wednesday, December the 1st.
Correct.
Right? And you sent your neighbor a message on Wednesday the 1st of 2021, 6:55 p.m. that you were reading, they may charge us.
Correct.
Okay. And December the 2nd, 2021, you wrote, they're saying involuntary manslaughter.
Correct.
You don't deny that?
No.
And of course, you looked at different news articles about that the next day.
Yeah.
And later on that day. And then you texted, after all of these messages and news articles, on December the 2nd, 2021 at 2 p.m., we're fucked. You wrote that to Mr. Malash.
Correct.
Okay. And then you wrote announcing charges at noon on December the 3rd, 2021 at 8:17 a.m.
Correct.
And you wrote that to Mr. Malash, you wrote that to Kira, you wrote that to your dad, right?
Correct.
Okay. So you don't deny any of that?
No.
Okay. Now you told us yesterday that you popped 4 Xanax?
I did.
Okay. And your husband popped 4 Xanax?
Correct.
You said you went to bed about 11 o'clock.
It was around that time.
Okay. And the evidence that we have admitted show that you set your alarm for 6:30 a.m. and 6:45 a.m.
I don't know if it was me who set it, but it was set for that time.
Okay. And from the evidence, it shows when it was set too.
Correct.
Okay. And it was set a little after 11 p.m.
Okay, correct.
Yes? Okay. So yesterday you said, I want to say it was after 11 about going to bed. I want to say it was after 11, maybe around 11 o'clock when we finally went to bed. I prescribed Xanax for anxiety, and we each took 4 because we knew we were going to turn ourselves in the next day, and we hadn't slept in 4 days, and we just wanted to sleep. The question was, okay, so you took 4? Your answer, we did. And the next question was, okay, so the next thing, the next piece of evidence we saw that was coming in that art studio, do you recall that? Your answer, I recall my husband screaming, there's people with guns against interface officers. Question, what were you doing prior to hearing your husband screaming? Answer, we were sleeping. Question, okay, were you aware that there was anything going on? Answer, I was not.
Correct.
That's your testimony.
Correct.
Okay. And you know when you say something that isn't true, that's called a lie.
Correct.
Okay. This is going to be exhibit 430. Council does have a copy.
Is it
The entire thread.
perfect? No
Here you
judgment.
go.
Oh, thank you.
Judge, does the court have a copy?
Is this today's?
Yes, Judge.
Okay. Any objection?
No.
Okay.
Mrs. Crumbley, you knew the police were there.
430 is admitted.
Thank you, Judge.
Not until I woke up, no.
Not until you woke up.
Correct.
Okay. Now, we heard testimony yesterday, or throughout the trial, that 911 was called at 10:43 p.m. You recall that?
Yeah, I saw in the video, correct.
Okay, and on the video, the first officers arrived before 11 p.m.
Correct.
Okay, and either you or your husband, we couldn't tell from the video, but you tell me, was it you or your husband out there smoking?
That was my husband.
Okay, so your husband walks in shortly after the 911 caller walks in the building to call 911.
Correct.
That was on the video.
Correct.
Okay, and officers arrived. And then we've heard testimony from Mr. Kirtley, who had a studio there. We heard testimony from Sergeant Hendrick, who was in the fugitive apprehension team, as well as Corporal Shaw with the Detroit Police SWAT team, about the amount of officers there.
Correct.
You recall that?
I do.
And you recall hearing the testimony that Corporal Shaw's team, their SWAT team, they actually used a 35-pound steel ram to bash in a door at the studio next to where you were at. You recall that testimony?
I do.
Okay. And your testimony was that you were asleep when the officers arrived.
Yes, I was.
Okay. But you had an alarm set for 6:30 in the morning on your phone, and that phone was found powered off, hidden in a tote, contained in a different tote, in a place away from the bed.
Correct.
You don't deny that?
No.
All right. And there are certain messages in 430. I'm going to go through them with you. This is actually to your attorneys. At the time, you had 2 attorneys. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. That's it. December the 3rd, 2021, 6:04 p.m. Do you recall that?
I don't, but I don't deny.
Okay, you don't deny.
No.
Okay. Your next message, the other phone broke. That's December the 3rd, 2021 at 6:04 p.m. The response was, when you can, we would like for you to call us. That was from either Ms. Smith or at the time co-counsel Mary Elaine.
Correct.
Your response, I'm sorry, this is from Marielle. Thank you. Shannon is calling you both shortly. Okay. At the top it says to and from. I'll make sure I identify for the record. From Shannon, Marielle and I are going to come get you guys in the morning. We do not think it will help to make a statement that you're coming back now or that it will be tomorrow a.m. We can say that we told everyone you were coming back, and as of tomorrow a.m., you are back. That's Friday, December 3rd, 2021, 7:02 p.m.
Correct.
Right? Okay. So that's after James had already moved the car around and backed into that parking spot.
I believe so.
All right. From Shannon, we can show them that everything we said was going to happen did happen. That's Friday, December 3rd, 2021 at 7:02 p.m. Right?
Right.
Your response, okay, that's at 7:03 p.m. From Shannon, I'm going to drive home from my office right now and call you guys in about 40 to 45 minutes so I can get all the bond factor information written down for Mary and me. That's Friday, December 3rd at 7:36 p.m.
Correct.
Okay. Your response, okay, we'll be waiting, 7:37 p.m. Shannon, I'm going to call in 1 minute. That's at 8:54 p.m. that Friday night. Your response was okay. You recall?
I don't, but I don't deny it.
But you don't dispute the records.
Correct.
The next message you send was, think we might have found, don't know, just heads up, please check. December the 3rd, 2021, 11:14 p.m.
That was written, but I do not believe it was written by me.
Okay, you don't remember, well, you told us you don't remember any of these text messages. You just
Right,
specifically
I
remember this one?
read through it, but,
You don't deny that this was on your phone, what we refer to as the burner or track phone.
correct, we
You don't deny
we
that.
were both using that phone at the time because my husband's broke.
Okay. And then you wrote in quick succession, don't know, 11:16 p.m. We might have been found, 11:16 p.m. Laying low, 11:16 p.m. You don't deny that these are the records?
No, I don't.
Okay. Response from Shannon, oh shit. Friday, December 3rd, 2021, 11:16 p.m. Now we know from all of the objective evidence, the testimony, the video, everything that the officers testified to, they were on scene before 11 p.m. You don't deny that?
No, I don't.
You don't deny that there were hundreds of officers on scene?
I don't know how many were on scene.
Okay. How many did you see when you got pulled out of the art studio?
Honestly, I don't know. It all happened so fast. I knew there was more. There was a few. There was more than a few, but not.
We saw the body
hundreds.
camera footage.
Right.
Okay. I do want to make a point so everyone's aware. This exhibit was just made admissible this morning.
Correct.
Okay. So we actually just received it this morning, and when you testified yesterday, you didn't know this exhibit was going to come into evidence.
Correct.
Okay. I want to talk to you now about the night before the shooting. November the 29th, 2021. You had testified that you got into a fight about grades with your son. Is that because you checked Power School?
Yes.
Okay. During that fight, did you lock your son out of the house?
We did not.
You don't deny that he was outside of the house?
He did walk out of the house. He was upset.
Okay. You told us that you took his phone.
We did.
That's not true, is it?
It is true.
On
We took
November the 29th, 2021, your son filmed a 19-minute video while he was outside describing what he was going to do the next day.
Oh,
What time
crap.
was that taken?
10 o'clock.
I don't know if he got it back. I know we took the shooting range away and we took his gun away. So I don't know if he got it back.
Now, all of the times that you were at the barn, there was nothing stopping you other than you told us he didn't want to go, right?
Correct.
There's nothing stopping you on November the 30th, 2021 from taking him home.
Correct.
Nothing stopping you. You know, actually, I want to go back to what you just said. You took his gun away.
We took the shooting range away.
You said you took his gun away.
No, I said we took the shooting range away.
No, she just said they took
Your
his
son
gun
could have
away.
been with you those 3, 4, 5 times a week when you were at the bar.
He could have, yes.
Your son could have been with you on those times when you were with either Mr. Malash or somebody else.
No.
In the weeknights, he could have been with you after school, after work.
I wasn't with Mr. Malash at those times.
Okay, the other individuals then.
I wasn't with them either at those
Well,
times.
According to the
I
friend finder,
might have messaged people at those times, but I was not with anybody at those times.
he could have been with you on the Halloween party.
He did not want to go. It was a bunch of little kids.
And on November the 30th of 2021 at 12:51 p.m., you could have been with him,
I could have, yes.
and you didn't.
No.
Nothing further.
Thank you. Mrs. Crumbley, I just have two areas of questions for you. Mr. Keys played some recordings. Who were you on the phone with in those recordings?
And my dad.
Okay, so you asked a couple of questions about calories, and then what was the other one?
I guess a child tax credit.
Okay, how often did you speak with your dad?
During the summer, it was every day. They went back to work. It was just on the weekends. They're both teachers.
And how many hours a day do you spend with other people?
Sometimes it's none. Sometimes it's when they walk by my cell, I'll talk to them, but I'm locked down 23 hours a day. I get 1 hour out by myself. I talk to my clergy lady legally, so I see her. Sometimes I talk to the church priest, or I'll talk to my attorney, but it's about the most human contact I get.
So I guess one of my questions is, when you do talk to people, you talk about, are there more conversations than just those?
Right, there are.
Okay. And then that night on December 3rd, going into the 4th, after 11, there was one phone being used, is that right?
Correct.
Whose phone was being used?
It was my burner phone.
Who was using the phone?
My husband was using the phone.
Okay, were you also using it?
No, I was using my other phone. So he started using my burner phone. I used the one with the regular phone number to do anything on.
Okay, so these messages are from the burner phone.
Correct.
To myself and Mario.
Correct.
So the ones after 11 o'clock, so at 11:17 or whenever these texts came in, what were you doing?
When I saw the video of my husband going to the car and having a cigarette, I knew I was probably sleeping at that time, because I did not like us not being together after what happened to us on the 30th when the police came to our house. So if he went out to have a cigarette, it was most likely because I was asleep.
Okay, when guns were in your face and we saw that on the video, before that, had you been asleep?
Yes.
Are you absolutely sure about that?
I'm positive.
Okay, I have no further questions. Thank you.
I'm going to excuse you for about 10 minutes and we'll see where we're headed. Okay?
All right,
She said, I'm going to excuse you for about 10 minutes and then we'll see where we're headed. She's talking to the jury. I guess they're going to have a sidebar to discuss what is allowed next. I don't know. I'm really surprised that the prosecution didn't go harder on her. I mean, at first he was like all riled up, and then he kind of just settled down. Why are y'all talking about them being teachers? They're not teachers.
You can rejoin your attorney. Okay, so tell me what's happening now.
Can I have just a moment for my client?
Sure.
They purchased burner phones. Even the police told him that you should go get a burner phone because we're going to have your cell phone for a
Your
while.
Honor, this time the defense rests and we're ready for closings.
What?
Great.
We are not at this point. We would need at least a 30-minute. We can be ready in 30 minutes.
It was Mrs. Crumbley's parents. Those were very short witnesses, so.
Well, that's fine, but
I wouldn't know how long they want. I just,
Okay.
she said there were two more that were.
I don't have an objection to them having 30 minutes. I'm just saying we're ready to go to closing, which is good news.
I'm not surprised because she was planning on resting, but she didn't tell us that, which is fine. But her client just testified to some things that we really do want to incorporate into our closing.
Okay, well, that raises a couple of questions. One, okay, so you rest. Are you calling anyone in your role?
that's what I want to speak with the prosecutor about.
One
Judge.
moment.
In light of-
Hold on.
Sorry.
Okay.
I'm so sorry. This is a lot.
Okay, well, if you guys want to break to this.
If
Yes,
we could,
we
Okay,
do.
so they have a right to rebuttal, so I'm going to.
Okay, things are changing a lot, sorry.
Okay, so I'm gonna allow them to have that discussion.
Okay.
But as I indicated yesterday, I think that we've been back and forth on jury instructions. And I submitted to you, I don't know, about 5 days before the trial, what I believe would be the final instructions after consultation with you. And there might be some fill-ins, there might be some things, so I need to know what those are. I make the attorneys sign in law that they agree on before closing, so.
Your Honor, just so I can make sure I have the absolutely most updated copy, Ashley, would you email it to me?
Yeah,
Okay,
we
I'll,
can email it to you, we can have, but
I
we
just,
have,
well,
we
I have
have it.
so many files,
We
I
have
just
it.
want to make sure that I'm looking at the right one.
We-
And I think,
we do have it.
I think we're actually good on those, so.
I thought before we started, we agreed upon the instructions. I recall that.
Oh, we
The
did,
first day.
but you know, sometimes.
I just need to double check we pull out, like defendant not testifying,
Right.
like the simple things.
Yeah, some small things can change, okay? So, you got it? Do you want to get back to me shortly and let me know if you're gonna have rebuttal?
Yes.
Yes, sir.
Okay. Because
Wow.
that will determine what we do next.
Sounds good.
Thanks, Ron.
All right.
So they're going to take a break. I think she said 10 minutes. I know it's hard to hear the judge. When I'm doing my video clips, I'm automatically increasing the volume on this trial because it's just been so low. Look at Shannon smiling. She's all happy. She said, "I finally stumped them for once." That is interesting. What do you guys think? Oh my gosh. I wonder if Shannon's doing that because she's like, okay, I don't want to give him a chance to come back and get anything else on Jen. I feel like I wonder if she's regretting what she did at this point by letting her come up on the stand. I know, right? That, like, we rest. That came out of nowhere. Completely out of nowhere. I'm going to pause it over here. Hang on so I can just focus on you guys. I want to read what you guys are talking about over here. Defense never has anything. She really went to DB law school. I thought this would go most of the day. I did too. I thought this was going to be an all day thing. I thought they were going to really get her on the stand. So, because they had the opportunity. I think they could have recalled her, right? Do you think they were expecting to see what the other witnesses said, or they were focusing in on the other witnesses? And then they were like, well, if we need to, we can pull her back up on the stand. Aren't they allowed to do that? I just stayed at a Holiday Inn last night, and I did eat my Wheaties this morning. But I'm not an attorney. I just play one on TV. What in the heyday is going on? Scott, what are you doing? I thought you were supposed to be at work. I saw another defense attorney predicted she would do that because she has no defense. Oh. It's over, Casey said. Yeah, I don't know, guys. What do you think the jury's thinking right now? They could not get into his video. Okay, so there was a bunch of stuff that they were not allowed to bring in. Number one, yesterday they discussed the journal. I'm uploading a video on that this afternoon. And that was yesterday. And his journal was very damning. There was some information about him and a bird and the things that he had done to that bird. And they said, nope, you can't bring any of that in. So I'm thinking that when it comes to the videos of him, those were also couldn't be brought. I don't know why they wouldn't be able to, though. Yeah, the prosecution, the first time in this trial, and it's been a week and a day, I guess. And this is the first time I've seen them scramble like that. Okay, that's what I thought, Numfundo. They could call her back in a rebuttal. Can they still do that right now? Or is it we're going to closing and that's it? I know. Lenny said, I think I'm just used to the clarity of DB, so this is kind of lackluster to me. No, well, when you said that, I'm like, we didn't watch a normal trial when we watched the Waukesha attack trial. So a lot of us here, I know y'all watch other stuff other than that, but I mean, for me, it's like I'm not used to the normal. I've been watching way too much of the other thing. Scott said, I'm working. I just stopped to tell y'all that. Well, thank you. Thank you, Scott. We appreciate you. Yes, they are entitled to a rebuttal case. The prosecution is they have the burden of proof. Thank you, Miss Kimmy. I know some of you guys know more about this stuff than I do, but but the state holds the burden of truth. So yes, they could be able to. Thing about it is she held her ground. Yeah, Casey, she held her ground, but she looked defensive though. I mean, she was very, of course, who wouldn't be in that position, but he caught her on a couple of things. He said something about the whole thing about saying I love you to her, to Ethan. How far did he go back? He said it was only mentioned 3 times and only one of those was towards Ethan. Laura said they had similarities, talking over each other, interrupting each other, talking down about the other, arguing over stupid stuff, the usuals. I'm just very surprised that that's all they came back at her with. I think that this morning the judge ruled out that when it came to them turning themselves in, they could not. It was just they couldn't go there, and I think I think prosecution was trying to get Shannon on twisted on that. I don't know. I've got something over here. Hang on. I was gonna play for you guys. I guess I turned it off. I was going to play a video for you guys about. Let's watch this one. If I can get it to play. Because I kind of want to go back to, since they were talking so much yesterday about them on the run.
now they have no leads on their whereabouts.
Sorry, I didn't
Larry
realize we
Spruill.
didn't have sound. I apologize.
It doesn't.
Thank you for letting me know
Parents
that.
of the suspect in the Oxford high school shooting remain on the run.
It doesn't really surprise me that they won't stand up and follow the court order and turn themselves in.
As we come to you with Local 4 News at 11, it has now been 7 hours since James and Jennifer Crumbley were supposed to face a judge.
Tonight, the U.S. Marshals, the FBI, as well as the Oakland County Sheriff's fugitive team are all searching for them. This all started around noon with prosecutor Karen McDonald announcing 4 counts of involuntary manslaughter against the parents. When the Crumbleys could not be found, a statewide be on the lookout alert was issued around 3 p.m.
Sources tell the Local 4 defenders they recently withdrew $4,000 from an ATM and haven't been seen since. Well, within the past hour, Sheriff Michael Bouchard went on cable news saying as of now, they have no leads on their whereabouts. Larry Spruill, live tonight at the sheriff's office. Larry, you just spoke with the Crumbleys' attorney. What did he say, or she say?
Good evening, Devin and Kimberly. She tells me that her clients are not hiding. They're not running. As a matter of fact, they are on the way back here to face those charges. She tells me that she will be right there when they do.
They are making their way back here. They will be arraigned. They will be turned in.
Attorney Shannon Smith is representing James and Jennifer Crumbley.
They are not hiding. They are not running from anywhere. They're not out on the lam. They are turning themselves in.
Smith says Thursday her office contacted prosecutor Karen McDonald's office to discuss possible arrangements, but found out about the charges just like everyone else.
Instead of letting us know what was going on and calling us back like they said they would first thing this morning, they went ahead with their press release, everything else.
Oakland County Sheriff Michael Bouchard and prosecutor Karen McDonald talked about that on Friday.
And if they're tuned in at all, they should do what they originally were supposed to do with their attorney, and that was to make themselves available for arrest.
We purposely don't reveal information about what we're doing and when we're doing it to a defense attorney on this kind of crime.
There's reports saying that you tried to reach out to them earlier and you could not get in contact with them.
I was in trial all day, and so when I got a call from the fugitive apprehension team, I said, I'm texting them and I haven't heard from them yet. I had just started texting them. I was in trial all morning. That had nothing to do with them being elusive or evasive. It's just the way life went. They are going to be turned in. They are going to be arraigned. They are going to face their charges. They are not hiding from anyone.
And again, the attorney tells me they are not running or hiding. She says they left shortly after the shooting because things were just too horrific and terrifying. We are live at the Oakland County Sheriff's Office tonight. Larry Spruill, Local 4.
Larry, I understand the attorney says they'll be back. Did she give you any sort of timeline here?
And so, Kimberly, I asked her that very question multiple times to try to get some kind of answer. I asked her, where did they go? When will they be back? She tells me that they simply went out of town. She would not tell me where. And she also says she is not sure when they will be back, but when they do, they will turn themselves in, and then the arraignment will happen shortly after that.
Okay, let's watch this one again.
Prosecutors say early on they raised concern that trying James and Jennifer Crumbley together would pose a conflict, and we now know at least some of that has to do with 2 people in Florida. Couple once lived.
I think they're both just as culpable. They both played their roles in different ways.
Many parents of Oxford high school students believe Jennifer and James Crumbley sharing the blame of their son's massacre. And now the husband and wife want separate trials, 2 years after the couple and their attorneys declared that they wanted to share counsel.
At this time, there is not a conflict. We have addressed if a potential conflict, how that could arise. We don't anticipate that's going to happen.
Ms. Crumbley, and knowing all that, do you still want to proceed today with these attorneys?
Yes, Your Honor.
Mr. Crumbley, do you want to still proceed today with these attorneys?
Yes, Your Honor.
Okay.
It was predictable. It was so predictable that one of the defendants was going to throw the other under the bus, or there would be testimony that would only apply to one of the defendants.
In James Crumbley's motion for a separate trial, his attorney says they just realized there's a conflict of interest based on information recently provided by the prosecution. We get more details in the motion Jennifer Crumbley's attorney filed, in which they state that 2 weeks ago, law enforcement interviewed 2 people in Florida. And after reviewing audio of those interviews, they need to sever Jennifer Crumbley's trial from her husband's. Attorney Todd Flood represents one of the young shooting victims who survived.
There was inevitably going to be a conflict, right? Of one pointing the finger at the other. Well, he did this or she did that.
In the prosecution's response to the motion for a separate trial, they agree with the defense that there is a conflict, but deny that it's anything new. Prosecutors say Jennifer Crumbley is entitled to a separate trial because some of the evidence pertaining to her husband will be damaging to her and vice versa.
I feel that both of them were on board with purchasing him the gun. Maybe the father took him there, but the mother took him to the shooting range. So it wasn't like she wasn't aware. So it's, in my eyes, they're both just as responsible.
Kimberly Craig, 7 Action News.
Okay. Well, Kimmy said, this is where I call BS. At very least, she'll get time served, which is 2 years and 100 pounds. When I first read that, Scott, I was like, I thought you meant, I was thinking, oh, he's watching from the UK. He's watching from across the pond. Now I get it. Oh, that's awful. Yes, please hit that like button, you guys. I would appreciate it. It's the algorithm is killing me in this trial. It is a very difficult case to prove as the crime is a matter of opinion. I find her guilty, but can see how not all 17 jurors will. Yeah, I think so too. Kimmy says she uses her job as a lot of as an excuse as to why she hasn't done something. She never owns up to anything. Okay, I think that was a very good point because her boss got up there and he was like, no, she could have left whenever she wanted to. No, I would have totally understood. Her boss might have thrown her under the bus a little bit though, because you don't know. I mean, I'm going to be honest. There's a lot of times when I was like, well, you can only be gone from your job for so long. And if you're really into your job, as it seemed like she was, it weighs on you. You can't just call in a lot. So I don't know if I go 100% with that one. It is, yeah, Laura, you're right. Going forward, this is going to make, that's why the judge said early on that there's a big appeal going out there for this. Let me put this on so you guys can see that I've got, I want to make sure I pull up the court stream so you guys can see that I've got it up. Judge said, I know going into this, there's going to be problems afterwards. There are going to be appeals filed. And right now, what I'm thinking of is Jennifer Crumbley has ineffective counsel appeal on the table. But yeah, I think that this is going to go on for years after this is over. Barbara said a lot of states have you must prove malicious intent for criminal charges, or you can only proceed in civil court. And some of you guys weren't on here yesterday when I mentioned that I had looked up about the school and whether or not the school was ever held responsible civilly for any of their actions that day, because they did not check his backpack. They did not say he can't stay here. You need to take him home. And a judge ruled back, I think it was 2023, it was last year, March of last year, that the school cannot be sued for anything they did. When he said, if there is proof that he planned this and they saw it beforehand, then why was it not played? That goes back to what they were allowed to do in court today, or in this trial. There was a lot of stuff on Ethan that they were not allowed to bring in. See, and that's the part that I'm kind of like, what? Because Ethan, she followed him on Instagram. The mother followed him on Instagram. So I don't understand why they couldn't have shown that video. It's a landmark case. Yeah, definitely a landmark case. Right, Laura. Kimmy said I was referring to the defense attorney. What did you, I forgot what you said already. Son looks just like dad. So I wasn't paying 100% attention to this trial when it first started, or when back in December of 2021. Does anybody know when they were representing the other female lawyer that's representing James, were her and Shannon in the same firm? But they're not now. Because they said they split up their firms just over this trial. Yeah, good point, Kimmy. Scott Peterson's trial is even coming back up 20 years later on appeal. Cass thinks it's a politically inspired witch hunt. Sybil is a suit. Sybil is definitely a suit. We got a suit, Lenny. Well, I'm not saying she saw the Instagram post. I'm just saying that they made it very clear to the jury already in this trial that she was following her son on Instagram. That's how they said it, that she followed him on Instagram. I don't see how she could have seen that post that he made. If it may not have been on Instagram. It could have been on Snapchat or Facebook. We don't know. But I don't see how she could have seen that post as a mom and not jumped in and said something or done something. I think if they were going to throw dad under the bus, they would have already done it. But she kind of did a little bit. Because she said he was the one that bought him the gun. Now she did go to the shooting range with Ethan, but one thing, just I'm trying to think as a juror, they showed footage of them at the gun range together. And it was very clear that Jennifer did not know how to use the gun, and Ethan was showing her. And before they showed that clip, they also showed a clip of when the dad took him to the shooting range right after he had gotten him the gun. So it wasn't just Jennifer that was taking him to the range. And I do believe dad was the gun enthusiast. But again, in this area where they live, there's a lot of people that hunt as a recreation. So some people may view it as it wasn't a big deal of having a gun. However, the type of gun is what troubles me. It wasn't a shotgun. You know, you use a shotgun to go out and hunt deer, duck, whatever, you know. Like she said, Laura said, like she stated, she didn't take her son seriously because he was always saying weird stuff. I agree, Mark. He's acting weird, so let's go buy him a gun. I agree. And they did also make it clear too, you guys, that when the gun was purchased, because of the text messages between James and Jennifer, you could tell it was very clear that James and Jennifer were not in dispute over buying him that gun. She was asking, "Did you get the gun yet?" You know, it was kind of like, it was very like, "Okay, we've decided to do this as a couple. We're going to get him a gun." So seeing those text messages was very damning. The range is controlled setting, and that's okay. If the gun wasn't locked up, that's a problem. Correct. And obviously it wasn't locked up. They had one of the first witnesses that the prosecution brought up was a gentleman who went over the guns. He was an ATF agent, and he went over and showed the guns. They showed what a gun safe is. This is something I learned for the first time. You know, when you hear safe, you think of a big safe, like a big money, something huge. A gun safe is very small, and it's just like a case that the gun sits in, but it has the code on it that you have to be able to get in. The problem is that when you buy those gun safes, the code for them is automatically set at 000. It's a 3-digit code. They saw that even though the gun was inside the case, and I still find this questionable because watching it, what I found or what I heard was that the Crumbleys never changed that code from 000 to their own number. So it's questionable as to whether or not that gun was locked up. But they showed the jury, and this is where I think they messed up. They showed the jury 3 different guns that were in the house. At least, I think it was at least 3. Hang on, I gotta clear my throat. And when I'm watching it, I'm getting confused because why aren't we just focusing in on that one gun that he used? Because he only used one gun. So I think by them bringing in the other guns and talking so much about them, it may have confused the jury a little bit. But again, the jury's gonna. I bet you money, you guys, in deliberation, there are going to be a ton of questions come back. I hope they allow us to hear what the jury questions are. Yeah, Scott says, yeah, okay. So the other thing was when you lock a gun, there's also a cable you can use to lock a gun. And it's like a bike lock almost, but it's fit for a gun. So, and I'm not trying to be condescending when I say all this, guys. I didn't know all this until I watched the trial. So, yeah, Mark said some guns are big as bank safes. Yeah, they're like, I always just pictured like the size of oh, I don't know. Give me an example. Like a little box for a gun safe. Okay. Scott says there's a lot of Ethan's words that weren't allowed to use because defense has no way to question him, which is fair, but would have proven her guilty. Okay, that makes sense. That makes sense. So Ethan, and this went on like from the very beginning of the trial, Shannon fought to try to get Ethan to come in, them to be able to bring him in for testimony. But his attorneys had already said that if you bring him in, he's going to plead the fifth. And the judge told them, I will not allow you to bring someone in who is going to get on the stand and plead the fifth. So that's the reason why. Thank you for clearing that up. A trigger lock. Is that what hey Mel, that's what it's called, a trigger lock? Barbara says if you can afford to buy a gun, you can afford to buy a safe. Well, a lot of the times they come in this safe. They're when you purchase them, it's like that's part of the deal. Or they come with a gun lock. Is that a law? That's a question for gun enthusiasts. Is that a law when you buy certain guns, they have to come with protective measurements? Lenny said, yep. Crazy KC said, yep. I know KC knows the law because she was once. What was your title, KC? You worked in the jails as you were not a Bailey. What do they call that? Hey, Melissa. Melissa said, yes, I'm right. Okay. Yes, all firearms must have a trigger lock when sold. Okay. Well, thank you guys for keeping me straight on that because I know I'm not the only one that questioned that. Trigger lock is different, but serves the same purpose. Yes, it's a law. Okay. So I guess you could, a trigger lock, you could probably get into that a lot easier than you could a gun safe. That would make sense. A gun safe literally looked like a little briefcase for the gun. That's what the ones that they showed in court anyway, that the Crumbleys had. Not all firearms, just handguns. Okay, that makes sense. But it sounds to me, and what I took away from this trial was that Ethan's gun wasn't ever locked up. I know Jennifer said it was, but then she went back and said it wasn't. So I don't know. I think it only had a, what you call it, a trigger lock. which is like a bicycle lock for his gun. I don't think his gun had an actual gun safe box for it. Yeah, I've got that. Let me show you guys where it's at on my channel so you can at least go back and look if you want to watch that part of the testimony. Because but what I was trying to do is just trim as much as I could. Because, you know, people come in, they don't want to sit through hours of pauses and, you know, questions that just aren't. You know how at the beginning they always ask everybody about their experience and everything? Sometimes you don't need to hear all that. I'm going through my, if you want to watch the coverage about the gun, this is the guy right here. This is the thumbnail. It's called Evidence Brought In During Agent's Testimony. I posted it 6 days ago. This is the ATF agent that talked about the guns. Oh, it's an hour and 41 minutes, so I probably didn't cut it down very well. but it's there. What else did I find important? The digital timeline of what went on that day too. This is a good one to watch, you guys, because this guy right here came up on the stand, but he was the forensics guy, and they went through like, it's a 39-minute video, but it was a very quick timeline that they went through. So you might want to watch that. It's this one right here. Crumbley's digital timeline. And then, of course, we did the school counselor, got the interrogation video. The only thing that they showed as far as picture-wise from the school was this one of his backpack in the bathroom. They didn't show any other footage from the school. Now, there are pictures of the Crumbley's home. And I actually, I think it's this one. Yeah. I just posted that yesterday. And this is the pictures of the hideout. Okay, I'm sorry. I just did, that was my promotion of my channel. I'll stop now. But anyway, if you're trying to find this information, it's there, and it's cut down a little bit for you guys so you can. Cable lock that goes through the barrel. The case also has holes for locks. Yeah, but I know, Barbara, but I'm not talking politics. I know this trial is so gray though, as far as getting into the politics of it, but I'm just not. I'm not going to do it. I'm going to keep it about this case. I just think, first of all, he was underage. And as parents, it's responsibility to make sure you are supervising your child. We were talking about the use of a firearm, and they weren't responsible. You're absolutely right. But again, I go back to not just that, Kimberly or Kimmy. I think it's also that the type of gun they purchased. Yes, Mark Bruiser has been very busy. He does not like all the time I've been spending over here doing this. Lenny says, you're right, Kimmy. If you bring it into your home, be the adult and do what needs to be done to protect your child, your family, and the public. It's simple. Yep. Until the child is 18, you are responsible. You're absolutely right. You're absolutely right. So I don't see them. You think, I wonder if the prosecution is going to come back in and say, we're not ready for our closing until Monday morning. No, I know, Barbara. It's just that you know, we all know that if a politician can get a hold of this trial and make it work for them, they're going to. We all know that. So no, I wasn't fussing at you, Barbara. I don't want you to think I was, honey. I hope they call Jennifer back to the stand. I hope they do too. Kimmy thinks it doesn't matter what type of gun it was. They can all kill someone, even a BB gun. Parents sometimes don't want to be held accountable. Yeah, but in the area that they're in, and I know you're over in New York. You're in a city style area. The area they're in, it's normal for you to buy a kid a BB gun when they're younger, and because you live out in like kind of country, rural, not rural. What the word? It's very like where I'm at right now. I could pull out a gun and shoot it. It's not illegal. If I could somebody call the cops and say she's shooting a gun? Could they question? I guess, but it's not. It's legal in some places to just pull out a gun because you're so much out in the country. So they're gonna kill her on the closing, but Shannon gets to. Shannon's not honestly though, guys. I just don't find her to be like. Even when she had the opportunity to bring in mic drops, she didn't. Something happened yesterday, and we were all watching it together, and it was during Jennifer's testimony. And Shannon she could have clarified something. She could have gone stronger in on it, and she didn't. And I was like, oh, she just missed that opportunity. Technically, the gun was owned by James. But it was very widely known that they purchased it for him as a Christmas present, and they got it on a Black Friday deal in November. So they bought it for him on Black Friday. And by November 30th, within a week, we saw what happened. To me, that's telling as well, you guys. It's not like he had it for a year or two before this happened. And so let me ask you guys, if the parents hadn't gone on the run like the way they were, do you think this would have gotten so far at this point? Yeah, Kimmy, early on they showed the receipts and the father had to apply for it. Ethan would not have been able to purchase it on his own without his father. But his father didn't sign off on it. I mean, if I remember correctly on the receipts, it had James's. Y'all almost want to go in and watch that video while we're waiting. Do y'all want to try to see if we can watch it? I'm going to talk amongst yourselves. I'm going to go in here and see if I can find the area where they talk about the receipts of the gun. It's right here. I'm going to turn the volume on the court on, and then I'm going to go back over here. If I hear the court come back on, then I will stop playing this, okay? We'll go back to the court.
No.
Okay. Were you able to determine whether or not she was aware they were at the range?
Yes.
And how do you know that?
I believe it was the same thing through Facebook messages. This was range fee, ammunition for 9mm, a rental of a 9mm pistol, as well as 22 caliber ammunition and targets.
In all of the videos you were able to obtain and observe, is this the first range video using a 9mm?
This is the first that I could find. Yes.
That we know of.
Yes.
Okay. All right. What are we looking at, Special Agent?
So that's James Crumbley in the white sweatshirt and gray baseball hat, and then the shooter is behind him wearing a light gray sweatshirt, dark pants, Nike shoes, and a black hat.
I take out the receipts of the guns. Oh, crap.
Ethan's parents were called into school that morning, but officials say they
Start from the
resisted
beginning.
taking him home and made no mention of any gun. Shortly after they left, their son began his rampage.
I thank you. No, I'm not sure every member of the jury does. So I'm trying to explain it to people who are not familiar with firearms.
Well, yeah, no, I understand that. Part of what you're saying might be argument, but it's a fair question that the SIG can eject more rounds quicker. You can shoot rounds quicker from the SIG.
I don't know. I don't know that that's necessarily true.
So if you just give me a couple questions.
Okay.
All right, thank you.
What
What is the difference between the SIG and a 22?
It's the size of the round is the main difference. And
Okay, the size of the actual bullet, for lack of another.
Yeah,
I know you
correct.
say round, okay.
Yes.
And why does the size matter?
The size matters because the larger the bullet, the bigger the hole.
Okay, more damage, whatever it is you're shooting.
Correct.
Okay, thank you.
So there was an administrative office inside the high school that had the computer system with this the surveillance video playing on a large monitor. I was in that room reviewing the footage as it played.
At some point, did you actually go to the home?
Yes.
Why did you do that?
Lieutenant Marsban had obtained the search warrant at that time, and I responded to assist with the search warrant.
And when you arrived, who else were, if anyone?
Multiple detectives from the Oakland County Sheriff's Office and also Lieutenant Marsban.
Did you actively take place, search the home, or were you just present?
I actively assisted in the search.
Okay. Did you recover anything in the house related to these weapons or relating a case, anything? What did you find? I don't want to put words in your mouth.
I was present for the recovery of evidence, and I also observed 2 targets on the wall in what would be the, I guess you call it the shooter's childhood bedroom, which shares a wall with his parents'
Okay.
bedroom.
Before we get to that, did you recover these 2 handguns in the house?
I was not the one who recovered them, but I was present when everything was there.
Okay.
Yes.
Were any other cases or boxes or anything related to the firearms recovered?
Yes.
Okay, I'm gonna hand you what's.
Okay, look at this, guys. Let's watch this one. This is an old. This is
By
back in
pleading guilty,
October
what this does is
22.
it spares so many families affected by this trial for Ethan Crumbley. It will now go to sentencing. But what did come out in court today, not only that guilty plea, but some more chilling details, as if there could be any more. But for the first time, we heard from the shooter, really in his own words, how he got that weapon, the murder weapon. He said in court, by way of the prosecutor, that it was his father, James Crumbley, who bought the weapon, and Ethan gave him the money. And remember, that murder weapon took the lives of 4 students.
What is your name?
Ethan Robert Crumbley.
And Mr. Crumbley, how old are you?
I'm 16 years old.
The Oxford High School shooter choosing to now plead guilty to 24 charges against him, facing life without parole.
Is it true that your actions on November the 30th, 2021 caused the deaths of Madison Baldwin, Tamir, Hannah St. Juliana, and Justin Schilling?
Yes.
These families and the thousands of others affected by the shooting in Oxford won't have to sit through his trial. And that does not mean any kind of shortened sentence as a result of the plea.
I want to be very clear. There were no plea negotiations, no plea offers, no reductions, and no sentencing agreements.
Crumbley's attorney, in so many words, says the evidence against her client too damning.
Originally, we filed a notice of insanity, and based on the conversations that we've had and the review of the discovery, we felt it appropriate to withdraw that and have him plead guilty today.
Some questions answered Monday in court during the hearing. Crumbley testifying that he had the murder weapon, a Sig Sauer handgun, and 50 rounds of ammunition in his backpack at school, while school officials questioned him about a violent drawing depicting a shooting the same day he opened fire at the school. It also came out from Crumbley that his father, James, bought the murder weapon for him.
Is it true that you asked him to buy the firearm?
Yes.
Is it true that you gave him your own money to buy the firearm?
Yes.
He had access to it whenever he wanted. So that was mind-blowing too.
Oxford High School parent Megan Gregory in court seeing the shooter for the first time in person. She says her son Keegan was able to get away from the shooter after being held hostage in the bathroom with Justin Schilling, who was shot and killed.
I'll never have a child that was the same person he was on November 29th.
She says her son watched the hearing via live stream.
He didn't want to be here. He struggles with the thought of being in the same room. I mean, he was held hostage by him for almost 6 minutes.
Ethan seemingly lacking emotion in court. He did not say much beyond one-word answers to the judge and prosecutors. His attorney says it will be clear his remorse at the next hearing.
I hope that someday he does feel that remorse. I still saw evil.
We got to learn a little bit about what life is like for the shooter through his attorney, Paulette Lofton. Still segregated from general population here at the jail in Oakland County. He only has contact with his attorney and deputies. He does have a tablet, but it is restricted. He can only talk with his attorneys on that tablet. Now, she says, Paulette Lofton, that he is taking accountability for his actions with today's guilty plea. Reporting.
You know, he wanted attention, and he definitely got it that morning. He got it from the school. He got it from his parents. But one thing that was very damning is when the school counselor came in, and the dean also, when he did his testimony, it was they threw the Crumbleys under the bus. They basically said that they didn't seem loving towards Ethan. They didn't seem like they were wanting to coddle him at all. They were just like, okay, I gotta go, like, especially Jennifer, I gotta go back to work. They were worried about getting back to work. They weren't, there was no hugs, nothing. So that's what this jury heard. I don't know. I don't think Ethan knew what being loved felt like or even wanted. I don't know. Oh, and they also, yeah. It came out in this trial that somebody had mentioned that Ethan was an oopsie baby. So that was interesting. Well, and so how much of what happens with Dad's trial is going to be affected by this trial, I wonder. I still feel like even if she's not guilty, he still has a chance to be guilty because of the fact that of the paperwork involved in it, if that makes any sense. I feel like from a public standpoint, because she was the mom, she should have known more than the dad. It's kind of a how we place our thoughts on how a mother should be versus how a father should be. And the mother should know more, that term, the mother always knows. So it just depends on the jury's frame of mind in that and how they feel about that. There's more women on the jury than there are men. Do you guys want to hear about who's on the jury? We watched it last night, but if you want to watch that video, I can pull that back up too, because I did a video on who's on the jury and a little bit about their background. Yeah, they're not the ideal parents, no, but they also they're not Timothy and Tracy Ferreter either, though. You know? Now, with this happening the way it happened, like, let's say this all plays out to where both Jennifer and James are found, or just one of them, let's just say just one of them's found guilty, right? Could past situations, past events with these youngsters going in and doing mass, I don't want to say the word, but you know what I'm talking about. Could we see lawsuits come out with them? It all depends on the statutes, right? What's the limit of when they can file charges? Statute of limitations. That's the word I'm trying to say. But when you talk about how they weren't giving them a lot of love or whatever, I see, to me it was like her personality, she's just not one of those people, and I don't think you can blame her for her personality the way she is, right? You can't blame her for having a sarcastic, that's just her personality. That's not her mothering skills. I'm just saying that's her personality, right? And I do believe that a lot of that was seen when she got up on the stand when her defense attorney was questioning her. And I think that was huge because as a juror, she was looking really, really bad just sitting over there at the defense table. And it does kind of make the way she reacts to things, it is telling. I separate that from her parenting skills. I don't know. Does anybody want to come up and chat with me? Yeah, she's got like that flat effect. You're right. It's just very flat. And the dad seemed just to go along with what Jen says. He's just kind of like whatever. But he was the one that stepped up when they were both in the interrogation room with Ethan. He was the one that stepped up and said, "Yeah, we're gonna get an attorney. We're gonna." So that surprised me that it wasn't Jennifer. And when you think about, remember Aiden Fucci trial, we followed that one too. He was the one that murdered little girl Kim. I know I'm gonna say the wrong name. In the neighborhood, remember he murdered the little girl in their neighborhood because they met up they snuck out of the house and they met up and they went into the woods. His mom, when she came in to the interrogation room with her son, she wasn't lovey-dovey with him either. She was like fussing at him. But I also think that any mother, you love your child, but any mother that walks into that, the first thing you're going to do, are you going to hug your kid after they've just done what they've done? I'm not a mom. Tell me what would you do as a mom? Laura said, "I'll only get you in trouble." Instead of a gun, purchase a car. At his age, that would be on his mind. He was 15. He couldn't drive on his own. I think there's a lot of things they could have bought other than a gun. So the money with the lawyers. Well, you heard them mention, and the prosecution mention, a GoFundMe page. Let me look it up real quick and see if there was one. It'll still be up, right? It might be closed, but it would still be up on the page, right? Let me go to GoFundMe. I'm just looking up the name Crumbley. I don't see anything. Under GoFundMe. I think they got 6,000 out cash. For their attorney. That they got out of their own bank account. Tristan Bailey, thank you, Laura. That was her name, Aiden Fucci. I didn't want to butcher her name. Lenny said if I was the mom and I walked into the interrogation room, I think I would be angry and ask what happened, but I would have hugged them and said, I love you. This is a good point, Kimmy. All mothers, good or bad, love their children, but I think the difference happens when you become more concerned with your life than that of your child. Yep. Agree. Hey, Julie, she cared more about her horses than her son. That's been out there. You know what? The media really spun that, though. The media really spun that. And in watching this trial, you guys, it wasn't, her and the horse barn didn't stand out to me as much as the way it was made to seem in the media. I do remember there being a lot of talk when they first retained their lawyers that they had gotten a lawyer for themselves, but they did not get one for Ethan. That was a big deal. Ethan had a public defender. Mm-hmm. But they retained attorneys. So, but that wasn't discussed in this trial, though. So again, just from a juror's perspective, what they're thinking, that was not brought up in this trial. But everything was so publicized. How could they not know about some of this other background stuff? How could they not have watched what went on in Ethan's trial that happened before all this? I'd love to know what the questions were to the jurors. Let me see if I can find it. I'm going to Google it. Jury selection questions. I know that a lot of the questions were revolving around guns. And whether they owned guns, how they felt about them. Oh, they did it. They did dismiss a juror. Oh, wait. Let's listen. Okay. I'm going to read you. This is from here. I'm going to just read this and I'll leave it up on the trial so that you guys can see what's going on that side. But okay, so this was dated. This is Wednesday, I think. This was January 31st. All right. Or January 24th. So they confirmed the jury on Wednesday at 2:38. There are 10 women and 7 men on the jury. I think that's key. that there's more women than men. They dismissed one juror during jury selection that went into the box and said his wife has a strong opinion about Jennifer Crumbley. She believes Crumbley should do the same amount of time as her son. He said he doesn't always agree with his wife, but going home could be an issue, and he was dismissed. Defense attorney Shannon Smith dismissed a juror, and that person was replaced by someone who is very much against. Oh, when the defense dismissed a juror, they were replaced by someone who has very much that was very much against guns for anyone. And the judge excused that person. 17 will be seated. And I think, what was it? So there's 5 alternates. This is like a Twitter feed almost of what I'm reading. Okay. I'm going to read from the bottom up, so that would help. This is long. Hang on. I'm about to sneeze. Let's watch this.
At long last, finally brought. All right, after a very long morning, Judge Matthews, in the jury selection case of Jennifer Crumbley, at long last, finally brought the first group of jurors in. Go and click on Detroit.com at the breakdown of what this jury, potential jury, looks like right now. If you took parents and grandparents of Oxford students impacted, of course, by the shooting, the first jury pool, the first 50 that are in the courtroom right now, 17 in the jury box to be questioned first. They look like the parents and grandparents of anyone from Oxford High School impacted by the shooting. Now, they're going to start asking questions of the first potential jurors around 2 p.m. I'll continue to feed. Click on Detroit.com. And when they are done for the day, I'll be live at 5 and 6.
Okay, so here's what was said in the jury selection. Judge Matthews told the attorneys that the name of the shooter will not be spoken in her courtroom. She quickly read the list of at least 80 witnesses who would be called. She did not read the shooter's name, but he was on the witness list. The first 17 were called into the jury box and asked by the judge if there's anything that would keep them from being a juror. Some said they had prepaid trips for works or vacation, and the judge excused a juror who had a prepaid trip scheduled. Jurors were asked whether they believe most police officers to be truthful and whether they have any family members who are police officers. That's kind of a common question these days, though, right? Let's see. Some of the other questions posed to potential jurors. Do you think police officers are truthful when they testify? Do you have an Oxford Strong sign in your yard? 2 people have said that they were victims of armed robberies. One juror said she doesn't like guns and knows she saw that the gun in this case was unsecured. There was a teacher up there that looked emotional. Now, there is a teacher on the jury. She said she has stage fright and watches the news, but thinks she can be impartial. I think she stayed. I think she's on the jury. She said she votes Democrat. The judge said she wasn't asked that question, and the courtroom erupted in laughter. She was asked if her child threw a ball through a neighbor's window, would she be responsible? And she answered no. Oh, wow. Think about that question, y'all. Teacher said she may not be able to afford to serve and she just started a new job. A juror asked if, since it's the first time parents have been charged, if Crumbley is found not guilty, does that send a message? And the judge said it does, and that the message being sent would be that the prosecutors did not prove their case. Did I read that right? If she's found not guilty, the judge says it just means the prosecutors did not prove their case. I'm looking for jury questions. The judge said 2 jurors were told to arrive at 9 a.m. are missing. We do not want to wait, and as far as for those 2, I will handle that later. She could enter a bench warrant for them. One juror asked to be released for upcoming travel and financial considerations, and he was replaced by a different potential juror. The judge told jurors that they know a minor killed people at Oxford High School, and he has been convicted of murder. What they want to know is how he got the gun. They won't know that until they heard the evidence, the judge told them. While questioning one of the jurors, no juror has ever been told that serving on a jury was a horrible experience. Smith spoke to some of the jurors, including one woman who said her decision would be based on the evidence and not concerns about backlash if she could Crumbley not guilty. I think that means if she could show Crumbley not guilty. She's already made her decision. I doubt they kept her. Check the courtroom. They're still on break. I think they went to lunch, y'all. Let's see. Defense attorney Shannon Smith continued to question jurors, including one who said she believes Crumbley should have been responsible for her child. He said if his child threw a baseball through someone's window, he would be responsible for it and pay for the window. He remained in the jury box. Another juror asked about being a parent and agreed to listen to the evidence before making a determination. Smith told jurors that Crumbley is sitting there because she's accused of a crime. She asked if any of them believed Crumbley is there because she's guilty. The jurors said no, and they agreed that they could see themselves finding her not guilty. See, you guys, I'm telling you, we got a wish-wash. I mean, this is going to be very interesting. Excuse me. One juror said she doesn't go to theaters or malls because of mass shootings that have happened in the past. She said it takes a lot to calm her down when she sends her children to school. And then defense attorney Jennifer Smith said after the Oxford High School shooting, she couldn't send her children to school for days. I wonder if she should have said that. But I think that juror that they just mentioned right there, she's on the jury. I'm pretty certain. One potential juror said she was almost in a school shooting about 20 years ago, but the school resource officer caught the person. She said her sister was a target. She's on the jury. I know because I remember that one. The juror said that this affected her life, but she could be fair and impartial. The defense asked to dismiss 2 jurors for cause. The first had strong knowledge of the case and was dismissed by the judge. The other juror believed that no minor should touch a gun. She said she can try to be fair. The judge asked if she would consider Crumbley guilty no matter what if her son had touched a gun, and the juror said no. Sorry, I got a scratchy throat. Okay, let me read this. The purpose of questioning jurors is to attempt to flush out who has any preconceived notions about important issues in the case. Are y'all still with me? I'm just checking on you. Oh, y'all are over there talking about other stuff. Let's see. Preconceived notion about the case. About important issues in the case. I'm glad that Judge Matthews allowed the lawyers to question the jurors themselves because it gives the lawyers a chance to present their own concerns about important issues in the case and to see how the jurors may feel about them. In this case, guns, parental responsibility, school shootings, teenagers, etc. My sister's driving me insane. Hang on. Oh, my computer's here. Guys, hang on just a second. I gotta put it on mute. I think I got a package I gotta go get up from the front door. Okay. Sorry about that. The lawyers can evaluate whether each juror individually is right for this case. Some jurors will reveal that they have biased. They have bias. I don't know how to say that properly anymore. And prejudice that cannot be overcome, and they've been dismissed for cause. And for cause challenge means just that. There is a reason that the lawyers have given a cause that they can cite. That juror couldn't or shouldn't sit, and the judge can agree or disagree. But the lawyers have other challenges too. 5 preemptory challenges. They can excuse a juror for no reason given, just the way they look or didn't look, their job, their history, etc. They do not need to be explained, and this is a strategy involved. The lawyers cannot use the juror's race, religion, gender, etc. as a basis for to excuse a juror, but they can use nearly any other reason. As jurors are excused, the new jurors will fill the empty chairs and they're subject to renewed questionings. Once there are no for cause or the parties choose to not excuse any others, they'll have their jury. Next potential juror, which I believe is now on the juror, was the parole officer of the state who said that the job will not come into play. He said he has no verdict on Crumbley because he hasn't heard the evidence. Oh, she did excuse the sister who was the target of a possible shooting. Okay. I'm going to go back and play this for you guys. Since we're so close to the end of the trial and we're waiting to see what's going to come. I'm going to play this about this video I have about the jurors because I just feel like it's so much information and it is telling. So you may have heard it last night, and if you did, I apologize. We're going to watch it again. I got to pull it up. Okay. I think right now, guys, I think they're at lunch. I'm going to play this for you guys, and I'm going to go grab something to drink because my throat is killing me. In a previous video today, I did mention a little bit about the jurors, and then I was able to find this article from the Detroit Free Press that I wanted to go over with you guys. Went over the 12 jurors and 5 alternates. You have 10 women and 7 men, most of them parents, including multiple gun owners and hunters, who will be tasked with determining whether Jennifer Crumbley is responsible for the death of 4 students killed by her son in the 2021 Oxford High School shooting. I'm actually very surprised at the information they provided, but let's go over it. Juror 1 is a white female. She works in human resources. She has 2 adult children. Her father was a hunter. She told the court that she gave up watching all the news in all forms 6 years ago and says she's pretty uninformed. Regarding her father's gun, she said, "I know my dad's guns were always locked. It was not for the children." Juror number 2, white 26-year-old married male, says he grew up in a strict Christian home. He works in sales for the mortgage industry. He took hunter safety classes when he was 16, but is not an avid hunter. His father has a gun and has a concealed carry permit. The jury said he doesn't have strong opinions on guns, he doesn't have cable TV, and he tries to stay away from social media and despises TikTok. Well, you and me both, buddy. Juror number 3, white female hairstylist, says she's familiar with the case, has no issues with guns, and can be impartial. Juror number 4, white female engineer, husband is a lawyer. Juror number 7, white male doctor who told the court, "I've seen a lot of gun violence. He owns multiple guns that he stores in a safe. He calls himself a very strong proponent of the Second Amendment and goes to shooting ranges about once a month, maybe every 2 months. He has lost 2 loved ones to suicide by a gun." Oof, horrible. Juror number 8, white male, automotive engineer with twin teenagers. He has a collector's gun that belongs to a relative who served in a war. He remembers being a kid and learning how to shoot a shotgun, though he is not into guns as an adult, beyond owning his collector's items. Juror number 9, white female, first grade teacher, married with 2 grown children and an older teenager. "I don't have guns, but I understand that it's lit," she said. Juror number 10, white male, works in vehicle logistics. He owns several guns and remembers tagging along with his dad to gun ranges when he was 10. His best friend is a police officer in a jail, and his girlfriend is a personal trainer. And he likes walks on long beaches. Oh my gosh, this is just this is a lot of information. This is a lot of information. Okay, sorry, I'm not trying to be funny. Juror number 11, single white female, no children. She has a gun for personal protection, worked 16 years as a police officer for a university. Now she handles parking tickets. Ooh, she's going to be a tough one. She's going to be a tough one. All right, juror number 12, black male, single, no children, works as a manager in sales. His father had a gun and taught him about gun safety. Juror number 13, single white male who works as a powertrain engineer. He doesn't own any guns, but went to a shooting range with his girlfriend over the last year for fun. He grew up in Nebraska. He says his engineering brain makes him a good juror, as he will be able to carefully analyze evidence as it applies to the charges. Ooh, he's an eager beaver there. Defense attorney Shannon Smith joked with him that we don't let engineers sit on juries because they typically see the world in a black and white way, but there's a lot of gray space in this case. The juror said he understood and that he could be fair. Juror number 14 is a white male parole officer who says he's fair to a fault and sees success stories in his work involving prisoners who turn their lives around. Okay, see, he's going to be lenient on her. I think he's going to be lenient on her. Okay, he's married, has 2 older teenagers, has guns at home, keeps them in a storage unit. His kids are not interested in guns. Before his 20-year career in law enforcement, he worked for the government's Medicaid and food stamp programs. Juror number 15, single white female who works as an accountant manager for rental properties, and she lives with her parents. Oh, I bet she has cats. Juror number 16, white married female with an infant son, works in billing for university students. She is originally from the Upper Peninsula and used to be a hunter. She remembers getting days off of school She remembers getting days off from school as a kid during hunting season, but she no longer hunts. Her sister was a target. Oh, now see, I would have said that she would be a good one. However, last sentence. However, it says her sister was a target of a school shooting that was stopped. So that's a hit or miss. Okay, juror 17. White female, married with 2 school-age children and works in veterinarian medicine. She said she's not a good one for Jennifer. She told the court that when I think about this case, I feel rage. She grew up with guns. Her dad hunted, and her sister is a competitive shooter, though she said her husband is very anti-guns and just doesn't want them in our house. I don't know about her. If she can be impartial. All 17 jurors will sit in on the trial. though 5 alternates will be dismissed before the jury goes into deliberations. The alternates will not be known until that happens, which is designed to make sure all jurors pay attention to the case. Another thing, too, one thing the judge said when she was up there, they were talking about, she made a comment today to the jury about them not going into the cafeteria because she doesn't want them to be approached with people. It's a very high profile case. So she's taking extra measures to make sure that they're sequestered. Let's listen to what she said earlier today because they did get a note from juror 15 that said that they may have an association with Jen's employer. Now, this is the juror that is a single white female who works as an account manager for a rental property. She lives with her parents. So she gave a note to the judge today after Jennifer's boss and coworker had testified. And it said something to the effect that she has an association with someone. Say association, but I'm to hear this, what they talked about, so you can make your own decision on that.
As long as the juror can be fair and impartial, I think. See, there's an issue.
Do you want me to ask?
I would ask only because we've had witnesses from Princeton testify. So I'd ask that we inquire into the juror.
Okay, I'm gonna read the question.
Man.
Okay, a juror says.
Your Honor, we have made a concerted effort to not say any of the places of employment or businesses for any witness, so just.
Yeah, well, someone said it though.
I believe opposing counsel did, but we've made an attempt for all of the witnesses not to identify specific places.
Your Honor, I didn't mean to identify. I didn't even realize that the prosecution, there's no order preventing the release of the name of where Mrs. Crumbley worked. I didn't violate any order.
I'm not suggesting that.
I think that saying the work location triggered number 15 to send us this note. And it sounds like she works indirectly with someone who is with Ms. Crumbley's former employer. She doesn't say that she knows anybody from there. But after the break, I'm going to bring her in and ask her. Okay?
Sounds good. Thank
She
you.
doesn't say she knows anybody, but she just. I actually am appreciative when these jurors say that I maybe know someone. I think they're doing what they're supposed to. So.
All right, guys. Well, that's it on the jury. I've got tons. Shut up, Carrie. You stop talking now. What do y'all want to do? Are we just going to sit here and wait? Mark, come up. Come on up. Who wants to come up and talk to me? Come up and give some of your feedback. I want to hear somebody else's opinion. Y'all are so funny because, like, other live streams, people are dying to come up. And y'all are just like, no, I don't want to. You going to come up, Kimmy? Now, Kimmy, we're going to keep it about the facts and we're not going to talk about the meat market or anything like that, okay? It's so funny. Crazy's got her buds in. Okay, here's the link, you guys. I'm going to let 2 people at a time come up. Y'all just be careful not to talk over each other. Might as well while we're waiting, right? Y'all hear my dog drinking water? It sounds like he's drinking it out of the toilet bowl. He's not, though. I promise he's not. All right, let's see. All right. Come on, guys. Kimmy, never have I cheated in a parking lot. Never have I ever cheated in a parking lot. She's so funny. Kimmy. There she is. Y'all watch out. Here she comes. There she is.
Hi, everybody.
Hey, Miss Kimmy. All right, let us have it. What do you think?
I'm going to.
You're going in and out.
Hold on. Let's see what's going on. Can you hear me better now? Am I?
Yeah, that's better now. Mark's trying to come up. It says his device connect. You got to add your camera or your not your camera, but you got to add your microphone. You can add them to the stream. You got to do something else, Mark. It's not taking you. Okay, go ahead, Kimmy.
Can you guys hear me?
Yes, ma'am.
I don't know. I'm torn. I'm torn. I'm kind of 50-50 on her.
Me too. And don't you think that with 10 women on the jury, there's going to be some of them that are the same way?
Yeah. I think so. I think that she
Casey says, Kimmy, behave.
Wonderful behave.
Oh, there was a hot officer up early on in the trial, and I thought about you, Kimmy. All right, so let's talk about the gun thing. Now, you are in Brooklyn. You're on mute. Why are you muted? There you go.
Yes. I'm mute. It's echoing for me.
Oh, turn your volume down over on the other side. I'll mute while you talk.
Okay. Is that better? Am I still echoing? I don't know. Okay, I think I got it. Okay, can you hear me? Carrie? You're muted.
I'm muted. Yes, I can hear you now.
Okay.
All right. What do you think about the gun thing?
The gun thing, I don't know. I feel like the gun thing, I don't know. I feel like the mom knew what was going on. She's not as innocent as she pretends.
Yeah, I agree. I mean, obviously she's going to get up there and try to be the best person that she can look like, right? But do you think what I think about her personality, the way it is, if she was heavy duty lying, we would be able to pick up on it.
I don't, it's a tough call because as a parent, she doesn't want to be in trouble for what her son did.
I mean, it opens a lot of doors. I mean, so that's that's an appeal question though. I'm just trying to think on today, like if you're on the jury, how you would feel. And if you are feeling 50-50, you would have to go with the not guilty, correct? I think Kimmy's having audio problems.
Yeah, I am. My audio is really acting. It's like echoing and it's delayed for some reason.
CB Clark says she has a paper trail back to Daddy-O for the gun relationship, but she's taking him to the firing ranges. She really muddies the water. Yeah, you're right, CB. You're right. But the water's just muddy. It's not clear. You know what I mean? Like I'm still leaning towards that. Oh, look who's here. You guys, we have Mark up. Mark, is this your first time on stream?
Yeah, can you hear me?
Yeah. This is your first time on stream with us, isn't it?
Yeah, it is.
Ah, Mr. Jokester. Let's see how you do live.
Hi, y'all. Hold on, I gotta mute the live.
Okay.
Yeah, it's the first time I've been out of jail. I mean, yeah, first time.
All right. So, what are your thoughts on Mommy Dearest?
Oh Lord, this is a tough case. I think they're going to find her not guilty. I don't think the prosecution's got enough evidence for a manslaughter charge. Plus, it would set one heck of a precedent.
Mm-hmm.
Now,
do you think they're thinking about that though? Do you think that the jury is actually worried about what it's gonna the president's? You think they're really thinking that? I guess they could be.
I do. I mean, when you look at the big picture, of parents and especially teenagers, I mean, are they thinking, oh my God, like the thing about, the question if your kid threw a rock through a window?
Mm-hmm.
I mean, there's civil cases for things like that. I don't know if this comes to the level of a criminal charge of manslaughter.
I don't know. I don't know. I agree with Mark too, because it's like I think that's why I'm 50-50, because I feel like she has I guess 50-50 for me is she has a certain level of responsibility as a parent, and they were not responsible in purchasing that gun for him.
Yeah, I've got a real problem with the fact that the parents knew that their 15-year-old was having mental issues and behavioral issues and school issues, and they go out and buy him a gun. Okay, guns I have no problem with guns. I own one. Out and accessible to some kid that has issues, that's negligence. But once again, I don't know if it rises to the, passes over the bar of, manslaughter.
All right, let me read out the charges to you guys. We've got count 1, involuntary manslaughter, a maximum of $7,500 fine and 15 years in prison for the death of 17-year-old Madison Baldwin. We have count 2, involuntary manslaughter, maximum $7,500 fine, 15 years in prison for the death of 16-year-old Tate Meyer. Count 3, involuntary manslaughter, maximum $7,500 fine, and 15 years in prison for the death of 14-year-old Hannah St. Juliana. Count 4, involuntary manslaughter, maximum $7,500, and 15 years in prison for the death of 17-year-old Justin Schilling. So you're looking at 60 years.
I guess. I'm sorry. Go ahead.
Sorry, Mark. I don't think she'll get the 60 years. If they find her guilty, I think it's a stretch. Because I think most people feel she's guilty. They're guilty as parents on the irresponsibility of it all. But I don't know.
Well, I think a lot of it depends on what the definition in Michigan is for involuntary manslaughter, and I'm not sure what it is.
I'm gonna pull that up real quick. Go ahead, keep talking. I'll pull it up while you're talking.
But I've got a feeling you're gonna find out that it has something to do with the person knowingly contributed to the cause of the death.
I can see that.
And if it,
now, yeah, if that's part of it, then I can see them finding her guilty if that's part of what the law is.
Okay, grounds for involuntary manslaughter in Michigan. It's the lowest homicide offense you could be charged with, but still carried serious legal consequences. This area of law covers killings that are accidental in nature, but were the result of negligent or criminal actions on the part of the defendant.
Yeah, see, that's where the definition, I mean, negligent in the cause of the death. I mean, how far do you stretch that back? I mean, negligent in the fact that you left a gun available for the kid to pick up. Negligent in my opinion is something like you knowingly drove a car that had no brakes.
Yeah.
Okay. You didn't murder somebody standing on the sidewalk in a premeditated fashion, but you knew you didn't have any brakes. Therefore, that negligence caused the death of that person.
But can we say it's negligence in that he was 15 at the time this happened?
Yes, he was a minor.
He was a minor, right? And the first, in my opinion, I won't say a mistake, but the first thing you did was you ignored what he was telling you. He's telling you that he sees things flying off the shelves. He's hearing voices. And he's not saying it in a joke, like as a joke, like on Monday. He's saying this frequently, very frequently. He keeps saying this, and you are, as a parent, are saying that he's messing around, and you never go to inquire or have him talk to someone to see if he really legitimately has a problem.
But she never heard him say, she claims she never heard him say that he wanted to hurt other people, only that he was depressed. I'm playing devil's advocate here.
Right.
You know what I mean?
And she's saying that, okay, but then at the same time, it's like 6 of one, half a dozen of the other, because she then says that the things that he was saying to her, she thought he was messing around. So either he said it to you or he didn't. Like, it can't be both.
Yeah. Okay, so I'm reading here in KuntzLaw.com. It says how the prosecution proves involuntary manslaughter charges. So when faced with involuntary let me reread that. When faced with involuntary manslaughter charges, the prosecution must prove all of the following conditions without a shadow of doubt. The victim died because of your actions. The actions you took were egregiously negligent, or you intended to cause the victim harm, but not necessarily kill them. You did not have lawful jurisdiction. Sorry.
You better prove that jurisdiction.
Hang on. Let me read. I was so wrong in that. It's because y'all are on here. You did not have lawful justification for taking the victim's life. There are also specific circumstances listed in Michigan law that are considered involuntary manslaughter. The purposeful killing of an unborn child. Let's see. If you administered any drugs, okay, this is interesting. If you administered any drugs, substances, medicine, or use instruments with the intent to hurt an unborn child, and if you intentionally pointed a gun at someone and accidentally fired it, resulting in injuries that result in the victim's death, you must have committed this crime without malicious intent to harm or kill the person. That's interesting. So they're using the example of if you pointed a gun at somebody and it accidentally went off.
But was it egregious? I don't know. Is the prosecution proving all of those points? I don't think so. I think the
No.
only point that they have is that the parents were negligent because they left that gun very much unattended. And as a minor, as a 15-year-old, and I understand, in rural counties and areas like that where hunting is a thing and stuff like that, they still shouldn't just have access willy-nilly. There still has to be some sort of supervision. Because in that case, so if he got mad at someone, that means that, he can just run in the house, grab the gun, and shoot the person because he was mad? No. I don't agree with that.
And that's why I'm really on the fence, because there's a lot of gray areas here. I mean, it's like it'd be different if the parents said, put the gun in your backpack, go to school, and we'll go to the range after school. Okay, now you're definitely negligent there because you sent the gun to school with them.
Right.
But in this case, I don't think they knew he had the gun. Now, on the other hand, like I said, I'm on the fence. On the other hand, they get called into the school and are presented with this drawings, where he obviously is going to do something bad with a gun, and they know he's got issues, and they take no action.
Mm-hmm.
They both leave, and she goes back to work or back to her boyfriend or whatever, and he ends up committing the crime.
What I find so disturbing is that they didn't bother to check on the gun.
Nobody looked in the backpack. Nobody looked in the backpack.
No.
But neither did the school didn't
But
either.
I mean, I'm not a gun owner, so I can't speak to the thought process. But I would like to think it's just like, it's just like me at home when I leave the house every day. One of the things I do before I leave the house is I check to make sure the stove is not on. So as a gun owner, you didn't check to make sure that the gun was secured before you all left the house, because anything can happen when you leave your house. Like if someone breaks in, it could be a lot of things. So wouldn't that be something you would check? Nobody looked for that gun to realize that he had it in his backpack. I don't understand that.
Well, where was the father when all this was going down?
He was DoorDash. He worked for DoorDash at the time, and he was there in the conference meeting with them. He went to the school with the mom and left. He came and left with her.
But when the kid left for school, were the parents both gone?
The dad dropped him off at school.
Oh, okay.
And
yeah, like I said, I don't know. This is going to be a tough one. I don't think a jury of 12 people is going to be unanimous on this.
No, I agree. I think that they're going to be having a back and forth, just like all of us in the chat and here, that we all are. It's like so many different ways to look at it and interpret the information. Because as a mom, she went in and they gave her the list of counselors for her son. Instead of her being proactive, she gave it to the husband. But this is the same man. This is where I have the problem, because this is the same man you're saying you don't trust him to get up on time. You don't trust him to mow the lawn. So why would you trust him with this, with the paperwork, or even trust him in securing a gun if you can't trust that he would get up out of the bed on time?
Yep.
Well, I think both of them are losers, but
for the
trial, I think it's going to be a hung jury.
I do too. I think she was more concerned with getting back to work. She said she had to get back to work to make phone calls. But who were you calling? Were you calling Joe Schmo so that y'all could meet in the Costco parking lot? Behind the tires? What were you doing?
Yep.
She seems so concerned about. She seemed to be saying she gave all of this, she put it all on her husband. But I feel like she's a ball buster, and she emasculated her husband.
In that same frame of thought, she also said, I have to take control. My husband's lost his job just in October. He lost his job because of COVID. So I'm having to do all this other stuff to kind of keep the household going. I cannot lose my job right now. We cannot afford for me to lose my job as well. So in her frame of mind, I think that that was also a big deal, which makes sense because she's worried about. And that's a thought of I got to take care of my family financially. You know what I mean?
And I agree, but I also, as someone who works in corporate America, I also wonder, like, when you get there and you start to feel like that, I wonder if it had anything to do, and this is just kind of, going way off topic, but did that have a lot to do with her work performance at work because you were sneaking out and making all these phone calls to get with your boy toys?
Mm-hmm.
You know what I mean? Because, like, I don't see any employer wants you saying that I have to go to school for my son, that they wouldn't give you a bit of a wide berth with regard to that. But this happened when, in 21 or 2020? 21, right?
2021.
I mean, by was it at the end of the year, like November or something like that?
Yeah,
No?
it was November 30th of 2021.
But by the time all of this is going on, we're now coming out of COVID. So companies are coming back online. So I'm not sure why she thought she would be in trouble with her job. I don't know.
And your state where you were, was it a heavy lockdown?
I'm sorry, say it again.
Were you in your state in New York? Was it a heavy lockdown area? Because I'm
We
sure
were heavy. We were like everyone. Everyone was locked down as of March 2020, right? But my job, we came back. We were given the all clear to come back to work in July of 21.
What about you, Mark? You're in Wisconsin, aren't you?
No, I'm in Virginia.
You're in a neighboring state.
Yeah, I'm in Virginia, but I lived in Wisconsin. I lived in Waukesha, actually.
Okay. Were you there during COVID?
No, I was in Virginia.
Okay. I just wonder because like I was in Florida and I know that was heavy lockdown, right? I came back to Alabama and found out that there was a lot of companies that never shut down. They never shut anything down. They were still working like normal. They had to have masks on and all, take precautions, but they never shut their businesses down.
And I guess it just depends on what type of business it is. There were some businesses here in New York, like restaurants and
movie theaters and stuff like that.
Well, movie theaters were shut down completely. The only thing that wasn't shut down completely were restaurants and grocery stores. And I would assume it was like that all across the country. I don't know. I just made that assumption. But like my job, but in terms of, I don't know what kind of work she did, but most companies, they just put business continuity into place where everybody was working from home, even social services, even the city, like we have public transit. They're back. Uh-oh, here we go.
Oh,
I guess we're done. Later, okay. I'll bring you back up later.
Okay.
Okay, bye.
Bye.
A comment on the jury instructions, and I think it was about 2 weeks ago that I emailed a set of final jury instructions that I believe both sides agreed to.
Yeah.
But I just want to briefly go over the instructions that we're doing, find out if there's any fill-ins, and then we'll have a final set of jury instructions. I'll provide these to the jury, okay? So we're gonna give 3.1, 3.2. We're taking out 3.3.
Yes, sir.
All right. 3.5.
Oh, this is going to be boring.
3.6.
Because now they're talking about jury instructions.
3.7. 3.10, 4.1, 4.3, 4.4.
Yep, that means no rebuttal, Julie. That is strange to me. Thank you so much, Mark and Kimmy, for coming up. I appreciate you guys.
We have not read the stipulations to the jury. I don't know if we plan to. On the keeper record stuff, do we need to?
The things that were the subject of stipulations have been admitted.
They've already been admitted, so I don't believe it's necessary, Judge.
I didn't know if the court wanted them on the record or.
It doesn't matter to me. Normally, it's advantageous for stipulations to be read into the record, for example, in civil cases with large amounts of exhibits. But if the exhibits that were the subject of the stipulation are admitted anyway, it's probably not necessary.
Yeah, these are just keeper of records, chain of custody. I don't think we need to.
If there's anything that was not admitted as an exhibit, there's no stipulation that doesn't admit an exhibit, right?
Correct. Let me
Actually, I'm
confirm.
not sure about that.
Okay, so anyway, 4.7, 5.2, 5.3. What about 5.8A?
I don't think that was
No.
used
Out?
at all.
Out, right?
Thank you, Judge.
Okay, 5.8A is out.
5.10 needs to be amended.
Oh, okay.
Detective Wagorowski was an opinion, or was an expert, but I don't believe there were any other experts admitted, were there?
No, the two medical examiners did not testify.
Sean and Brian, Packers and Brian are
Yes,
out.
sir.
We stipulated to their autopsy
Right.
reports.
So it's just Wagorowski, correct?
Yes, Judge.
All right. 5.11, 16.10. There's several of those as to count one, 16.10 as to count two. That's involuntary manslaughter. Instruction 16.10 as to count three. 16.10 as to count four. There's a unanimity instruction that is based on and adapted from 20.30A non-standard civil jury instructions, and the parties agree to that instruction.
Yes, sir.
Correct?
Yes, sir.
Yes.
Okay. 16.13 involuntary manslaughter, failure to perform legal duty as to count one. 16.13 as to count two. 16.13 as to count three. 16.13 as to count four. 16.15 as to count 16.15.
Just one instruction for 1615.
Say it again.
Just one instruction for
Yeah.
1615.
I was trying to see, I think there were some things added. There was a foreseeability excerpt
Yes,
that was
sir.
agreed upon.
Yes, sir.
Yes.
Yep. That's non-standard, but agreed to by both sides. 16.18, gross negligence. There's an instruction about not using the shooter's name. Maybe I should get rid of that one. 3.11, deliberations and verdict.
Yes.
3.13, which is possible penalty. 3.14, communication with the court. 3.15, exhibits. 3.16, written or electronically recorded instructions in the jury room. 3.20, single defendant, multiple counts, more than one wrongful act. 3.23, with regard to the verdict form, and then there's the verdict form that's standard, right?
Yes, sir.
We have obtained a computer that would accommodate the thumb drives that's going to be in the jury room. Anything else you can think of?
I don't think so.
Your Honor, I don't have a thumb drive with mine. I just have mine. I just have a
Okay.
hard copy.
Oh, that's good. We'll send it all in. Okay. Thank you. Anything else? We're gonna make those minor amendments. Anything else at this time?
No, Judge.
I don't think so, Judge.
Okay, so we'll be back in about, well, we're gonna take her back down, aren't they? Okay. I'm gonna take her back down, and I'm gonna ask them to bring her right back up, right? It won't take long. Okay, yeah, the jury instructions are ready. I think I'm gonna give you each copy of the jury instructions just to be sure that we've done it accurately, all right? And these will be the instructions that go in with the jury as well.
Thank you, Judge.
Okay. At the moment, after closings, I'm going to eventually instruct them. I am going to have all 17 come back Monday, right? Does that make sense to you?
I think we'll get through closings and they could start deliberating.
I'm concerned about that. Are you not concerned about that?
No, Judge.
The one up front?
Hey, there's my hometown neighbor Charles is in the house. I was eating, so I apologize. So here's my thought. They're going to do closings today. They'll close out the trial early. They'll leave early for the day. We'll go ahead and watch the closings because even if there are verdict questions, they're not going to, there's no way that they're not going to go into deliberation for several days. It's going to be mid to late next week, I think, before we get a verdict. That's just my opinion. Because I just feel like there's going to be a lot of questions, and I feel like there's going to, unless it's a no guilty. Oh, hang on, y'all. I opened a box. Opened a box of those donuts, powdered donuts, and my pit bull just realized that they're open. Okay, hang on, they're back. So now he's all up in my grill.
All right, you want me to bring the jury now?
Sure.
Yes, please.
One moment, we're just waiting, having some.
Just take 1 second to set things up, Judge.
Ms. Williams is going to print a copy of the jury instructions for you, just to be sure. Okay?
What's that?
We're going to print a set of the jury
Oh, sure.
instructions, and they can review those, just to be sure that they're.
Yeah, but even if it's a hung jury, they can't really come to that until next week, though, right? They got to go back and forth on that, right?
5.88 comes out. 3.2 comes out. Yeah. And then that witness is only one box, the other two.
Yeah, it's Mardi Gras here in Mobile, you guys. I started last weekend. I didn't go, though. I haven't been yet. I want to go, but part of me does and part of me doesn't. It's been so cold. That's what I was thinking. Mark says judges usually make them deliberate for a long time before they can call it a hung jury. So the longer it takes, then we'll know what we're leaning towards, I guess.
Just one moment, Your Honor.
Kimmy, John Bubba is not loyal to me. He's only loyal to the Brooksaholics Anonymous Club. Y'all can tell him I said that. He's hurt my feelings. All right, here they come. Oh, Noreen said she rested early because prosecutors haven't proven their case. Good point. I don't think they have either. Gonna be all for nothing.
Ms. Smith, am I correct that you rest?
Yes, thank you.
Prosecutor, any rebuttal?
No rebuttal.
Ladies and gentlemen, the evidence in this matter has been concluded, and now that we hear closings, I want to remind you that closing arguments are just that. They are how each side sees the evidence in the case. The closings themselves are not evidence. Because the prosecutor has a burden of proof, the prosecutor also has a right to rebuttal after the defendant's closing. Right? I think you're going to hear certain elements again, of the crime charged, the crimes charged, and I'm going to be giving you written jury instructions that list those, just so you know. All right? Prosecutor.
Yeah, if they lost this case, prosecution, they lost it because they didn't come back with a rebuttal. Looks like it's fixing to happen. Closings.
This is forward pretty far.
Tip that way.
You want it still facing this way?
I want it like almost in front of the witness box. Sorry. Okay, thank you. Good afternoon. We told you in jury selection it was going to be 3 weeks, and it's now been 2 weeks, so we're a little bit ahead of schedule. This is our time for our closing argument, and I'm going to spend some time going through the evidence, and I'm going to spend some time going through the elements of the crime. I want you to know that I have been watching you diligently, taking notes and listening. So what I'm not going to do is spend a lot of time repeating everything that was said from the witness stand, because I know that you all listened, and I also want you to know that I really appreciate that, and I know the court does too. I told you during jury selection that it wasn't going to be easy, and it was not easy. Listening and watching and thinking about 4 young kids being gunned down in their school is not easy. You listen to every witness, you examine the evidence, and I suspect that many of you feel the way that we do, that it's difficult. But we owe it to the victims and their families to say what really happened. And you've listened and you've done that. In our system of justice, we have different roles to play, and each role is different. There are people who think it's the prosecutor's job to convict people. I don't think that's the prosecutor's job. I think my job and our job is to present the evidence and the facts and tell you the truth. And telling the truth sometimes means showing you things none of us want to see, some of us don't agree with, some of us don't like. But I believe that that's my job. We don't pick or choose the very best things, because I believe that you should have the truth. And I believe that it's not my job, nor is it right, to sanitize what happened in that school that day. Because if we don't tell you exactly what happened, then you don't know all the facts and you don't know what the truth is. My job here, our job, that I believe we have done, is to meet our burden to prove that Jennifer Crumbley is guilty of 4 counts of involuntary. The burden is high. I told you that during jury selection, but we embrace it. And I believe that we have met that burden. It means that you had to sit and listen to a lot of very emotional things, a lot of emotional people who sometimes aren't emotional. but we're emotional for this because what happened on that day, every single person in that building had never experienced anything like that in their entire lives. And I hope to God they never do again. So you did see a lot of people, including law enforcement, become overwhelmed with the emotion of it all. That's not a show. That's just how that was. That's how it felt that day and every day after. So I want you to know that there was no picking and choosing the very best evidence to give you. There was no filtering things out that didn't help our case. I showed you everything. And I called witnesses to the stand to say things I knew you probably wouldn't like. But my job is to give you all the facts. But my job is also to prove beyond a reasonable doubt that Jennifer Crumbley is guilty. And I believe we've done that. The defense also has an important job to advocate and argue for their client. And they decide how they want to do that. And of course, the judge plays an important role. Her job is to call balls and strikes when two sides disagree, to make a ruling and then to tell you what the law is. And she's going to do that as soon as we conclude here. And then there's your job. Your job is to decide what the truth is, what really happened, what are the facts, and then take those facts and find the truth and apply the law. We're going to go over some of the evidence, but I also want to remind you that you're allowed to use your own observations and your own insight. And if there's something that you notice from the witness stand that I didn't say, you should rely on that. We can't possibly tell you every single little thing. And sometimes, ladies and gentlemen, the most important things are the things that don't get said. The most important things are the way the victim or the witness spoke, the way they answered a question. And I encourage you to rely on your own perceptions of that. I want to start out by talking to you about the elements of the crime. Involuntary manslaughter. She is charged with. This case is based on two theories. You're going to have all this in their jury room, but hopefully I'm going to explain it so well you will have no questions. These are dependent on two specific theories. One is the gross negligence in the performance of a lawful act, and that gross negligence caused death, and in doing so, the act that caused death, the defendant acted in a grossly negligent manner. The second is the gross negligence in failing to perform a legal duty. One, I have to prove that she had a legal duty to the victims. Two, she knew of the facts that gave rise to the duty. Three, she willfully neglected or refused to perform that duty, and her failure to perform it was grossly negligent to human life. And then four, the death of the victims was directly caused by defendant's failure to perform this duty. Causation. The judge is going to instruct you, maybe more than once, and I'm going to say it, that there may be more than one cause of death. And it's not enough that the defendant's acts made it possible for the death to occur. In order to find the deaths of Madison Baldwin, Tate Meir, Hannah St. Juliana, and Justin Schilling were caused by the defendant, you must find beyond a reasonable doubt that the deaths were the natural or necessary result of the defendant's actions. You heard the evidence that the defendant's son shot Madison Baldwin, Tate Meir, Hannah, and Justin. And as previously noted, there may be more than one cause of death. And defendant's acts or inactions need not be the sole cause of the harm. In order to find that the death of Madison, Tate, Hannah, and Justin was caused by the defendant, you must also find beyond a reasonable doubt that her son's act of shooting these four individuals was reasonably foreseeable. Now you look at that, all that I have to prove. And it seems a lot. It seems like it's going to take a pretty strong case to prove that. It's going to take some pretty egregious facts, some unique, egregious, incomprehensible facts. And that's what we have here. Gross negligence means more than just careless. It means willful disregard of results to others that might follow from an act or failure to act. In order to find that the defendant was grossly negligent, you have to find the following three things. One, that she knew of the danger to another. She knew there was a situation that required her to take ordinary care to avoid injuring others. And second, that she could have avoided injuring another by using ordinary care. Third, that she failed to use ordinary care to prevent injury, and to a reasonable person, it would have been apparent that the result was likely to be serious injury. I told you there are two theories. We're prosecuting and charging based on two theories. They're both based on a legal duty. What's a legal duty? In Michigan, a parent has a legal duty to exercise reasonable care to control their minor child, to prevent that child from intentionally harming others, or prevent that child from conducting themselves in a way that creates an unreasonable risk of bodily harm to others. We talked about there's two alternate theories. Both of those theories, if proven, are sufficient to establish the crime of involuntary manslaughter. It's not necessary that you all agree on which theory has been proven. And as long as you all agree that we've proved at least one of those theories beyond a reasonable doubt, you can find her guilty. I want to take you through the testimony. I'm not going to get into every single detail of each of these witnesses' testimony, because I know that you were listening and you were writing. You heard from Molly Darnell. Molly was a teacher in the school that day. She was in room 224. And she saw the firearm when it was raised, shoulder height, pointed directly at her. And what she noticed was there was no orange tip. You also heard her say that she locked eyes with Jennifer Crumbley's son as he was taking that stance. You heard her testify that she jumped to the right, thank God, just in time, because the shot in her shoulder that she sustained was only inches from her heart. The next witness you heard from was Christy Gibson Marshall, who's an assistant principal at Oxford High School. I don't think there's one of us that would disagree that Christy Gibson Marshall did the most dangerous thing she could do. And she did not follow the protocol. It's probably one of the most courageous things I've ever seen. She walked to the shooter. She saw a student on the floor. And then, when she finally came face to face with the person who had shot this student, she didn't move. She just stared at him. And he didn't shoot her. She testified that she knew him. She was his principal in middle school. And she just couldn't believe that he would do something like that, because she knew him when he was in middle school. You saw the video of that day and what happened. And he just kept going. And even after he left and she had no idea where he was going, she didn't go hide anywhere. She didn't keep herself safe. She bent down to render aid and assistance to that student. And when she rolled him over, she realized it was Tate-Near. We all know that she didn't and wasn't able to save Tate-Near. We heard from Cammie Batt, who sold the Caltech and the Derringer to James in June of 2021. She also sold the 9mm 6-hour to James with the shooter present on November 26th, the day after Thanksgiving. She testified that James came in and pointed right at the SIG and said he's had his eye on it. She walked us through the process of purchasing a firearm. She talked about the trigger lock statement provided to James upon purchase and the cable lock provided with November 2021 on that gun purchase. Next, we heard from Special Agent Brett Brandon, who's sitting right here. You heard that when he was informed about the Oxford shooting, he left so quickly that when his partner came back, his chair was still spinning. And he raced and drove up there as fast as he possibly could because it was very much his own community. You heard he went right in and he found Lieutenant Willis and he said, do you know where the gun is and do you know where it came from and do you need help? And so he was responsible for finding out where that gun came from, which he did. He was also responsible, because he chose to be, and watched the surveillance of the video and helped to prepare search warrants. And you heard him testify that as soon as he saw that surveillance video, the one thing that stuck with him is this is not an inexperienced shooter. This is a shooter that that is proficient with a firearm, knows what he's doing. Taking shots, a lot of people wouldn't. And what he did was start going to gun ranges and ask people to say, because what he was thinking was, who taught that kid to shoot? He must have been to a range, and he was right. And that's how the investigation led to where Jennifer Crumbley's son learned how to handle a firearm that eventually resulted in killing 4 students in Oxford High School. Can you go back to that? Special Agent Brandon also testified that and showed the purchase and we showed you each one of those guns. He testified that there is a distinction between a Derringer, a Caltech, and then the 9mm. And what we really heard from him was that 9mm is a much more dangerous gun. It causes more damage to whatever it hits. The bullets are a larger caliber, and it's a very dangerous weapon. He showed you what comes with every gun purchase, which is the ATF pamphlet. He read to you about the warnings. There's a reason they put it in every single gun purchase. And its sole purpose is to protect kids from gun violence deaths. He talked to you about what a trigger lock is and the trigger lock statement. He showed you the Instagram post that's unforgettable. We don't have to really argue about whose gun that was. Jennifer Crumbley told us whose gun that was. She told us when she posted on social media, it was his Christmas present, and she told you in this trial. That weapon is not just that weapon. It is the defendant's son's gun. It was gifted to him. And not only was it gifted to him, she bragged about it on social media before the shooting. Special Agent Brandon also introduced all of the surveillance and the videos of the shooting range. And you got to see with your very own eyes the training and the preparation that the shooter ultimately used to kill 4 of his classmates. We all saw that. We actually saw the last day he was practicing to kill 4 of his classmates. And there was only one person with him, ladies and gentlemen, and her name is Jennifer Crumbley. And I want you to remember that video. And I want you to remember the look on his face when that target comes back in and he looks at it and he's smiling. Special Agent Brandon also introduced the worksheet. You've seen the worksheet a lot. I bet you that worksheet's burned in your memory and I wouldn't even have to show it to you. But what Special Agent Brandon testified to and showed you is that that wasn't just a picture of any gun. It was a picture of his gun, which was the murder weapon. And he showed you the details, and we're going to talk about that later. And next, we heard from Ed Wygrowski. We now just call him Ed because he works for the Secret Service. And he testified for an entire day, and he had a lot of information. But he also really couldn't help himself from becoming emotional. And I know that you're going to remember this, but what an extraordinary thing. That's just not seen very often. He sat right there and he took you through every single action of the shooter and every single death from his memory. And he told you that he could do that because it's burned in his brain. These are seasoned law enforcement. This isn't an act. They hate showing emotion. He probably will never forgive me. Lieutenant Willis tells me all the time how much he really hates me for that.
I would object.
It's my opening. It's my closing.
To what a witness tells her all the time, that's not evidence.
Okay. I'll move on. Okay. Nobody likes doing that. Nobody likes doing that. But it tells you something about what it was like that day. And despite what anybody will tell you, it is about the shooting. There are 4 counts of involuntary manslaughter. It's very much about the shooting because the shooter learned how to shoot and was given the murder weapon by his parents. And this parent is sitting here today on trial. Okay. You'll be able to review the evidence. It was a lot. But he talked to you about what cell phone extractions are. And because of the cell phone extractions, we have a mountain of evidence that you saw. And yes, it's a lot of data. But you know what else it is? It's telling you exactly where the defendant was, who she was talking to, what she did, what she didn't do. And you can't hide from that. She tried. There's a lot of deleted messages, which are not coincidental. I don't think any of you believe that, but I'm going to tell you why they're not coincidental. He also talked to us about and showed you the messages between Jennifer Crumbley and her son. The messages between her son and his only friend. He introduced the voicemail that Jennifer Crumbley received the night before the shooting about looking up bullets. True. Pam Fine didn't tell her to call back. That's true. And she didn't call back because she didn't ask for a call back. We all know what she did do with that information. What she did do with that information is she texted her son, searching bullets. And we all know the phrases that we'll never forget. Did you show him your gun? This is the day before the shooting. Did you show him your gun? And the shooter responds, no, my God. LOL, I'm not mad. You just have to learn not to get caught. Kira Pennant testified that she knew Jennifer Crumbley. She testified about the amount of time that Jennifer Crumbley and James Crumbley spent at the barn. She testified about all the money they spent at the barn. Why is this important, ladies and gentlemen? It's not to show you that somebody's a bad person for liking horses or spending a lot of money on horses. It isn't. And it's not to say that somebody should spend every waking hour that they're not at work at home with their teenager. That's not the purpose of this evidence. The purpose of this evidence is to show you what Jennifer Crumbley cared about the most and what she was doing and where she was when her son learned to be a killer. Kira will tell you that she referred to her son as an oopsie baby and said he was weird. She rarely saw him. And that even after the one friend was taken away abruptly with no notice, they still went to the barn even at night and left him by himself. Which is absolutely normal to leave teenagers at home by themselves. Unless that teenager is showing signs of mental crisis and that teenager has lost the only person in the world that he has. And then she told us that when she got the worksheet texted to her that day by Jennifer Crumbley, she was very concerned. She was alarmed. And in fact, she said, bring him to the barn. And you also saw from the text messages that Jennifer Crumbley said he can't be alone. We know now that decision, that statement, she knew he couldn't be alone. She didn't decide to stay home with her son. That wasn't an option. She'd have to take him to the barn, where she herself testified he didn't want to go. You heard from two people who were at that meeting that day, Sean Hopkins and Nick Ejab. I'm going to tell you right now that this is not an argument that the school did everything they should have done. I'm not going to say that to you. I'm not going to tell you that I like everything they testified to. I'm not going to tell you that I think it was okay they didn't look in the backpack. I don't think it was. But this is about Jennifer Crumbley's actions. And any attempt to make it about what these two individuals did or didn't do, like it or not, who did not have any of the information that was so jarring, it's about what she knew and what she didn't say. Sean Hopkins testified that he was concerned enough that he called Jennifer Crumbley. And her first response is, can you call his dad? Eventually, he emails her both copies of the worksheet, the original worksheet and the worksheet that was scribbled on. And she eventually comes to the school. But before she comes to the school, she texts her husband, emergency. Along with, I'm very concerned. And James texts back, WTF. They're concerned. For the first time she testified ever, they're called to the school in the middle of the day, and they have that worksheet. Sean Hopkins is going to tell you that calling parents in the middle of the day and asking them to get a kid help is a pretty drastic action. And that he did in fact do that. And he gave them the list of places to call. He testified that when they entered the room, Jennifer Crumbley didn't greet her son. Jennifer Crumbley didn't hug her son. Jennifer Crumbley didn't engage with her son at all in the entire 11 minutes she was there. And we know she wasn't going to be in that school very long because she'd already told her boss she'll be back by 12 or 12:30. Doesn't leave a lot of time for the meeting at the school. It's a 20-minute drive. Sean Hopkins will tell you that what he felt mostly in that room for the shooter was compassion. He didn't want him to be alone, and he felt really bad. And he also knew mom and dad decided, no, we can't take it. We have to go to work. They said that in front of their kid. He knows very well what they do. He knows his dad works for DoorDash. He knows his mom and her ability to work flexible hours. She worked at home. But they left. She did not hug him goodbye. She did not greet, touch, or even acknowledge him. And we know now from her testimony, we know why. She was mad. she was mad at him. She did not think that he should have done that, and she thought this was a discipline thing, and she was very angry. We heard from Nick Ejek. He's the dean of students. He also testified and corroborated what Sean Hopkins told you, which is that the meeting was called. They were concerned about a mental health issue. They told mom and dad he needs services. Here's a list of the services, and Jennifer Crumbley seemed irritated by it. In fact, when she walks into the room, she doesn't sit next to her son. She goes back here and stands. And that meeting ended with her saying, "Are we done here?" They're consistent about that. Nick Ejek testified he didn't think there was any risk. I don't like what he said, and I knew he was going to say it. But it's not my job to put witnesses up here and only say things that I want them to say that helps my case. It's my job to present evidence that's the truth, because you have to know the truth. Sergeant Joseph Bryan is the first law enforcement that had contact with Jennifer Crumbley and her husband right after the shooting. And you saw the interview in the substation. And you saw the demeanor of the defendant. I want you to remember something. It wasn't even an hour. It was around an hour after the shooting took place. She's on her cell phone. She's looking to see if it's on the news, she said. We also know that there were deleted messages. We don't know when she deleted them, but we know there were messages deleted after the time of the shooting, from the time that the phones were seized later that night. He asked about the gun, and you heard what she said, what they both said. It was hidden. It was hidden. She read the text message. Oh, he said he loved me. And she reads the text message. And then she said, I texted him, I love you back. It was 49 minutes later that she texted, I love you back. And it was after she already knew that he was the shooter. She doesn't say what the text after that is. She leaves that out. The text after that is, Ethan, don't do it. She doesn't say, well, we were at the school, but he was also caught searching bullets that night, the night before. She doesn't say that, and I told him, don't worry about it, just don't get caught. She doesn't say that they had just purchased the weapon and it's not secure. What do they say? The very first time they are asked about what Jennifer Crumbley's asked, where was this gun? The very first time, what did she say? It was hidden. She does not say there was any locking mechanism at all, and neither does James. It was hidden. You're at the police station. Your son's in the next room. You know the murder weapon was the weapon you just purchased for him. And when you're asked where it was, you say it was hidden. We also heard from Andy Smith, who was Jennifer's boss. He testified she could have absolutely gone home. She works from home, and there's flexibility, that they have kids that come to work, that the meeting that she wanted to get to was not in any way mandatory. And he testified about some very bizarre communications. He testified that as soon as she left, he got a text saying, my son, the bullets are gone, the gun is gone. He must be the shooter. Oh my God. Those were deleted by Jennifer Crumbley. We don't know why. I think there's a lot of circumstantial evidence to suggest why, which is those are statements you don't want on your phone. And then, not 3 hours after her son shot and killed 4 people, and he's already in custody, and it's already clear that he is probably never, ever, ever going to be out of prison for the rest of his life. She's texting, don't judge me based on what he did. I need my job. Her explanation for that, she was in planning mode. The next witness is Amanda Holland, who testified that she came back to the work that day. She had the worksheet. Amy Smith also said she before the shooting occurred, she was down, she was sad. I feel like a failure as a parent. I feel like a failure as a parent. This is before the shooting. And she also tells Amanda about this, and she tells Amanda he can't be alone. So I'm just going to take him to the barn tonight. We can get to it a little bit later. I guess what's really hard to comprehend is how before the shooting, just based on the meeting and what she knows and the drawing, she thinks she's a failure of a parent. But she sat right here and said, after all, she doesn't really think she was a failure as a parent. And that's after she knows everything that happened. Detective Adam Stoyak executed the search warrant at the defendant's home. I want to make it really clear. Jennifer Crumbley is not being charged with involuntary manslaughter because she has a dirty house. That's absurd. And you can see pictures so we can prove that she didn't have her house cleaned. I don't care if her house is clean or not, and I don't think you do either. Those pictures are shown to you because that is where the shooter lived and it's where she lived. And you saw his 2 bedrooms. There was barely a place for him to sleep. The testimony shows he had no person in his life after that friend left. He was not in a club. He was not in sports. He wasn't working. When I see those photos, what I think is, yeah, 2 rooms that were completely filthy, dusty, covered with clothes everywhere. But then I think, what? That is where he spent 99% of his time. It's where he ate Thanksgiving dinner, just days before the shooting. The search warrant photos were also shown to you so you could understand where these guns were stored. We have a pretty good idea that the Kel-Tec and the Derringer were in what's called the gun safe. The lock was 000, but we know that they were kept there. What do we know about the safe, the Jennifer Crumbley's son's gun? We know that there was a box on the bed and the ammunition next to it. This is the box. This is the box. I'm sorry, this is the thing. He's going to show you in a minute. This is the box of the Kel-Tec, which was found with this cable lock inside of it. Where she kept the other guns? No.
I'm sorry, is that the box or the cake? Is that the box or the safe?
This is the box.
What's the box?
It was in the kitchen, in a cupboard, down
I'm sorry.
in the
But
cupboard.
the empty box was in the kitchen, right?
I don't, what exhibit
Your
number
Honor,
is that?
this is my closing argument, and I would just like to finish, please.
Sure, can you tell us what exhibit number it is?
Yes, it is 35.
Go ahead.
This was found in the kitchen. Inside is the cable lock. This was found on the end of the defendant's bed. Special Agent Brandon showed you what it's like to open this up and close it. You hear that clap? It's not an easy thing. So what this is laid out on the defendant's bed, and the bullets are right next, the box of the ammunition is right next to it, empty. The story, one of these stories that is told by Jennifer Crumbley is he must have come in there when they were sleeping, because she was in that bed all night long, and they left after her. Except that the ammunition was in the box. Taking it out and leaving the box while your parents are sleeping doesn't make a lot of sense. And it doesn't make a lot of sense that this was taken, the weapon was taken out of this case with no one hearing while they were sleeping. And you are allowed to use your own common sense. He also testified about the search warrant. He testified where this cable lock was found, and he testified where the case and the box was found, and he testified where the gun safe was found. It was not, unlike what Jennifer Crumbley alleged, stored separately from the ammunition. It was actually right next to the ammunition. In a gun safe, the other two guns with the combination 000. Sergeant Peschke arrives at the scene, doesn't know anything about the Crumbleys, doesn't know that they've already been to the substation, doesn't know that they were at the school that day. He's there and was ordered to be there to keep the house safe while they are waiting for the search warrant. And doing so, he needs to keep the defendant out of the house. She goes in the back of the car, and you saw the video. She now tells Sergeant Peschke she actually never really looked closely at that worksheet. Now that she looks at it, it might be disturbing. We know that's not the truth. The question is, why is she lying? She says that the .45 caliber gun used at the school, and he asks if it was, and tells him no, it was a 9mm. The other is a 22, I think. She said that they had a fight the night before with her son over grades. And she says, so we told him, no gun range, no phone. Those are his trigger points. Ladies and gentlemen, that phone was never taken away from her son. We know that. We know that because he had it the night before and he had it at the school. We know that because when Jennifer Crumbley was asked about it and asked, when did you take this phone away? We know that he made that video in that shed about the school shooting with his phone at 10 o'clock. The phone was never taken away. Why is she saying that? I don't know. Then she says, my biggest fear was that he turned the gun on himself. And when he asked her, do you ever keep guns in your car? Here's what she did. Shook her head. It's not what she says here today. Next, we heard from Bob Patelis, who processed the scene. And you saw those pictures, and they were hard to see. He told you that there were 32 fired cartridge casings. He collected all that evidence, took all the photographs, and recovered the murder weapon. Lieutenant Marsvan was also at the school that day, and he testified that he picked up the phone and saw the screen and saw that the last text was, Ethan, don't do it, from Mom. He executes search warrants for all of the devices and the home and sends a team, including Officer Peschke, to secure the house before the search warrant is executed, which is what they do. He testified that when he went into the house, he finally got there and he needed their phones. And he testified that Jennifer Crumbley said, no, I don't want to give you my phone. I'm not giving you my phone. She finally relents because her husband says they're going to get it either way. And then she doesn't want to give the passcode up. She doesn't want to give the phone up. But the most important thing that Lieutenant Marsman said is when he described how he had to identify the body of Hannah in Madison that day. Dave Hendrick is retired, but he's the former sergeant in charge of the fugitive apprehension team we call FAT. And his job, his only job, when he was doing that, is to find people who have felony warrants and haven't turned up. He has a lot of ways to figure that out, but he was asked to find Jennifer and James Crumbley to make sure they turn themselves in. But one of the other primary goals he has is that they turn themselves in safely. And she was given every opportunity to do that, and she did not. I want to talk to you about something. The judge is going to instruct you that you can considered flight. It's not an element to the crime. I don't have to prove that they fled. The reason we introduce this evidence is she's going to instruct you that you can use that as a sign of consciousness of guilt. What do you do if you know you've done something wrong? You can use that to show consciousness of guilt. And we're going to get to it, but I believe we have shown that beyond a reasonable doubt. He's going to tell you that the defendant with her husband immediately began to avoid detection because they're pulling cash out. They're pulling cash out of their son's bank account. They're pulling cash out of their bank account. Where's their son during this time? He's at Children's Village being arraigned with this court-appointed lawyer, where they had the opportunity to go see him, where they had the opportunity to go to that arraignment, and they did not. Because they never even went, they fled their house and went to a hotel, and then they ended up at an extended stay, and that is where they ultimately left one of the Kias, backed into a parking space. He's going to tell you that he eventually did apprehend the defendant. You've heard a lot about that. And he's going to tell you that there were hundreds of law enforcement officials on the scene when she was apprehended. Luke Kirtley, I know you will not forget him, coincidentally knew a lot about cars and coincidentally pulled into that parking lot right about the time and coincidentally had just seen the wanted poster, he called it, and with a description of the cars and a photo of the defendant. And coincidentally thought, maybe that's the car. And he watched the video where he goes around and he sees the license plate and he plays it cool and slowly walks into the building and then makes the call to 911. He describes to you how within minutes, police officers arrived and then swarms of law enforcement arrived, SWAT, the marshals, ATF, the sheriff's department, Detroit PD, all sorts of law enforcement show up immediately. He also testified that the unit where Jennifer Crumbley was actually found was very close to his, and it faced the parking lot, and the whole wall was windows, and it was on the first floor. And he's going to tell you that the whole parking lot was lit up with law enforcement, lights, sirens, all kinds of things. Next, we heard from Corporal David Shaw, and he testified that once he got there, they took a 35-pound ram to breach the door, which was right outside the unit where the defendant was found. We heard from Brian Deloche. Also, didn't love a lot of things he has to say, but you deserve to know the truth. And the truth is, like it or not, this is who Jennifer Crumbley spent her time with. And she told him that morning, the gun's in my car, and I'm afraid my son's going to do something stupid. Before the shooting, the same day. You've also learned that although their Facebook thread in general was always deleted, after the shooting, it remained, except she deleted, not unsent. Rely on your own memory about what that testimony was. Those were not unsent messages, they were deleted, and you heard Ed Wogrowski tell you that. But these were the two that were deleted. On the run again, and we're fucked. William Freer testified what was found in the building and the art studio where Jennifer Crumbley was found. You saw the photographs. You learned that there was a little over $6,000 in cash. You learned where the phones were found, and the cash, in the purse, in the plastic tub, in another plastic tub with a lid on it, feet away from where the mattress was, and there are other things where you learned all those phones were off. He also testified what else was found. Booze, orange juice, ice, and avocado, bananas, socks, blankets. And that is the room where Jennifer Crumbley was ultimately apprehended. You heard from Lieutenant Willis, who was the officer in charge. He told you what it was like in the school that day. He described the autopsy protocols that were done and how each of those kids died and where they were shot. He told you that both Justin Schilling and Madison Baldwin were shot in a contact wound, which means the gun was either very close or actually touching their head. He showed you the video of the shooting. And again, this is not to incite emotion. The video of the shooting shows Jennifer Crumbley's son taking a stance he clearly knew how to take and was trained to take. And you watched his demeanor and the calculated, cold way he proceeded through those hallways looking for people to shoot. You saw the surveillance of how he ultimately surrendered. Walked out after executing Justin Schilling, laid the gun on a wastepaper basket, made it safe, took the magazine out, and surrendered. He showed you and introduced the bank records that show you what they were doing after charges were either very soon coming and after they were announced. And he showed you an in-car video of Jennifer Crumbley and her husband, who just a few hours after the shooting embraced, kissed, whatever happens, I love you. Don't say anything to the police. One of the elements we have to prove is what a person using ordinary care would have known about whether or not there was a situation that they needed to exercise ordinary care. So the defendant's knowledge about her son matters, but it's two different stories. It's what she knew before the shooting, and it's what she said she knew after. Before the shooting, she tells Kira, my son's weird. She always refers to him as an oopsie baby. She tells Amanda Holland he's lonely. He's hearing things around the house sometimes. She says, I'm a failure as a parent. The message to her son's friend's mother, he's kind of depressed in April. She texts that. And then the messages from her son. The messages in March about he's seeing things. Things are flying off the table. Now she wants to tell you that was just a joke, but I think you really need to consider whether a 15-year-old boy is going to text, could you at least answer me or reply to my text as a joke? And we know there were no replies. There were missed calls. He called her. There were no replies. And she told us why. He was just messing around. But after the shooting, in the in-car, we hear her say, he's never been in trouble. He's never done anything. He's never done anything wrong. He's a good kid. Also in the in-car, I never even thought like he would have any mental issues. Like he never exerted any type of anger. He's never exerted anything. He's just like one of those mellow, laid-back kids. In the substation, he's never done anything. He's never done anything bad. After the shooting to Brian Lowe, she's never done anything wrong. Jennifer Crumbley has said a lot of things about that drawing and that meeting at the school. She sent the drawing to James, and Kira and Andrew, as I said before, with the call now emergency. She told Kira he couldn't be left alone. She tells Andy she needs to get him counseling, and she tells Amanda that the drawing was really scary. She agrees. After This is what she says in the substation. Nobody didn't seem worried about it, and he said that my son's more than welcome to stay at the school, or he could go home. And I really wish we had taken him home. In the in-car, she said, I didn't even look at that closely. Now that I do, when I was at the substation, I looked at it closely, which we know is not true. I looked at them closely, and they're a little disturbing. Well, they're very disturbing because look what he just fucking did. And then to Milo, she says, the school was very nonchalant, but the paper they showed me had all of the things scratched out. That's just not true. It's just not true. And you don't have to believe me because we have evidence it's not true. And you heard it. The statements about the gun are also numerous. She said, we've heard her testify the gun was in her car. We know that she's acknowledged that she drove to the gun range. There was no lock on the gun when she drove there. She returned with the gun. There was no lock on it, but she said James locked the gun when he got home. She didn't see him do it. She testifies at trial. James is responsible for the gun. In the substation, though, when asked where the gun was, hidden. In the in-car interview, James flew home and he's like, I had the gun hidden and I told him where I hid the bullets. He asked whether she kept the gun in her car. She shakes her head no. And she tells Milosh, after the next day, we had the string lock on it that came with in the case. Everything was secured, not loaded, bullets stored separately. Oh my God, oh my God, oh my God. That is not what she says in the substation. Jennifer Crumbley begins distancing herself from her own responsibility about the gun. You heard her testify that they wanted to get the gun. It was my son and my husband. My son did a lot of research on the gun. I guess when I was shopping. She doesn't say she didn't know. She doesn't say that she didn't approve. She says it really interfered with going to get Christmas trees. That was what she was upset about. And she said it's James's responsibility. However, as I've shown over and over, at the substation and in the car, it's we. It's we take him to the range. It's our hobby. We go to the gun range. That's what we do. We just got him this gun. Sitting here today, it's all James' fault. It's not us. And then, of course, the statement that we don't really have to question whose weapon it was. Jennifer Crumbley posts, Ethan and James Crumbley both got handguns this week, testing them out at the range. That's in June. The evidence really shows that the shooter owned 2 guns. But for sure, she acknowledges Mom and Sunday testing out his new Christmas present. You heard evidence that was presented that was found in the bathroom by the shooter's backpack, right before the bathroom that he exited and started shooting. I have zero help for my mental problems, and it's causing me to shoot up the fucking school. Next slide. First off, I got my gun. It's an SP 2022 Sig Sauer 9mm. The shooting is tomorrow. I have access to the gun and the ammo. I am fully committed to this. So yeah, I'm going to prison for the rest of my life, and many people have about 1 day to live. One of the things I want you to ask yourself when you go back in that room is why, after hearing that there's an active shooter situation and knowing that your son is involved, you are taking the time to delete text messages. And look at the messages that were deleted. We're on the run again. Helicopters, not sure where to, I'll message you, and we're fucked. Deletes, the gun is gone and so are the bullets. Oh my God, Andy, he's going to kill himself. He must be the shooter. Ethan did it. Those were deleted from her phone. She deletes all of the things she says about the drawing to Kira, including making sure that she still was going to get her lesson that night. This is the timeline from when in March, which you've heard a lot of testimony starting in about March, was where we first have evidence that he was struggling, he was hallucinating, he was seeing things, and he wanted her to text back and she didn't. We know that he had some incident, and he said that the mental breakdown in April. You saw text messages between James and Jennifer saying, did he say anything about last night? He woke up in our bed, he didn't know where he was. We don't know what that was about, but we certainly know that that is not evidence of somebody who is completely fine and stable. In fact, lots of messages from Jennifer Crumbley saying, I'm worried he's going to do something stupid. In April, she texts her friend that she thinks he's depressed. The Caltech and the Derringer was purchased in June. They go to the shooting range in June. They go to the shooting range in August. They go to the shooting range in September. And then in November, they buy the Sig Sauer. And we see the shooting range that Jennifer Crumbley went to with her son, testing out his new Christmas present. Here's what we learned Jennifer Crumbley did after the shooting. As soon as they took her phone, they bought burner phones in the pier at 8 o'clock the night of the shooting. They checked into a Holiday Inn Express that night in the pier. They then left and went to an extended stay in Auburn Hills, which Lieutenant Willis testified was almost across the street from a police department. Upon learning that charges were possibly coming, and the same day charges were announced, they leave that hotel and drive to Detroit. They withdrew $2,000 from a Flagstar Bank on December 2nd. They drive to Owasso, an hour away, she says, because we just didn't want anyone to recognize us, to buy replacement phones. She texts that she's on the run again. Helicopters are not sure where, I'll message you to, at 7:31 a.m. on December 2nd. She texts on December 2nd, we're fucked, at 2 o'clock. On December 3rd at 4:59 a.m., she texts, I'd rather die than go to jail. Then she withdraws $4,000 from another Flagstar on December 3rd. She checks out of the extended stay on the 3rd and drives down and arrives at Bellevue at 10:58 on December 3rd. You heard what happened. You heard her testimony. The facts do not support the story that Jennifer Crumbley told you. They just don't. There is no possible way, and Luke told you that, and so did Corporal Shaw, that you could be in that building with that many law enforcement and not know that somebody was there. And we don't even have to use that today's testimony, ladies and gentlemen, because she texted herself, I think we're caught, we're laying low. She texts that, we find out, and this is evidence we got this morning. She texts that after she's already said she took 4 Xanax and went to sleep. Now you saw that video. You saw that video. All those people for over 2 hours, they're sleeping, and even when they come into the room, they still don't even act like they get up. It's just not true. And we know it's not true because they'd already taken steps. She had hidden the phones, powered them down, separate from all the other things they had, with the cash. Jennifer Crumbley wants you to believe that if only the school had done something different, we wouldn't be here. If only the school. Well, let's talk about what she knew that no school employee knew. She knew about the text messages in March that he was about a demon, throwing bowls, clothes flying off the shelf. She knew about the March 18th incident of waking up in his parents' bedroom and like he had way too much to drink and asking why he was in their room. She knew he had previously asked for help and to go to the doctor, and she laughed at him. She knew there were multiple guns in the home. She knew her son had been gifted a gun just a few days before the shooting. She had posted it on Instagram. But apparently, it's absolutely fine for all your Instagram friends to know that you got him a Christmas present with a 9mm handgun, but it's not okay or relevant to the people sitting in that room with that drum. She knew that that gun looked identical to the one in the drawing. She knew that the gun was accessible to him. She knew it wasn't stored properly. She knew that he was proficient with the gun. She knew he had access to ammunition. And she knew that her son was upset the night before. Now, that says he was locked out. She told Amanda Holland he got locked out. She doesn't acknowledge that. She does acknowledge that he did leave the house that night because he was upset. And we all know what he did. We all know what he did. He went to that shed and recorded that video.
I object, that video did not come into evidence.
Okay, it isn't in evidence. It's
Okay.
not. You're right.
That's true. Let's go back to the elements. Ordinary care. What ordinary care, the smallest, tragically smallest thing she could have done to prevent this? She could have stopped at home on the way back from the meeting. She goes right by her home to see where the gun was. She could have stopped on the way back to work. She could have searched the backpack. She could have asked her son where the gun was. She could have locked the ammunition. She could have locked the gun. She could have taken him home. She could have taken him to work. He could have gone with dad. He was door dashing. She could have told the school that they just gifted him a gun. She could have embraced her son. She could have said, can we talk to him for a minute alone? She could have looked at him and said, I care about you, I love you. She could have at least acknowledged he was in the room. She could have told the school about her son being in crisis previously and asking for help. Ordinary care would have included all of those things. And the tragic part about it is none of it was hard. None of it. The smallest thing, just the smallest thing, could have saved Hannah and Tate and Justin and Madison. The smallest of things. I have to prove that there's reasonable foreseeability. And that worksheet right there that Jennifer Crumbley saw just hours before the shooting is reasonable foreseeability. And we're going to show you in the next slide. That's the picture of the gun. It's not just any gun, ladies and gentlemen. It's the gun that they just gave him. Blood everywhere. That's what he wrote with ammunition. I didn't show you the picture with the blood because I don't think you need to see it again. But we know what happened in that school and in that hallway. Here's a picture with 2 bullet holes and blood coming out of the figure's head. And look at that. That is where those shots went. Those are from the shooter's gun. The thoughts won't stop. Help me. These are all of the things that were texted to Jennifer Crumbley. This was in March. But he's writing it on a piece of paper and he's showing it to her. That is foreseeability. He's telling in that drawing, this is the gun that was purchased for me. Help me. Blood everywhere. The world is dead. I know you won't ever forget the video, but if you look at the defendant's son and see that there was no emotion, none. He was only concerned in a very calm manner for finding as many people as he could to kill, and he did. My life is useless. These statements from the defendant's son are just heartbreaking. I asked my dad to take me to the doctor yesterday, but he said, just give me some pills and told me to suck it up. Like, it's at the point that I'm asking to go to the doctor. My mom laughed when I told her, but I am having bad insomnia right now. I need help. I was thinking I could call 911 so I could go to the hospital, but then my parents would be really pissed. Like, I am mentally and physically dying. Let's talk about the cable lock. Jennifer Crumbley says that the weapon was used, but it was locked in a cable lock. It came with the case. This cable lock that came is the cable lock that came in that case with the SIG. It's never been opened and it's never been used. This is the last picture that we have of that gun until we see it murder 4 kids on November 30th. And the person holding it is Jennifer Crumbley. She's the last person that we see with that gun. She's the person that said it was in her car, then she said it was in her house, it was her husband's responsibility, it wasn't hers. That's what she told you. She knew he was distraught the night before. He texted her, I love you. She told you that's never happened before. She did think it was abnormal or odd. She knew he was looking up bullets in the school. She knew he was watching violent videos. She knew he was proficient with guns. She knew he was previously in crisis. She knew his only friend that he talked to was just gone. She knew all those things. And then her own statements, ladies and gentlemen, when she took the stand. She testified that when she's looking back, she still wouldn't do one thing different. Not one. Not any of those tragically small things. Even now, she told you she wouldn't do anything different. And then she also told you that we took his gun away. You heard her say it. And then she said she doesn't think of herself a victim, but she has lost everything. You're going to hear the instructions from the judge, and you're going to take the facts and the witnesses and the evidence and use what you promised to use, which is impartial, honest assessment, and find what you believe the facts are in this case. The flight, evidence of the flight and what they did after is not an element I have to prove. But what does it show? It shows the minute this shooting became public and ended up in the paper and the media, Jennifer Crumbley started telling a story and then she ran. And she didn't run just because she was selfish, ladies and gentlemen. She ran and she started deleting text messages and she started telling a different story because she knew she had done something wrong. That's the only reason you start deleting text messages. It's the only reason that you start saying something that isn't true. It just isn't true. Jennifer Crumbley drove to Detroit with a bunch of cash and 6 cell phones powered off. You can consider that as consciousness of guilt. Everything she did from the time she found out that there was an active shooter and had a 10-minute call with her husband. They both say they went right. He called 911 right away. He did not. He talked to his wife for 10 minutes, over 10 minutes on the phone before he called 911. But the facts changed because it was an immediate attempt to misrepresent what actually happened. Why is a mother whose son just killed 4 people thinking about deleting her text messages? Why is she saying things that are not true about her son? Why does she care about her job? Why does she care about her horse lesson? Why does she care about any of these things? Because she knew she did something wrong. And she's deleting all of those things because she wants you to believe that she's somebody she's not. And you know what she's not? She is not somebody that used ordinary care to prevent what was foreseeable, reasonably foreseeable, that could have happened. Injury or death, and it did. It did. Those words on that paper helped me. She walked out of that school within 11 minutes, didn't so much even address her son. She did not give him the help that he wanted. And you can argue about the months before and the weeks before, but if you just even look at what happened that day, she walked out of that school and she knew something bad might happen. What does she do when she gets back to work? She all of a sudden texts her son, "Are you okay? You know you can talk to us." These are the actions of somebody who was worried. She was worried and she was concerned and she was panicked until after. And then it's a different story. Why? Because she knew she had done something wrong. She walked out of that school when just the smallest of things could have saved, could have helped Hannah and Tate and Madison and Justin. Just the smallest of things. And not only did she not do it, she doesn't even regret it. We have proven beyond a reasonable doubt that she is guilty of 4 counts of involuntary manslaughter. It's a rare case. It takes some really egregious facts. It takes the unthinkable. And she has done the unthinkable. And because of that, 4 kids have died. So I'm asking you to go back when you hear the law, review the evidence, and find her guilty because we have proven our verdict. Thank you.
Thank you.
Yeah, saying I wouldn't change a thing was pretty damning.
And I will, but I'm going to need to use the bathroom halfway through if I start now. Can I have like a 3-minute bathroom break literally? Do you guys want a break?
Okay. So we're going to take about a 5-minute break and then we'll do recess.
5-minute break.
Okay.
Oh
All
my
right,
God.
jury.
Y'all know she's going to talk for a freaking, the defense is going to talk for a freaking hour or 2, whatever the limit is. What is the limit? Is there like a set limit or does the judge just decide how long she gives them each time? The do's and don'ts of closing arguments. I think it's up to the judge. So they got to take her out now? I thought they were coming right back. I don't like how they argued in front of the jury either, but she did catch her though. She's saying the wrong thing. Okay, think about it. This same attorney, she tried Ethan's case. She's been involved in all of the other stuff with it. She probably, how could she remember what she should keep in and what she shouldn't keep in, for crying out loud? Defense table explains why she couldn't find anything. Look at all that paper. God, Lord. Yeah, she was in over her head. She needed help. I think that the judge is going to, I don't know. I'm kind of wondering if the judge is going to say, okay, do your closing. And then we'll do jury instructions on Monday. That wouldn't, no, surely not. Surely not. She will do jury instructions tonight. But I was trying to figure out what the judge, come here, Bruiser. Bruiser says hello to everybody, by the way, y'all. I was trying to figure out what the judge was saying about not being able to get something done today or something like that. It's a whole new meaning to belly chains. She's gonna talk for as long as they allow her to talk. How long did okay, let's look back. Okay, Bruiser, we know. Let's see how long the prosecutor took. She got up there. She went over an hour. She went about an hour 15-ish. So what does that mean? That means Shannon's gonna go. I bet she gave him an hour and a half. I bet she gave him 90 minutes. And if that's the case, then Shannon's going to talk for 90 minutes. Can we handle it? If Julie, I'm telling you, if she says anything in her closing about anything about herself, I'm going to be so mad. But I see it coming though. You're right. She's going to say something like, I've done this or we did that, or, it's going to get off point. Stick to the facts. They say that when you're doing a presentation, you will lose people after 30 minutes if you keep going on and on. You got to keep bringing something new to the table, right? And even if the jurors do sit there and they're looking at you and they seem attentive, you've lost them at that point. You can only handle so much at one time. Imagine that, just sitting there in the chair staring at her while she's giving her remarks. Kimmy's going to get booze. I need some booze. I need a beer. Somebody grab me a Miller Lite, something. She's going to be like, oh, what do you call it? I would be, if I was on the jury, I'd be sitting there like looking around because I have such bad self-diagnosed ADHD. I'd be looking at her jewelry. I'd be judging her outfit. I'd be looking at the judge. Do we think that do we think that her points were good? She did make some very good points. I did though. I know y'all said y'all thought she went a little bit too long and too much into detail, but I did like the way that she put the pictures of the witnesses in with her PowerPoint, because I do think that really helps the jury remember. And it's a, what do they call it in visual learning? It just helps, whatever. I'm so tired. I can't think straight. I'm so sorry. I stayed up late last night. I've gotten back. Do y'all remember the show Sons of Anarchy? Okay, well, I'd already watched it before, but I started watching it again 2 nights ago just to get my brain off of this trial because I've been doing so much editing of it, and I can't go to sleep because I like the show so much. So I've been binge watching it for the last 2 nights, and then I'm staying up till 2 or 3 o'clock in the morning. I know, Mark. I need you to come up here and slap me. Wake me up. Harry, it's 6:35 in the morning there in Australia. That's not what I wanted. I'm trying to get my thumbnails done while I was listening to her. Mark's like, gladly. I'll be right there to slap the heck out of you. So, are we going to have the same judge with the daddy like we did with the Farrader trial? I wonder. Because it was a different judge that did Ethan's trial, but that's a different type of case. Why do we have a different judge, y'all? Yeah, y'all need to buy me some coffee. Thank you, Craig. Thank you, Casey. I'm running low on my hazelnut Dunkin' Donuts. Y'all know I get that stuff shipped from Amazon nowadays, my coffee, because it's actually cheaper than buying it in a store right now. You like Guns of Anarchy? Yeah, that was such a good show. And now I'm back in it. I'm on season 1, watching. I'm on episode 7 right now, and I'm like, oh my god, I can't stop watching it now. It's not something I need to be. I usually go to bed listening to like Dateline or 2020, something that I've probably seen 100 times. If they didn't offer a plea, I don't think. Did they offer them a plea? Let's look. She said in her thing earlier that she did not offer. Oh, she said she didn't offer Ethan one. I'm Googling it right now. I don't see anything about it. I don't think they offered her anything. Hang on. What Jennifer said, though, earlier, you guys, about what was it? She said, I wouldn't change a thing. That was not good. That was not a good look at all. I don't ever remember anything about a plea in this case. I don't see anything about a plea. About them having separate trials, it says it isn't uncommon for judges in criminal cases that have multiple defendants to order separate trials. A judge can decide to separate the cases and the trials in the hopes that they will promote fairness for the defendants. They have a presumption of innocence until proven guilty. It's up to the judge to decide whether to separate them. Attorneys for both James and Jennifer Crumbley filed motions requesting to separate their trials on November 13th, 2021. Is that supposed to be 2022? I thought the shooting happened in 2021. After receiving new evidence from McDonald, the county prosecutor, it says that Oakland County Circuit Judge Cheryl Matthews issued 2 orders granting the motion to separate the cases that same day. Oh, you know what? Come to think about it, though, Brooks, in his Milwaukee case, he has a different judge listening to the hearing and the motions than he does actually on the trial itself. It is unclear why Jennifer Crumbley's trial was scheduled first. Whoever has the second trial has some benefit. It may be the case that after the mom's trial gets sorted away, maybe the dad tries to strike a plea deal, but it also might be the case the prosecutor has refused to do a plea deal with him. Sometimes prosecutors want to offer a plea deal even if they think they can get a conviction because it saves them resources and then it's done and provides some sort of closure for the families. But they may not want to do this on this particular trial. They're trying to set precedents because it's an historic case. Oh shit, hang on. I'm sorry. Back. She was putting lipstick on and powder in her face and everything else. She wasn't just peeing. Y'all know she wasn't. Look at her fixing her hair. Are you muted, Casey? They're going to let him take the brunt of it. Yeah, it doesn't look good when she does that, like, in front of the jury, and well, no, the jury's not in there, but in front of her, it's just not classy. She has no self-awareness of how she's portraying herself. I'm gonna go take a nap after this.
If you have just one reasonable doubt about the case, you must vote not guilty. And so this is my poster just showing beyond a reasonable doubt is guilty, but there's many, many other options. If you think it's likely, probable, possible, not likely, those are all not guilties. You have to be sure beyond a reasonable doubt. And later, as I go through my closing, I am going to tell you the reasonable doubts that the defense believes exist in this case for you to look at. The other thing I have to ask you to keep in mind is that in the jury instructions, and I think you've been told this throughout trial, the defense does not have to prove or do anything. Like Judge Matthews said, we could sit at the table and play chess the whole time, call no witnesses, cross-examine no witnesses, provide no evidence, because we have no burden to prove a thing. However, in this case, you obviously saw the defense present Mrs. Crumbley, who took the stand, so that she could give you some context beyond parts of the evidence that were confusing when the prosecutor was introducing in bits and pieces. And the problem in this case is that we can all agree everything can be seen different in two ways. First of all, when you look back in hindsight with 20/20 vision, when you look back in hindsight, it is easy to say, this could have been different, that could have been different, this would have changed. And the other circumstance, the second one that makes a huge difference, is when you get full context around the evidence that is being used. And in this case, the prosecutor has cherry-picked little bits of evidence out of mountains of evidence to put in front of you with no context to explain what they're doing. And when you get cherry-picked bits of evidence, it's easy to reach wrong conclusions. Now, during jury selection, it felt like the prosecutor was asking you questions and giving more of a campaign speech than a jury selection proceeding.
Ooh, that was bad.
And I would suggest to you that at the end of the day, the only judge, although Miss McDonald mentioned she's been a judge and was a judge several times during her jury selection, the only judge in this courtroom that matters is Judge Matthews. And the only other people whose judgment matters are the 12 of you who will collectively decide this case. The rest of us don't matter. My opinion doesn't matter. Miss McDonald's doesn't matter. The opinions of everyone in this audience doesn't matter. The media and all of the people who think they know everything behind keyboards at home commenting about what they think the evidence in this case has shown. So during this case, it's obvious real life is messy and complicated. And during this trial, I will openly admit that I'm a lawyer who messes up. I get thrown off when I'm surprised by something. I feel like I get overwhelmed when information is coming at me quickly.
See, it's about her.
I say I'm sorry a lot. Evidently, there's a TikTok channel of me saying I'm sorry through this whole trial. And all I'm saying is that I'm human. I am a human being. And so is Mrs. Crumbley. And that's what this case is about. She's not a perfect person or a perfect parent. I'm certainly not a perfect person or a perfect parent. And I'm certainly, beyond a reasonable doubt, bad with technology, which is why you're not going to see me touch that laptop. So during this trial, I have stood before you and shown you all my flaws, and I embrace them, and they are a part of what makes me human. And so has Jennifer Crumbley. She got on the stand and talked about every nook and cranny of her life, things no one else in the world knew, in her family, among her friends. And she wanted you to see the whole truth, the entire truth, and nothing but the truth on everything, where she had to show you that she has made immoral decisions to have an affair, that she has made decisions you might not make to have another person involved in the affair. Now, we didn't get too far into the details, but it was enough for you to know that Mrs. Crumbley got up there and literally stripped off her armor, let the prosecution cross-examine her, and show you what happened in her messy life. And I say that with all kindness because I'm a mess too. I saw a meme about a week ago that said, I'm trying to be a mom, trying to get exercised, stay hydrated, get enough sleep, text everyone back, and not lose my shit. And I've got to be honest, as a mom, a working mom, on most days, I'm lucky if I'm fit for human contact. I'm lucky if I've taken a true shower and didn't just grab a handful of wipes and scrub off the best I can on my way running out the door, putting on my makeup as I drive to court in my car. Because my life is not perfect and no one's is. And during this trial, you may have concluded that you don't like me, that you hate me. That's fine. I am just asking that your opinions about me as a person.
Are you kidding
and
me?
If you're one of the people who plans to make a TikTok about me, that you won't hold those opinions against Jennifer Crumbley and will judge Jennifer Crumbley's case based on the evidence about her and her family. And if you hate her or don't like her or agree with things she's done, that's okay too. You don't have to like her. You are not expected to go hang out with her when this is all over. After trial, you don't have to decide if you want to go to her house. You don't
And
have
if you
to have
do, just go to
Thanksgiving
Costco.
with her. But when you're looking at the evidence in this case, it's important to set aside your opinions of her or take your opinions of me and supplant them on Mrs. Crumbley. Now, when I took on this case pretty early on, I realized I am Jennifer Crumbley and I could be here accused and sitting in her spot very easily. Now, in my house, we don't have guns. I don't have guns, but I do have children. And actually, I have an oopsie baby, my fourth one. I did not want 4 in 4 years, but that's what I was blessed with. I say I'm abundantly blessed. And I have kids that seem to have no issues. And at the end of the day, they're good kids. They go to school. We have no discipline problems. We have arguments here and there, just like every family does. I have a son that wants to hang out with me very rarely, but I have no belief that any of my 4 children would ever harm anyone else. And while I don't have a gun, I have a large butcher block on my counter with big knives that I use when I cook, and I enjoy cooking. And at the end of the day, my kids could just as easily grab a knife without me knowing it and without me having it on my radar and walk out the door of my house and go play with their kids, the other kids on my block. Granted, they live farther down my block because I'm in the middle of nowhere. And my son could kill somebody with my butcher block knife that I would have never expected to happen. And if you saw the text messages that my husband and I exchanged on a daily basis throughout this past year and even years before, it would be so easy for me to be in her seat.
With my kids, I don't monitor assignments. I don't look at their phones. I have no reason to. My son plays a lot of video games. My son's online talking to a bunch of people as he's playing a lot of video games. Even though he has a cell phone, I don't go through it and look at his messages every day. And as he gets older, I do know he's interested in girls. If he starts receiving nude pictures of a girl on the cell phone I own but let him use and gave him for his birthday when he turned 11, should I be held accountable for receiving child pornography if a girl sexts him over some inappropriate pictures? If my son decides
Oh my God.
he's going to send some pictures back and takes a nude picture of his bits and pieces, that's a 20-year felony. Am I then responsible because he sent a picture of his penis over to some girl? So not only taking the picture, a 20-year felony, but then we've got a 7-year felony for sending it over. Can every parent really be responsible for everything their children do? Especially when it's not foreseeable. And this clearly was not foreseeable to Mrs. Crumbley, because there's no one in the world, including Mrs. Crumbley, who would have let a school shooting happen and let what happened on November 30th take place. Not only ruining the lives of so many families and victims and taking the lives of 4 young people, but also ruining her own son's life and ripping his life right from her as well. She would be the first person on the planet who would have never let that happen in a million years. So this case is a very dangerous one for parents out there. It just is. And it is one of the first of its kind. Luckily, however, this is a case where the prosecution cannot meet its burden of proof. And thankfully, it's a case where truly Mrs. Crumbley does have a defense. And this isn't just one of those stretched cases where a parent is liable for what their child has done. Now, the judge is going to tell you that you have to, if you find reasonable doubt in this case, you must find the defendant not guilty. And the law says you must have a reasonable doubt, not 3 reasonable doubts, not 5 reasonable doubts, not 10. If you have a single reasonable doubt, you must vote not guilty for Mrs. Crumbley. And when it comes to reasonable doubt, each of you can have a separate reason to have doubt in this case. You don't have to agree on what the doubt is. And for that reason, what I am going to do is show you all of the doubts that the defense believes exist.
Oh, she's just
in
now
this
starting her
matter.
defense. Closing.
Some of them may speak to one juror, some of them may speak to another, but at the end of the day, if you have just one, your vote in this case must be not guilty. So the first place the defense finds reasonable doubt is in the fact that the prosecution is so desperate to prosecute this case that they admitted a mountain of evidence that, quite frankly, was unnecessary. Now, they say to you they needed to show you, they needed to prove the manner of death. We stipulated that 4 people died. We stipulated that it was the most horrific set of facts you could ever imagine. We stipulated that what happened to Molly Darnell and Christy Gibson Marshall was horrible. But this prosecution, putting that evidence on, was designed to inflame you and make you emotional, strike your sympathy, and get you to hate Mrs. Crumbley, which, by the way, has been very effective for most of the media, most of the public, and for anyone who has seen information put out by this prosecutor in this case. A second reasonable doubt comes from the fact that we know, and the evidence in this case showed, context is key. And that was clear when Detective Wagrowski took the stand and said, you get better decisions when you have more evidence, and testified that in a former hearing, he messed up because he didn't have the video from before the one he saw. So he believed the parents arrived at the school together. And subsequently, when given more context, showing more video from further beforehand, he could see they actually arrived in different cars, met, and walked in the building together. And at the end of the day, the more context you have, the more accurate you can be. When Brian Milosh testified, another example came about where the prosecution had him testify that Mrs. Crumbley said to delete his messages, clear your cache. And I'm so thankful that the rest of the world sent me emails that I don't know how to pronounce cache, because now I do. And when Brian ended up seeing the messages before clear your cache and after clear your cache, he realized, oh, she wasn't asking me to delete messages. She wanted me to refresh my web browser to see if the Facebook had actually deactivated. And so that was proof again that when you have more context, you're more accurate. And the problem the prosecutor has in this case is they have very little context for the very little evidence they've submitted. There's also no context around some of this little bits and pieces of useless evidence, like Jennifer Crumbley saying that her son was an oopsie baby. I call my son that, so what? Does that mean I hate my son? Does that mean I would be okay if he went and killed a bunch of people and or if he committed suicide? No. Calling your child an oopsie baby was designed to try to make her look bad with no context. Having Amanda Holland come in, a coworker who's not a friend to Jennifer Crumbley and has been interviewed by law enforcement to tell you her advice on she should go have a mother Sunday with her teenager, so irrelevant when she's faced with raising toddlers every day. When I heard her advice, I thought, yeah, right. I have 3 teenagers. I almost have a 4th. And personally, not only would they rather do anything else than spend a day with me, I'd rather do anything else. And we do spend time together, but that's not their first priority when they get to pick what they're going to be doing.
This is horrible. Absolutely horrible. The worst closing statement I've ever heard.
It does not mean she loved her son any less. If she ever told a witness, my son is weird. And part of what made me realize I could be in Mrs. Crumbley's shoes is I have sent texts to my husband saying, our daughter is a psycho today. On the way to school last week, she's crying. She doesn't have people to sit with at lunch. I texted him, she's a nutcase. I don't know what to do. I don't know how to handle this. I don't have time for this. My other daughter is complaining about her lights flickering in her room. I texted my husband, this sounds like a case. The start of a case. My husband works for my office. He's actually my office manager, so he knows about the case. He went in her room and figured out in 5 minutes, it's because when she flips her blow dryer on, one of our plugs makes the lights flicker.
Oh my God.
So this ghost that you would read about in my text messages, which by the way, I did not respond to, despite the fact that it's on our 6-person group chat, would be taken out of context and make me look like I don't really care that my daughter is crazy. I also got text one day. We have no food in our house. I am absolutely starving. You are the worst mother ever. And you know what I did? I ignored it. She was mad we didn't have the right kind of chicken ramen. When we have 85, I like the number 85. When we have 4 other flavors of ramen, and there's about 100 other things she can eat. And I knew she's not going to starve to death, but taken out of context, it makes me look like a neglectful mother. But if you know all the circumstances and you know the relationship I have with my daughter, I knew it was an overdramatic, stupid point. So when you see messages from Mrs. Crumbley's son saying, will you at least call back? Those are so out of context. And when I'm driving home from court every day, I'm getting messages, will you at least call back? And I don't, because I know what they want is for me to run through the McDonald's drive-through and bring everyone a Coke. I do stop and get myself a Coke, but I am not getting a round of drinks every day for everyone. And I've realized it's easier to not answer the phone. So you can find reasonable doubt from the context that the defense did actually provide. And when Mrs. Crumbley got on the stand and explained to you her understanding of ghosts and dishes flying and laundry flying, that is evidence. And that is something that can create reasonable doubt to hear what was really going on. Even if you believe the prosecution's dates about what was going on, it's not strong evidence. It's very misleading. And I'm going to go through what it does show. There are three sets of dates involving Mrs. Crumbley, all from March of 2021. The first time is March 8th and 9th. They introduced exhibits, including text messages on the 8th, where Mrs. Crumbley starts off asking, is he home yet? Is he home yet? I don't want him to do anything stupid. I'm sure you all remember those. Then they introduced evidence on March 9th that she went to the barn that day with her husband on the 9th. Then they introduced evidence, and I will give them credit. They put together quite a case, although it's really not important, that there was a picture of the horse taken at the barn that day, that the data supports there was a picture of the horse taken at the barn that day, and that there was GPS tracking information supporting that she was at the barn that day. Okay, fine. So on March 8th and 9th, there's concern that the shooter, Mrs. Crumbley's son, is making weird comments. And on the 9th, she goes to the barn and she takes some horse pictures. That's all that shows. Pretty minimal. Next, they went to March 16th through 19th, which was broken up into a million exhibits that, quite frankly, were out of order, threw me off my game, helped create these beautiful TikToks. And I'm going to tell you what they show. Now, these ended up all being admitted as exhibits, but I'm going to go in order of what they show. There was a text thread in Exhibit 85, which if you want to look at it, you can, where Jennifer Crumbley said, I'm going to get drunk and ride my horse. This was on March 17th, St. Patrick's Day. A lot of people have a cocktail on St. Patrick's Day. That does not make her a mother that would be negligent or grossly negligent to her child. There's text messages from the day before where Mrs. Crumbley's son is saying some things about, now the house is haunted. Some weird shit just happened, now I'm scared. I got some videos, a picture of a demon. It's throwing bowls. I'm not joking, it fucked up the kitchen. I'm going outside for a while. Can you at least text back? On that day, Mrs. Crumbley didn't text back, but their own exhibit, okay, which is Exhibit 83, so the numbers do bounce around, so we go from 85 to 86 to 83, show that within an hour of the shooter making these ghost comments, she did call him. Specifically, she called him back at 7:24, and they had a 19-second phone call. If it was 19 seconds, it most likely was, I'm on my way home, we'll talk when I get home. So then the state, in order to make it seem like they've really, really got some proof here, they admitted exhibits 87, which show on the 17th on St. Patrick's Day, James was on a horse. They showed People's Exhibit 88, confirming the metadata that James was on a horse. They showed a picture, 89, of Jennifer on a horse that day. Metadata to prove she's on the horse that day. Another picture, number 91, of James on the horse, a different picture. The metadata to prove James is on the horse. A picture of Jennifer with her horse in Exhibit 93. And again, the metadata to support the picture was taken out at the barn and sent, and that these people talked about these horses. Okay, so fine. That's on the 17th of March. You're going to have access to all this evidence if you want to see it. Then they introduced exhibit number 86, which is where their son says the house is haunted. This is on the 17th. This is the day where he says, can you text back? This is the day where I already showed you the exhibit. She called him. She didn't text back, but she called him. And then they show a couple texts from a few days later on the 19th, where it's obvious from the messages, the Crumbleys had had an argument with their son the night before. He was upset to have his phone and things taken away, that Jennifer Crumbley gave him a melatonin to go to sleep. She should have only given him a half. It's in the messages, but she gave him the whole thing. And it knocked him out, and he slept in their bed that night. And when he woke up the next morning, James described him in the text messages as he woke up looking like he had way too much to drink last night, complaining about a headache. Jennifer says, well, he was really worked up and out of control, so I can see why, talking about his behavior during the fight. All I know, Jennifer says, he needs to eat, go to work hard, not complain, and he can get his stuff back. She testified that getting his stuff taken away is his trigger. It's what makes him get upset. She says, you respond and I didn't get it. James says, Jesus, yes. He said, let me ask you a question. Why am I in your room? That's when they talk about the melatonin. She says, oh my God. James says, I really thought you were giving him a Xanax last night. Jennifer says, does he seem better? No, melatonin. James says, I know. So obviously he's joking. Jennifer writes, but he hasn't had one before, so I should have only given him half. James writes, well, he's doing his school, says his head's hurt, so he took Tylenol. Jennifer asks, is he okay to work? James says, yeah. Does he remember what he did? James finally says, dude, I'm working. I'm on a demo right now. I haven't talked to him. He's doing school. And that's really the extent of the conversation. So fine. So one day they get in an argument. And I'll tell you what, those kind of arguments in a heartbeat could have me sitting in her chair.
Oh my God,
Date
Timmy.
that the state claims Mrs. Crumbley had knowledge about back from March of 2021 are exhibits 96 through 100. And 96 starts off with their son saying, I'm picking up the room. I cleaned until the clothes started flying off the wall. This stuff only happens when I'm home alone. I pick the clothes back up though. And that's the important part of those texts on the 20th. We know on that date, because the people proved it, no pun intended, but they beat a dead horse, that at 97, it's a picture of Jennifer at the barn. We've got the metadata showing Jennifer was at the barn. We've got another picture on 99 showing Jennifer was at the barn. And exhibit 100, Jennifer was at the barn. Big deal. Jennifer's at the barn. Their son is saying goofy stuff. Jennifer gave you the context. They had an Ouija board for a couple months after Christmas of 2020. He and his friend are playing with the Ouija board. They ultimately lost interest. They stopped doing it. Jennifer admitted to you one day to mess with them. She turned the power off in the house, turned the circuit off to mess with them. She mentioned a time where James pretended he was getting electrocuted. She didn't know what to do. She's screaming, trying to kick him, see if he's electrocuted. Ethan is laughing, taking a video of the whole thing. This family played together. They had fun. They did what families do. The prosecution just had zero context because they had tunnel vision that she was doing something wrong and was grossly negligent, and they were hell-bent on convincing you that was the case. So the other thing that you can find as a reasonable doubt in the case is the lack of evidence in the case as a whole. The prosecution has made very serious claims.
Thank you, Barbara.
And when
so
you
kind.
really look at it, they have very little evidence. So what they've shown to you, and I have it in these folders, are these dates in March 2021, which, by the way, are 10 months before the shooting even took place. They're before it would have, it's unreasonable to expect that things that happened in March of 2021 are an indicator that 10 months later their son's going to do something. It would be very different if every week there's something going on up until the shooting, but there's not. Because if there was, the prosecution would have brought that in and showed you every horrible thing that was happening to show you their son was being ignored, and they don't have the evidence. So what they did provide and what was admitted, this is exhibit, I believe, 423. These are all the Facebook messages between James and Jennifer. So when you look at those Facebook messages and consider, and this includes the photographs and the GPS stuff, that they're using this much compared to this much over the period between January 2021 and the shooting. This is a very little bits in time compared to the grand scheme of things.
That's her first
And
good
while
point.
the officer testified and played games with me that he's not sure this is the best evidence against mother, you better believe if they had better evidence, they'd be up here showing stronger and better evidence. This is it, ladies and gentlemen.
I will be
It's
thanking you for
obvious
this.
from the evidence in trial, and you may find it to be a reasonable doubt, that the Crumbley son was a skilled manipulator, and they didn't realize it. He's not sick. He doesn't have a mental illness. He's had no history of hallucinations. He has never shown his parents signs of mental illness. He certainly never showed signs of mental illness wanting to get a gun. No parent would purchase a weapon if they believed their child had mental illnesses. And these are people that had 2 other guns in the house for months where nothing ever happened with those guns. They had no reason to believe that somehow this third gun was the thing that was going to make the difference. The texts that the prosecution admitted as Exhibit 101 were texts between the shooter and his friend that we have not named. The extent of these text messages saying goofy things like, I told my dad to take me to the doctor. He gave me pills to suck it up. It's at the point I'm asking to go to the doctor. I'm having insomnia and paranoia. I'm calling 911. I thought about calling 911, but my parents would be pissed. I don't disagree with the prosecution that these are alarming messages. But clearly, the shooter's friend isn't that alarmed because he's not texting back. The shooter's friend knows there must be more going on because he doesn't tell Mrs. Crumbley, who is like, and he's like a second child to her. And we have no other context about these messages. And if anything, the evidence does not show that Mrs. Crumbley ever saw these messages. Now, when she sees them now, she thinks that's crazy. She'd like to know more context. But you also have to know, and And another reasonable doubt you may find in this case is created when you compare these text messages that were sent that have alarming things between Ethan and his friend to all of the messages between them, which are over 20,000. And what you would have to believe, and what I would believe, is that if the state had stronger evidence, they would have paraded it up and we would have been seeing a lot more of these. But instead, they were admitted, and you haven't heard the friend testify, you haven't heard any context about these, and all you can see, and really all the evidence shows, is that there's no reason to believe Mrs. Crumbley ever saw that.
Shannon's not dramatic at all, Lenny. What are you talking about?
I'm watching.
I've taken your advice. Now, the other evidence the state has shown are little bits and pieces from the shooter's journal that are quite alarming and disturbing. But again, Mrs. Crumbley says the information in there about my parents won't listen to me for help is not true. And there is no evidence to show she ever saw that 22-page handwritten document. She never saw the little bits of evidence that the prosecution admitted. To evaluate this case, you have to look at it from the perspective of what she knew. So the journal information and the small amount of text compared to all the text with his friend are things she didn't know about. There's also 2 times where the state says that they have proof that Mrs. Crumbley's son was showing signs of depression or being sad or lonely. All right, those come from April 29th, 2001. This is when Jennifer Crumbley emails the friend, his mother, and all she says is that her son has been acting kind of depressed. She doesn't know what's going on. She's trying to find out what's going on, but he won't really tell her much. She's trying to find out if there's an issue between the 2 boys she should be aware of. She's trying to get down to the bottom of it. If anything, she's doing what a good mom does to try to figure it out. But the worst of what she says is that he's stressed by school. I don't want to get this wrong. He's been acting kind of depressed. And she's happy to hear it's not an issue between them. Then they go on to make plans for their son. This was admitted as Exhibit 104. If you put my text up there and showed every time I told my mom that one of my kids was acting depressed or weird, I guess my favorite word is moody these days, it would look like my kids were complete lunatics. I'm actually shocked Jennifer Crumbley doesn't have more texts about her son acting like a typical teenager. And Jennifer Crumbley testified that although she said that, she didn't think it was anything she needed to run to a doctor about or anything she needed to do anything more with. And this moment passed, because if it didn't, the prosecution would have brought in all the texts that went beyond this, and there'd be more evidence. They also run in text with the same parent of the friend from Exhibit 105, the friend's mother, when Jennifer Crumbley reaches out to her saying she had no clue what they were going through with their son, and she felt really bad about it, and asked how they're all doing and that they're thinking about them, that family, a lot. And ultimately, the worst that Jennifer Crumbley says about her son is, I know my son misses him. And if you need anything at all, don't hesitate to ask. That's it. It doesn't go on with wild depressions or hallucinations or mental health issues. That's it. That's it. I'm actually shocked there's not more instances of depression or moodiness or my kid is acting weird.
The fact that there's this little evidence is shocking to me. However, it's a lack of evidence on the state's part. There's also a lack of evidence in Mrs. Crumbley saying he's depressed to really anyone else. Even after the shooting, when she's when she's talking to her friend Kira, to other people, to Brian, all she keeps saying over and over is, I wish there had been signs. I wish there had been something. He's a normal kid. There's a complete lack of evidence of mental health concerns specifically. If you want to really spend some time digging into this, you can read all the messages between James and Jennifer Crumbley, all of them, and you will find that there are not texts that go on and on that their son was exhibiting anything close to a mental health concern. And again, my text would read worse because I say things like, I think my daughter's psychotic. When Mrs. Crumbley did have to evaluate what's going on with her son, and there was something alarming happening, she relied on people who spend day in and day out with kids, people she considers to have more expertise in kids than she does, including Pam Fine, who left her a very nonchalant voicemail that you've heard, that was exhibit 115 if you want to hear it again, saying Ethan was looking up bullets in school today. It's not illegal, it's not wrong, he's not in any trouble. It's just like how teachers can't look up hops for beer. You don't need to call me back. She was relying on the representations by the school counselor, Sean Hopkins, who took the stand and has had a lot of training, hundreds of hours of training, and made it very clear this was just an issue where he needed some kind of therapy and didn't think it was necessary to suggest to the Crumbleys, go to common ground today, or serious enough that he called 911. And she relied on the assistant dean, who also has an abundance of experience Mrs. Crumbley doesn't have. And quite frankly, my kids didn't come with a handbook, and my guess is her son didn't either. And the assistant dean said the same thing in the meeting with Mr. Hopkins, that Ethan Crumbley that the son could remain in school that day, that he would probably be better off, according to Mr. Hopkins, around peers versus being alone. And that as long as they got him an appointment within 48 hours for some kind of counseling or therapist, that was sufficient. So it's absolutely not credible when a witness from the school, like Mr. Hopkins or Mr. Ejak, gets up on the stand and says, even if a kid is very sick, we cannot force them to go home. That is not true. And as parents with common sense, you should know that's not true. Because when my kids are puking, my kid's school will not let them be there. And when they have a temperature, not only can they not be there, but my children's school is always nice enough to remind me they can't be there for the next 24 hours, which means they can't be there the next day either. So reasonable doubt can be found in the fact that trained professionals told Mrs. Crumbley her son was not a risk, and Mrs. Crumbley relied upon it. This school also failed to even really look at the situation and tell her about things from the year before. They made it very clear that he was not in any kind of discipline issue, which is shocking to me and was shocking to Mrs. Crumbley, considering he's off topic looking at bullets in school. He's looking at a video in school of some kind of violent pictures. And then he draws a gun on his math paper instead of doing the math paper.
So when school officials say, okay, this is really not a big deal, all we want is a counselor within 48 hours, Mrs. Crumbley took that as a very strong sign that things were fine. And reasonable doubt can come from the fact that those 3 people at the school, Fine, EJAC, and Hopkins, are mandatory reporters by CPS who would have reported if they thought Mrs. Crumbley or Mr. Crumbley were neglecting their son. Mrs. Crumbley even commented to others about the nonchalance that was at that meeting, that it was only 12 minutes long, which surprised her, that she was disappointed they didn't take it more seriously, that she was surprised there was no disciplinary action, and she left the school actually feeling better that maybe she had overreacted when she flew over to the school. Now, the people who are trained in these areas, they didn't just say, we're not trained in these areas. They gave specific examples. They said that kids who are really a threat, they would show nervous behavior. They would show anxiety about somebody else handling their belongings. In this case, the shooter was cool as a cucumber as Mr. Ejak went down, got his backpack with the gun in it, and brought it to him. And Mr. Hopkins and Ejak said they hoped they could get him into counseling today, but ultimately said he can stay at school and we'll give you 48 hours to get it situated. All right, so the prosecution keeps harping on the fact that Mrs. Crumbley knew they had bought a gun and that the people at the school didn't. This is Oxford Community Schools. These professionals testified about how common guns are at the school, so common, and this kind of blew me away, although I live out there, that students are known to go to the gun ranges often, that girls on homecoming wearing their short little party dresses they wear to the dance take photos before the dance holding their guns, that kids go hunting on Late Start Wednesday before they go to school, and the school has to give reminders to parents for people to leave their guns at home. So this school that obviously has a strong gun culture going on, that sees a student looking at bullets, looking at a video game type thing with violence, and seeing a gun drawn on a paper, that these school officials, knowing that community, that they didn't ask if he had a gun when they carried the backpack down and did make a comment about how heavy it was, although the comment evidently was made to a different teacher, and I misunderstood and thought it had been made to the shooter. So yeah, Mr. and Mrs. Crumbley, they didn't mention the gun, but they did mention that they had been at the shooting range with their son. And this is a community that is so into guns. I can't even believe that these girls, I always look at those pictures on Facebook and think, oh my God, how short are those dresses? And these are girls showing their dresses with their guns in their hand. They know this is a gun community. Reasonable doubt can be found from the fact that the biggest concern at the time was suicide and not homicide. The worst case scenario that was presented would lead a reasonable person to believe there was a possibility of suicide, not homicide. The prosecution seemed to also carry on about the amount of money and time that Mrs. Crumbley spent on horses. Just because she spends money and time on horses doesn't mean she doesn't love her son. And the fact that they have to stretch so much can create reasonable doubt. And if you actually look at the exhibits the defense submitted, you'll see that Mrs. Crumbley said she has to get a second job to pay for the braces, which are very expensive to put on her child's teeth. She paid for her son to be a part of a bowling team. She paid for him to do other sports. She cared about her son. Just because she cared about horses and bought medication from them and had a horse hobby, that's not any different than a dad who likes golf and buys new golf clubs and has a membership to a country club and spends time there and spends money at the bar there on days they go golfing. It's not any different. To try to suggest that it shows the priorities were on horses and not their son is just garbage. This is a son who had everything he needed and all kinds of opportunities in life. A son they take camping and on vacation to Cedar Point. Not only do they take him, they take a friend with them. These are parents that clearly love their child. They're sitting there playing board games with him, spending time doing that. That's all in the Facebook pictures that were admitted. Those are submitted to you as exhibits, and you can take a look at them if you want to. Brian's testimony in this case absolutely creates reasonable doubt. When Brian Meloche testified, there's no question he was inconsistent. And I would submit to you that there was no reason law enforcement needed to interview him for 2 hours, 1 hour, and then 3 hours. But over time, the police certainly caught on to the fact that the more you ask Brian the same question over and over, and he realizes he's not giving the answer you like, he changes it. Tries to make it sound like, well, he didn't want his affair outed. From the very beginning, he told them he was having the affair with Mrs. Crumbley. That was not something that ever changed. It wasn't until the third interview when they started talking about his pension, talking about his job, that he felt pressure. He agreed with the word pressure, and he agreed with the word veiled threats, although he did take it back later, that the police wanted him to say something bad about Mrs. Crumbley. And I would submit to you that they probably did that to all of the witnesses in the case. But Brian Meloche was the one who admitted to it. And when Mr. Keast got back up there and asked him more questions, Brian got right back in line like he was supposed to and told them exactly what he knew they wanted to hear. Brian is a terrible witness. He said he had memory problems. And quite frankly, when he's testifying that he knows that the gun was in the car that day of the shooting, we all know no one thinks that's true. Mrs. Crumbley testified and explained the day the gun was in the car. Brian's just wrong. And when Brian testified that Brady was gone and he believed Brady died or committed suicide, I would submit to the jury that Brian is just an idiot and has no clue. And that the truth is, he didn't know the details about where the shooter's friend went. He just knew he went away. Wherever he got that suicide idea from, who knows? The prosecution didn't show any texts or anything to support that. But it's clear that Brian Meloche has been put on a mission, which is you're coming into court, you've got some things hanging over your head, and we want you to take a position against Mrs. Crumbley. And I would submit to you that if you read the 77-page exhibit that I got yesterday and went through in painstaking detail with you, you can see that Brian Meloche did not think of Mrs. Crumbley that way when he knew her and when he dealt with her. And he testified the only places he got new information about her that made him think differently about his answers were from law enforcement and were from the media. The media that we have talked about in this case repeatedly as being inaccurate. Brian admitted that when the prosecution asked him, and we've already talked about this, to delete his messages, when I went through the part about clear the cache, Jennifer telling him clear the cache, showed him the stuff before and after, he realized it was just to refresh the page to see if Facebook had deactivated. So Giving him little bits of information is particularly dangerous because he's not the sharpest. And that's what the prosecution did. They used him to their advantage to try to make it sound like they have this case and all these horrible statements against Mrs. Crumbley. And by the way, when they presented evidence that Mrs. Crumbley is deleting texts and keep making it sound like she selects different texts here and there, it actually sounds like Mrs. Crumbley deletes all her texts, as she testified, that when people start flooding her with text, she deletes entire threads at a time. Who knows what she's deleting? We saw her on her phone flipping through them super fast. And the texts ultimately that she deleted, the prosecution did point out 2 of them in their closing. They pointed out the texts about "we're fucked" and "we're on the run again," but they didn't mention that she deleted 2 texts that are actually very exculpatory and helpful to her. Why would she delete some of the most helpful and exculpatory things she said? Those 2 texts are on page 42 and 44 if you want to see them in the 77-page exhibit. And those 2 texts confirm, she calls it the string lock was on the gun. She means the cable lock, but she doesn't know enough about guns to say cable lock. The string lock was on the gun. And the other deleted text that the prosecution didn't mention was when she said that the weapon had been locked, the ammunition had been stored separately, and that everything was not loaded. There's no reason she would delete 2 messages that are that helpful to her. She's just a person who deletes all of her messages, as she testified to. You can find reasonable doubt that Mrs. Crumbley's state of mind is very obvious in statements she made after the shooting. Right away, she's talking about how she had no signs to believe anything would happen. At the substation interview, it's on recording, we watched it. She tells the interviewer, "I had no signs, there were no signs." Then when they have her in the car, the squad car, and she's in the back, she says to them again, "I had no signs." In her text message with Kira, which was admitted, she says there were no signs. Kira says there probably were, you just missed them. With Brian Maloche, Mrs. Crumbley says again, there were no signs. I would submit to you, this is not some master plan where Mrs. Crumbley decides she's going to suddenly say there's no signs. First of all, there's no evidence of signs Mrs. Crumbley knew about. And second, all of her immediate fast statements in a time of stress, when, right after she's had guns held to her face, walking out the front door of her house, she's saying there were no signs. You might find, and I know the prosecution takes issue with this one, but Mrs. Crumbley was actually, in fact, a hypervigilant mother. She's the kind of mother who is going to the friend's mom to chase down why he's having a moody and kind of depressed day. She's on Power Schools on the app multiple times a day, checking for missing assignments. She's emailing teachers about grades. Christy Gibson Marshall, the assistant principal, who did do one of the bravest things I've ever seen, she testified she saw the shooter's face and couldn't believe it was him. And the reason she couldn't believe it was him is because it was so unforeseeable. Mrs. Crumbley's hypervigilance also comes when you look at how she takes him for medical appointments. They're at the urgent care because some little mole on his back changed colors when she's applying sunscreen. I think of myself as a hypervigilant mother, and I've never noticed any moles on my kid's back, and I must need to go home and look. Because when I look at the actions of Mrs. Crumbley, she actually pays far more attention to that kind of thing and other things than I do. I could easily be sitting in her chair. When her son's experiencing headaches and medical issues, she's at the doctor or doing virtual visits. There's no reason to believe that's not true. With the headaches, they go through a whole process. She gets a whole x-ray done of his head. She takes him to the eye doctor to see if that's causing the issue. Ultimately, she pays and puts braces on his teeth. Then he's a bad brusher, so she's going to the extent of getting the braces off his teeth so he can get the cavities fixed, 13 cavities. I would go crazy on my kid. And she's just doing each thing she needs to do as a hypervigilant mother. And yes, a hypervigilant mother can have a drink once in a while. I'm a hypervigilant mother, and I not only have a drink once in a while, but sometimes I've been known to have 2 or 3 or maybe a bottle. Reasonable doubt can be found from the fact that Jennifer Crumbley did her best as a mother. While going to the shooting range is not her thing, she's trying to find a way to bond with her son, who has just had his best friend move away. She took him camping, took him on trips, brought the second son along like I've already talked about. She let him have pets. He has the cutest little kitten you've ever seen in these Facebook pictures. Board game nights with him. She's not neglecting him in any way. And if anything, she's going to the gun range for him, not because she enjoys it. You can tell how much she loves it when she gets up there, shoots a couple shots, and then just stands there letting him enjoy the activity he likes. And I do the same thing for my kid. He likes to go to skate parks. I would rather do anything but go to the skate park. But I sit there and watch and say, oh, that was amazing. And all I hear is, Mom, watch this. Mom, watch this. Mom, watch this. And I would rather do anything else. But Mrs. Crumbley on that day is trying her best to bond with her child and have a relationship. Showing the pictures of the messy house was just not necessary. And the prosecution explained to you they weren't trying to prove she had a messy house, but much of it was just so unnecessary that I would suggest they are trying to make her look bad. They do kind of make her look a little bit like a hoarder. But if you saw pictures of my house right now, like a snapshot in time, you'd be just as horrified. I've been so busy getting ready for this trial, ready for all the fun we've had in the court and through these last few weeks. I still have my Christmas trees up. I was complaining to my husband the other day, oh my God, we still have our Christmas trees up. This is embarrassing. And he said, hey, Shannon, we still have ceramic pumpkins up. And I realized, oh yeah, all of our fall decorations are out too. And right now I have piles of laundry all over. My kids over Christmas break put together stacks of stuff I need to take to the Salvation Army. I have donations of my own that need to go. My house right now, if they did a search warrant today, would look just as bad as Mrs. Crumbley's. And it says nothing about me parenting my child. If anything, when I come home from work, I make a deliberate decision. All right, listen, I can run around this house for 3 hours and try to get as much as I can done. Or I can sit on my couch and watch old episodes of the Kardashians with my daughter. And I believe my time is better spent hanging out with her, watching trashy TV, than cleaning up my house because I get a chance to spend time with her. And Mrs. Crumbley was the same kind of mom. She was waiting until the holidays to have more time. She said she was going to clean her son's room. I would be screaming that I would make my son clean his room, but regardless, the project coming up was going to be to get those rooms in order. But at that point in the year when the holidays are coming up and you're getting ready for all of it and going through Thanksgiving, it does get to a point where you do have boxes piling up and you're just trying to get through those last days of school to get to Christmas break. There's reasonable doubt when you look at what Mrs. Crumbley thought after the meeting with Mr. Hopkins and Mr. Ejak. The state of mind she was in and her thoughts and what she was thinking come in through her statements. She thought everything was way less of a big deal when she left that meeting. She thought leaving him in school with his friends was the better decision based on Hopkins saying peer support is a good thing. She thought making him an appointment was sufficient within 48 hours was sufficient. That doesn't even mean the appointment was going to be within 48 hours. Reasonable doubt can be seen in the video when Mrs. Crumbley first sees her son at the substation. Her reaction to seeing him in this complete state of disbelief as to what's going on is to look at him and say, why? Why? She doesn't look at him and say, I knew you were going to do this. She doesn't look at him and say, see, I knew we shouldn't have bought that gun. She says, why? Why? And when he says, take care of Dexter, she cannot believe that's her son and goes back into the other room with her husband and says, what the fuck? He didn't even care. And while the prosecution asked questions about, well, she's not sobbing, and we hear sobbing, and that's clearly James. James is sobbing. When you look at the video, if you decide you need to see it, Mrs. Crumbley is dabbing her eyes and wiping her eyes. And fine, she's not the crier some other people are. Reasonable doubts can come from the statements in the heat of the moment at the substation when Jennifer Crumbley is in a state of shock trying to answer their questions. She says, he's never done anything bad. This is after she already has somebody saying you really should have a lawyer there. She's still just talking about what the truth is. He's never done anything bad. One of the parents says he's a perfect kid. Jennifer Crumbley tells them the most of an issue he ever has is anxiety over tests. Jennifer Crumbley tells them everything was fine this morning. In the statements Jennifer Crumbley made when she was in the car and doesn't even know yet if there has been fatalities, she says he's never done anything. She acknowledges he ruined lives today. She says, it's the first time I've ever seen him do anything. She says, he's a good kid. He's never angry. He's mellow. He's not what he looks like. He's not a monster. And she's not a monster either. She explains to them in detail when they ask, he's never had mental issues. In those moments, she can't even think straight about life around her. She's worrying about a horse and her job and all kinds of random stuff. And ladies and gentlemen, when emergencies happen, life doesn't just stop. So the fact that she's able to function and think, I still need a job, I need some money, I need a phone that works, that doesn't mean she thought her son would terrorize and kill people and shoot people at a school. Her reaction when she finds out there are fatalities was genuine and honest. And she broke down crying, although she does continue to keep answering their questions. She explains why she feels like fatalities are different. She explained that on the stand. If he had shot people and injured them, it was something they could at least deal with. But a fatality is a fatality and can never be changed. The prosecution's attempt to misconstrue Jennifer's entire demeanor is a reasonable doubt in this case to show they don't have a strong case. They keep saying she's not sad. Jennifer explained she went into what can I do mode. She did show sadness if you read the texts between her and Mr. Milosh. She showed sadness in the way that she shows sadness. And for these officers to get up on the stand and say she didn't behave like the mother of a school shooter should behave is nonsense. None of them have ever dealt with the mother of a teenager who has just killed people and shot many others. There isn't a right way in any handbook to say how you should or should not behave. Trying to make her look selfish and callous goes right with that same thing. How she reacts is how she reacts. You see it on the screen. It's really hard to pass judgment, although these police officers did, on how a person should react when for the first time in their lives, they walk out of their house and are surrounded with guns in their face. Or how a person would react to be woken up in the middle of the night on a mattress with police around them and above them with guns in her face. So not only has anyone not been in the shoes of a school shooter and dealing with the kind of emotions that would come with that,
Go up to the house.
they also don't know, and there isn't a standard reaction for how you behave when you're surrounded with guns in your face. Jennifer's own statement provides reasonable doubt that she didn't think he would hurt other people. She typed to him, "Ethan, don't do it." She didn't say, "Don't shoot people." She didn't say, "Don't hurt anyone." She thought the only thing on her radar that could be possible at that point, knowing there's an open shooter and he has a weapon, was that he would kill himself. Reasonable doubt can be found in Jennifer's testimony. Jennifer's testimony is evidence. And at the end of the day, whether you believe, like, hate, however you feel about her testimony, the defense didn't have to prove anything. You still have to evaluate the prosecution's case for what it was. However, Jennifer Crumbley did take the stand, and that was not easy for her, to give you additional context about what was going on in the shreds of evidence the prosecution cherry-picked and put before you.
Somebody take those flashcards
The
away.
only person who's actually been consistent in this case, and you can find reasonable doubt from this, is Jennifer. She's consistent in what she says to police, what she says to her husband about things, and what she says to other witnesses who testified. You can find reasonable doubt in the fact that the police officers are very, very biased in this case. There is no doubt this is one of the most awful situations any one of them have ever been involved in. But it's also very clear they have a narrative that Jennifer Crumbley is responsible. And when they came in here and took that witness stand, they were going to mess with me on questions that were so stupid. Like this ATF agent telling me he doesn't know if teenagers could lie. Everyone in the room knows a teenager could lie. That was a low ball. Just answer the question. When you have an ATF agent that can't even get on the stand and answer a question that's common sense, that should speak volumes. That there's a narrative they've been directed to get out and they have an agenda. And that agenda, ladies and gentlemen, is not positive for Jennifer Crumbley. Making this big deal about money and cash that Mrs. Crumbley took out is another reasonable doubt in this case. Mrs. Crumbley explained her dad had accounts frozen. She didn't want her accounts to be frozen. Her dad put money in that day so she could take it out. Getting money out of the account that had her son's name on it wasn't done in any way to steal money from her son or show she doesn't care about him. She's the one that contributes every week from her paycheck into that account. And at the end of the day, she wants cash because everyone in the world absolutely hates her. She can't walk in places and hand them a credit card. Hey, Jennifer Crumbley's on that credit card. The only option she had was cash. She can't go in and start showing identification and things to get hotel rooms, and the more cash she can use, the better. The less she has to risk that people are going to figure out who she is. And remember, the world was essentially showing its colors against her as she was receiving threatening messages in the days that followed that shooting on Facebook from other people, in her emails, in her Instagram, everywhere. They're so threatening. Her employer is making her shut down accounts. Her friends, people that have been her people for years, don't want anything to do with her and don't want to be by her because she's that dangerous at that point in time. So for her to want to have cash makes absolute perfect sense. That's not a sign she's trying to flee. And also, if you're trying to flee, you don't go around local Oakland County and areas surrounding it and carry around a syringe of horse medicine. If you're going to flee, you abort mission on the horses. At that point, you're fleeing. It's very obvious Jennifer Crumbley, her intent was not to flee. Her intent is to stay safe. Her intent is to avoid threats. Her intent is to get this horse medicine to this horse, which obviously can't happen if she flees. It's clear when she's at the art studio that she's not hidden very well. She's outside smoking. Her husband's outside smoking. We saw the evidence of the cigarette butts in the snow. There's commercial buildings around and businesses within that studio. She's walking around taking a tour of the studio with her friend who owns it. And there's cameras all over the building. Obviously, she's not trying to hide if she's going into a building where you can see security cameras right on the outside that would document everything that's happening that we ultimately got to see in this trial. It's clear she's trying to stay the night in Detroit on November 3rd and didn't know where to go. It's clear from the video she's dead asleep at 1 o'clock in the morning when they're ultimately found and woken up to guns in their face. She testified she took 4 Xanax and so did her husband. We also saw evidence there was a liquor bottle in the garbage and presumably she had a drink. After 4 days of no sleep and not really eating, one can only imagine how hard 4 Xanax and a cocktail might hit you. So they make this big deal that there's text messages after 11 o'clock saying we might have been found. Well, earlier in those text messages that were admitted by the prosecution is Exhibit 430. The first text says, Marielle, this is Jennifer's phone. And Marielle was the other attorney at the time. Marielle, this is Jennifer's phone. James and Jennifer are using Jennifer's phone now. Next message. The other phone broke. And then there's a message to the Crumbleys, when you can, we'd like for you to call us. That's at 6:19. Then at 6:21, thank you, Shannon's calling you both shortly. Then at 7:02, I text, Marielle and I are going to come get you in the morning. We do not think it will help to make a statement that you're coming in or that it will be tomorrow morning. All we can say, as we've told everyone, is that you're coming back, and as of tomorrow, you'll be back. My next message says, we can show them that everything we've said was going to happen did happen. Because the Crumbleys weren't running. They just wanted to turn themselves into a court. And law enforcement got on the stand and told you that's something people commonly do. It just didn't happen in this case. At 7:03, the Crumbleys write back, and we don't know if it's Jennifer or James because they're sharing his phone. Okay. Text to the lawyers that say Marielle Shannon lawyers. Who knows why they sent that? I text, I am going to drive home from my office right now. I'll give you a call in about 45 minutes so I can get all of the bond factor information written down for you for Marielle and me. I'm asking for bond information so we can go to the court in the
Your
morning.
Honor, I'm going to object. There's a prior ruling. She cannot be a witness. That was already dealt with.
Sorry, I thought I was arguing off the evidence they admitted.
Well, you can argue off the evidence.
Okay. So they say at 7:37, okay, we'll be waiting. I'm gonna call in 1 minute, okay? Then at 11:14 on the phone that both of them have been using, a text is sent to the lawyers. Think we might have been found, don't know, just a heads up, please check. It's not for a couple hours that they're actually found, but Mrs. Crumbley testified she didn't send that text and she was already asleep. Now, after those text messages, there's 2 more pages that are included in that exhibit. So if you do end up taking a closer look at 4:30, which is totally fine, just be aware that there's another thread that starts that's a repeat, and I don't know why that is. I just want to let you know that, and I'm not sure why that exhibit is like that. That was a new one we got, obviously, all today. In the days after Mrs. Crumbley and Mr. Crumbley are planning to turn themselves in, we know they're planning to turn themselves in because Exhibit A was admitted, which showed they were trying to find a hotel in Auburn Hills on Priceline for December 4th and 5th, in case they needed it for the weekend. There's no doubts, and I don't need to go on and on about this, they were getting threats. That was so clear at trial. They were afraid to go turn themselves into a police station where if they went, there would likely be other inmates or bad people there, and their faces would be up on a TV because it was all over the state at that point. They were terrified. They wanted to go in through a lawyer. Reasonable doubt can be inferred from the fact that they set an alarm clock, which was admitted by the prosecution, showing that on Saturday they were getting up at 6:30 or 6:45, completely consistent with their plan to go to Novi for an 8:30 hearing. This is also not James's trial. I am not standing here suggesting that James is guilty of involuntary manslaughter in any way, but it is important to point out that James was the parent responsible for all of the storage of the guns. Jennifer Crumbley barely knew a thing about them. She didn't object to them being in the house. She didn't object to buying the gun that James and Ethan were interested in. She didn't object to calling it Ethan's Christmas gift. She was not responsible at all for the storage of the weapon. It is misleading to suggest by the prosecution that that Sig Sauer case was open on the bed and that it sat open like that all day with the ammunition box next to it. It's very clear that when James and Jennifer Crumbley were on the phone during that 7-minute phone call, Mr. Crumbley was looking for the gun, found the gun was missing, asked Jennifer Crumbley, where's the ammunition, pulled it out, and set it on the bed. It's not like that gun box, that case, was just sitting out there open at all times. When law enforcement did get there, find it on the bed, even they moved it around to the kitchen counter and other places. While this is not James's case, it is fair that Jennifer Crumbley would expect that he would have more flexibility in going to handle an issue at the school. That is not unreasonable and does not make her a bad mom. He's out in the Oxford, Lake Orion, Rochester area door dashing. She's the one with the professional career supporting the family and paying all their bills and trying to keep her job, which they may need to add the family on for insurance in this open enrollment period. She shouldn't be diminished as a mother because she was going to let father go to the school and handle whatever issue there was. Now, ultimately, they went together, but he's a DoorDash driver. She's trying to pay the bills. She's the breadwinner. At that time, he's in between jobs. She shouldn't be dinged for that. It's misleading for the prosecution to suggest there's been evidence in this case. She keeps guns in the car. She didn't say she keeps guns in the car. When she was interviewed, and if you really want to watch the interview, you can. Jennifer told law enforcement there was one time that gun was in the back of her car. That one time was when James put it in the back of the car, and she drove the car to the range. Her son and her had a experience at the range, and she drove the car back home, left the car locked with the gun in it, so that when her husband got home, he could put it away. It is not true that she was driving around keeping guns in the car. That is not what she said to police. As far as Mrs. Crumbley knew, there was a cable lock on the gun at all times. She called it a string lock. She testified that the key was kept in a separate place in one of the many beer steins they had. She testified that she did know where the ammunition was. She hid it in her drawer of jeans. And she testified that things were locked and hidden separately, and that Mr. Crumbley was responsible for hiding the weapon. If you are upset with how the weapon was hidden, that's not your issue to decide. That's a future jury that will look at the case of James Crumbley. You're here to look at the case of Jennifer Crumbley and consider what she knew. She is not the person responsible for storing this weapon. I'm not trying to suggest she didn't know it was in the house, but she is not the person putting the cable lock on and off or doing anything with the gun. We saw her gun abilities when she went to the range and had to have her son show her everything about it. It's a gross overstatement to keep saying that the gun was his gift. It's very clear it was something bought for him to use at the shooting range, something that may one day ultimately be truly just his. But it's just like any of us giving our kids a laptop to use, a cell phone to use, a car to use, a jet ski. I have a friend that has kids, they have snowmobiles. Nothing different. It doesn't really mean the kids just have free access to all of that stuff. It comes with conditions, rules, and parameters. Unfortunately, this is a case where the prosecution made a charging decision way too fast. It was motivated by obvious reasons for political gain and media attention. And we know that because on 11/1, when the shooter was arraigned, the shooter was on Zoom, and so were the parents, and the media was aware. And when Mr. and Mrs. Crumbley were charged, and there was a swear to at the court, the media was all there, but guess who wasn't? Mr. or Mrs. Crumbley. Mrs. Crumbley testified she didn't even know there was going to be an arraignment, but the media knew. And then the prosecution came out with a big press conference, announcing it. I would submit that the plan was never to let the Crumbleys turn themselves in, but to turn them into a big charade of looking like they're trying to flee when they absolutely weren't. The prosecution and law enforcement have approached this case with tunnel vision from day one. Brian Maloche called it a witch hunt. I would submit to you it was. And once they charged these parents and the ATF, Sheriff's Department, Border Patrol, Secret Service, all U.S. Marshals, not Secret Service, when all these agencies have gathered around and hundreds of people are looking for the Crumbleys, it's really hard to say, we made a charging decision a little too fast. And in this case, you heard evidence that much of the evidence in the case didn't roll in until after the parents were charged, arrested, and in jail. To try to suggest having multiple phones as a sign of fleeing is just garbage. I think everyone here clearly understands why they bought burner phones and why they went and bought replacement phones with their phone numbers so they could use two-factor authentication to get into their accounts. Jennifer Crumbley is seen in the police interview at the substation handing her phone to law enforcement when they're asking questions. When the police tell her they want to take her phone for a search warrant,
She doesn't want to hand it over right away, but it's not because she's trying to hide things. It's because it's her only line of communication. She doesn't really understand how a search warrant works until her husband explains it. All of her contacts are in the phone. She doesn't carry around a little diary of all the numbers, although police do let her get the numbers out. And it's the only way people can get a hold of her. And she's been in touch with them nonstop, as we can see when she's in the police vehicles. And again, although she's on her phone and there is a substantial amount of time where she's looking things up, communicating with people, trying to get things done, that doesn't mean she believed her son was a school shooter and had no emotions over what was happening. The prosecution has painted her out to be a person who lacks remorse, and I would submit to you that she would change everything if she could. And when she looks back and says there's not a thing that she feels she could have changed that would have changed something, you have to keep in mind that the suggestions by the prosecution are just ridiculous. Giving him a hug that day in the counseling office was going to stop a mass shooting. That's just ridiculous. There is nothing to prove that anything could have stopped a mass shooting when you're dealing with someone who is so manipulative and is a criminal and was a shooter in cold blood and pled guilty and took responsibility as an adult for his crimes. Finally, my last reasonable doubt card is blank, because I've tried my hardest to come up with all the reasonable doubts the defense sees in this case. And like I said, each of you need only one to vote Mrs. Crumbley not guilty. But a lot of times jurors think of a reasonable doubt I miss because there's so much evidence. And we've already established, and I've admitted I'm not a perfect person and not a perfect lawyer. So I put a blank card before you so that if you have a doubt I've missed, you know you're not limited to what I've suggested or the defense has suggested. You're welcome to come up with your own doubts on your own. And if you decide you want to dive in and read the truth between Mr. and Mrs. Crumbley and everything they talk about, you're totally more than welcome to. Those exhibits are all going back with you. And what I'll tell you is that you're going to find a lot of instances where Mrs. Crumbley is anxious, asking where her son is, where her husband is. You're going to see a lot of horse talk. You're going to see arguments between a married couple. When I read them, they read just like my husband and myself, yelling and swearing at each other at times. And then the next message says, hey, what do you want for dinner? And then we just move on, and that's just how life is. You'll see messages in here that will certainly make you blush when you read what Mr. and Mrs. Crumbley intend to do in bed that night. You will read a variety of messages that show real life and real life between two married people that have a child. And it should make no difference that they may use their horse's name more often than their son's. And I'd also submit that every time you see them talk about when is he going to be home and what are we going to eat for dinner, even if they don't use the words spelled E-T-H-A-N, that's who they're talking about, because there are only 3 of them in that house. At this point in the trial, I am asking that you find Jennifer Crumbley not guilty, not just for Jennifer Crumbley, but for every mother who's out there doing the best they can, who could easily be in her shoes, for every parent doing the best they can, who could easily be in their shoes, for every parent that has snippets of text messages that could be read and make them look like horrible monsters, for every parent that has fights with their kid on text message that also would make them look like terrible parents. For every parent that's ever had a hobby and has not spent 24/7 with their child. That should not be held against parents. For any parent that's ever had an affair or spent time communicating on an affair, that says nothing about how much you care about your child or your expectation of whether or not they would commit a school shooting. People who have
will not expect their child would do this.
Oh my
I
goodness.
do wish more than anything, this case could bring justice to the victims of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything, it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy and the tragedy that unfolded on November 30th. At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. They cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else.
Thank God.
And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue.
Sorry, I needed to refresh that. I'm going to rewind her. I'm just kidding. I figured y'all needed a break. No, but I didn't think it would do this though. Shit. Hang on. Hang on, just one moment, please. No. That way you're doing giving a closing. Yeah, she didn't stop. I just cut her off. I didn't mean to. Hang on. We're refreshing. My computer is burnt alive from all that horrible closing that she just did. You want me to play it all over again, Jason? He missed a few points. He would like for me to go back and let her go through the flashcards one last time. Oh, come on, y'all. Get back on. Hang on. I just cannot with this right now.
Is guilty of involuntary manslaughter.
I do have to rewind. Sorry.
Of the shooting, the victims of the terrorism that took place that day, and the victims of their families. I wish more than anything, it really could be a result that would be a Band-Aid to make everyone feel better, but it can't be. First of all, it brings back nothing for the people who have lost. It certainly doesn't bring back any lives. And if anything, this is not justice. This is not how justice works. This case does nothing for the people who have already lost everything. Many of the people sitting in this courtroom. And it does nothing to bring back the tragedy and the tragedy that unfolded on November 30th. At this point in time, the prosecution cannot prove that Mrs. Crumbley avoided exercising ordinary care that would have saved lives. The prosecution cannot prove that Mrs. Crumbley was aware there was a danger that existed by her son that required her to exercise reasonable care. they cannot prove that she was grossly negligent and that there was any way she could foresee that this would happen, as awful as it is, and we all stipulate it is. At this point in trial, I always have to sit down. This is how the court rules work. Prosecution gives a closing, I give a closing, they have an opportunity for rebuttal, and then I don't get to say anything else. And I'm sure you can see from my demeanor in trial, when the prosecution says something that I know I have an argument against, I get anxious, you can see a reaction, and I'm not going to do that. But I am going to tell you that as they argue, I will have many things that I wish I could get up and say, that's not true, and argue against. So what I would ask is that when you go back in the jury room and begin to deliberate, you think about and ask yourselves, what would Shannon Smith have said in response to the rebuttal where they get the last word? I would just ask that you consider that in your deliberations, because I guarantee you I'll have a very hard time sitting here knowing that the prosecution gets the last word when I know the defense would disagree with it. And I am asking each of you to vote that Mrs. Crumbley is not guilty, because she is not guilty, and because a not guilty verdict is the only fair and just result in this case. Thank you.
Not how she would respond. It's more like how should she have responded?
You get the last word. I get the last word. The people do. Because it's our burden. And that's why we get the last word. And it's a burden I embrace. It's the burden to prove beyond a reasonable doubt that Jennifer Crumbley is guilty of involuntary manslaughter. It's not a burden that I have to prove every single fact about the case beyond a reasonable doubt. That's not the law. That's what she told us. It's not the law. The law is I have to prove every element beyond a reasonable doubt. Beyond a reasonable doubt. Not any doubt. Beyond a reasonable doubt. The defense gets to decide how they present their case. They get to decide that. She gets to stand up and say what she said. But your job is to listen to the facts of the case. Your job is to listen to what the judge tells you the law is. Your job is to tell you to look at the evidence, the people sitting here, not what somebody else wants to have said that they said, but what they actually said. Your job is to consider not what lawyers say about their own life and their own circumstances and their opinion. Your job is to consider the facts and the evidence in this case. I have to address a couple things, and I'm going to be quick. There was absolutely no evidence at all presented to you that anybody at that meeting told Jennifer Crumbley it was no big deal. There was no evidence of that. There was no evidence at all that Jennifer Crumbley was very surprised by how long the meeting lasted. Jennifer Crumbley didn't say that. That's not into evidence. I don't have to prove, the people do not have to prove that Jennifer Crumbley knew that there was going to be a homicide or a school shooting. As Lieutenant Willis pointed out correctly, if she knew exactly what was going to happen, she'd be charged with murder, ladies and gentlemen. She is not. She is charged with involuntary manslaughter. And the elements, you'll get them. I read them to you. The standard and what I have to prove is not that she knew that her son would go shoot up school and kill 4 kids. I have to prove that she had a legal duty. She negligently performed that legal duty. She negligently did not take steps to take care and protect the other children in that school when there was
a reasonable foreseeability that ordinary care was required. The smallest of things. The smallest of things. I apologize to the law enforcement in this room and any listening that I have to stand here and to defend their integrity. But I do. Because if you believe that Special Agent Brandon and Lieutenant Willis and the other law enforcement that took the stand
Your
here,
Honor, objection.
including,
I'm objecting because I'm allowed to argue based on what's in evidence, and Miss McDonald is trying to make me sound like I've done something wrong. And I didn't. My argument was proper.
she's arguing. It's my rebuttal.
Yeah, and overruled, you commented on the statements of the police officers, you argued about the statements of the police officers, she gets to argue about the statements.
The exact quote was, they probably did that to all the witnesses in the case. If you believe that, then you believe that the sheriff's office, Lieutenant Willis, Special Agent Brandon, the ATF, the federal marshals, the Detroit Police Department, anyone who the evidence tech, they were all in some sort of conspiracy. That's what you'd have to believe, and I know that that's not what you're going to find. Look at the evidence, apply the law, and decide what the truth is. That's all I've ever asked you to do. That's all the judge is going to ask you to do. Nothing here was designed. Nothing here was made up. And I don't have to convince you of that, because I know that you're going to use your hearts and your minds and your sense of reason, and you're going to look at the evidence. The first statement Jennifer Crumbley makes about this gun, her son's gun, was at the substation after the shooting, and this is what she said. It was hidden. It was hidden. That's what she said. It was hidden, ammunition separately. It was hidden in a dresser. It was hidden. That's all she said about it. The school's actions or inactions do not excuse the culpable behavior by defendant. Ladies and gentlemen, he literally drew a picture of what he was going to do. He drew a picture. It says, "Help me." It has the drawing of the gun that she bought him, posted, and bragged about. Blood everywhere. The thoughts won't stop. The world is dead. He drew her a picture. Pretty egregious and unique circumstances. And in fact, it is absolutely not true that we have to worry that we'll all be sitting here. We agree on one thing. Her testimony is evidence. Jennifer Crumbley's testimony is evidence, and you should consider it. And when you consider it, I'm confident that you will agree it is not consistent at all. It wasn't even consistent from her direct examination to her cross-examination. She acknowledged sitting here when Mr. Keys asked her about, "Where's this phone? You said you took the phone." You heard what she said. We took his gun away. We took his gun away. I don't have to prove flight beyond a reasonable doubt. I already told you that. You can infer consciousness of mind. And what does that mean? You run, you delete text messages, and you lie because you know she knew she did something wrong. The question about why Jennifer Crumbley didn't take one of these small actions, secure the gun, find out where the gun is, it looms large in this courtroom. There is no one it looms larger for than the victims and the family members of those kids who were killed on that day. We don't have to prove why. But remember what she said. I wouldn't change a thing. Just hours ago, she said, I wouldn't change a thing. This prosecution is about nothing else except the facts of this case and what Jennifer Crumbley did and what she didn't do. If only I could look at the faces of these parents who are dealing with unspeakable darkness and grief. If only I could make that better. I could appease them, as defense counsel suggests, by charging Jennifer Crumbley. These are the parents of Hannah St. Juliana. These are the parents of Madison Baldwin. These are the parents of Tate Meir. These are the parents of Justin Schilling. And not just their parents, they are mothers and they are fathers and they are sisters and their brothers. And do not think for 1 second that this prosecution takes any of that pain away, because it doesn't. This isn't an effort to appease anybody. Your verdict means one thing. It means Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter beyond a reasonable doubt. And I am not going to stand here and tell you that that's going to take away this pain that these families feel, because it will not. I won't stand here and say that the pain will be gone for Molly Darnell or Christy Gibson Marshall or Special Agent Brandon, who ran out of that office so quickly that his chair was spinning, or Ed Robrowski, who viewed the surveillance video to identify the path of the shooter and it was burned in his brain forever, or for Lieutenant Tim Willis, who answered the call to lead and maybe the biggest ask of his entire career, but one he did not back away from. Don't render this verdict for the hundreds of kids in that school. It will not appease them. Nothing will. But you are now called upon. You are called upon. You are called upon to do your part as jurors, to keep the oath that you took, to be fair, to be honest, to be impartial. You are the ultimate fact finder. But what happened that day? You are the ultimate fact finder of the truth. We have met our burden. We have proven beyond a reasonable doubt that Jennifer Crumbley is guilty of 4 counts of involuntary manslaughter for failing to exercise ordinary care when the smallest, tragically simple thing could have prevented it. It could have saved Hannah. It could have saved Madison. It could have saved Tate. And it could have saved Justin. And she sat here and she said she wouldn't do one thing different. And lastly, I'm gonna address the question I know that's on the minds of a lot of people in this courtroom and a lot of people listening. I'm gonna say what I know they're all asking and they want to say. When she took the stand and she testified about her own loss, and she was asked the question, "You lost everything?" She said yes. She hasn't lost everything, ladies and gentlemen. Her son is still alive. Find her guilty of 4 counts of involuntary manslaughter. Thank you.
Thank you. I have to have you come back Monday.
Oh,
You
she's
know
sending
that,
them home.
right? You knew that before I said it. You guys have been so terrific. You've been on time. I have not heard, I still have 5 alternates, right? Because no one, as far as I know, has violated any rule, has read a newspaper, has posted anything on Facebook, has talked to anyone who talked to someone else who repeated it to the court. We appreciate that. You know how hard it is. I'm going to ask you to come back Monday. But I want to instruct you that during the trial, do not read.
All right. Guys, I got to go take my sister's dog outside, and I'm probably going to have to clean up a ton of pee because the poor little thing has not been out. She's going to be, her eyeballs are going to be floating. Thank you for watching with me today. I really appreciate you all. And I enjoyed being here with you today. And if this was not such a sad circumstance, this trial, it would definitely be an epic one, wouldn't it? Let's see what happens. I'm not going to come back live on Monday. If they get a verdict, if we hear they've got a verdict and I have time and everything, I'll come on a live with that. But otherwise, I'll just keep cranking out updates on that. And I got to get back over and start getting some more Judge Tammy out. And I've also got to finish up on Kimberly Kessler. So y'all stay good. Love you too, Kimmy. Y'all have a blessed weekend, and I will talk to you very soon. Bye, everyone.